matter appears under the urgent motions. Today it is appearing as new motions instead, Your Lordship, as item 39. I was beseeching that today is the disconnection deadline. Any convenient time Your Lordship may take up the
Item
matter.
number?
Item number 39. Your Lordship had specifically directed for it to appear under urgent motions, but it is not appearing.
Appearing for the respondent license company, my lord. I have taken instruction matter, my lord. This disconnection, my lord, has been, that notice has been issued on 27th of October 2025, my lord. We are today on 12th of November, my lord.
Let the matter be taken up and then my learned friend may make his submission.
The matter has been filed at the last moment at the time of disconnection, my lord. And the grounds, my lord, which has been cleared in the writ application, my lord, lot of documents are not annexed. So, my lord, as my lord desires, my lord, any day subject to my lord's kind convenience.
Whether you're going to disconnect today?
Disconnection notice is there, my lord.
No, whether you're going
Tomorrow,
to...
my lord. Tomorrow is
Tomorrow.
disconnect.
So come at 2.
My lord, 12:30 if it's possible, my lord.
12:30.
12:30, my lord. Subject to my lord's kind consideration, my lord.
Okay, come at 12:30.
12:30. Very well. I'm deeply obliged.
Lordship,
Item
39. 39.
39.
39. 12:30.
12:30. I'm deeply obliged.
Lordship, I had mentioned Lordship, I had mentioned the restoration application on 3rd November. Your Lordship desired that I wait a few days for the records to come.
Yes, you give.
So it has not come.
My lord,
It may be.
may I leave to mention one urgent application, my lord?
Please listed tomorrow under the heading application.
My lord, under compelling circumstances, my lord, I am mentioning, my lord, 2 matters which were the earlier.
What is the urgency? Because
But
today is not the mentioning date.
My lord, urgency is that, my lord, in earlier Korean bench, my lord, fixed the matter on 10th. Because of urgency is there, my lord, over, my lord, one
Why you not mentioned
katha of,
yesterday?
my lord, one katha of land, my lord,
Why you
that
not
is,
mentioned
my
yesterday?
lord, that is my mistake, my lord,
So
kindly, my
come
lord,
on
any
Thursday,
date, my lord, as your
Come
lordship,
on Thursday.
Thursday.
My lord,
Yes. Call the list.
May I have your lordship's leave?
Huh?
To read petitions.
Thursday, come mentioning Thursday.
My lord. Obliged.
my lord, only one urgent, my lord, application. Trying to leave to move this application, my lord.
One
One application.
a short point involving this matter, my lord.
I'm taking the preliminary point regarding the maintainability.
But earlier, so the honorable court was directed to file a report.
Ah.
But a report not yet filed.
Ah.
But my lord, that student are suffering, my lord, for disconnection of the school. My lord, kindly only my lord point is my lord page.
You are appearing for the WBD-SCDL. Whether you submitted the report. July, there is a direction for file report, sir.
But after July, my lord, matter is appearing before your lordship today, my lord.
Okay.
Report is with me, my lord.
Report is there?
Yes.
Yes. Give the report.
But only thing before going through the report, if your lordship see, my lord, he is virtually disputing
My petition, my lord,
No, he is raising the maintainability question. I mean, yes, what is the maintainability point?
but he is raising the dispute as regards the, my lord, the bill of the electric consumption.
What?
He is raising the dispute of electricity bill according to us that he has consumed. According to him, he has not consumed. Now, my lord, there is a provision. If he is, my lord, raising a dispute, then in terms of regulation 3.5, more particularly 3.5.1, he has to approach before the, my lord, the primary authority, that is the, my lord, RGRO.
Correct.
And if he is at all agreed by the order of the RGRO, he has to approach before the learned ombudsman. Now, my lord, against the order of the RGRO, he has rightly went before the RGRO. RGRO, my lord, there is a, your lordship knows there is a draft settlement order, but there is a direction that he will pay by installment. He has not paid. If he is at all agreed by the order of the RGRO, my point will be, submission will be, he has to approach before the learned ombudsman. If ombudsman does not decide the same, the remedy lies before your lordship's court. Therefore, I am taking this preliminary point. Now, my lord, earlier bench my directed me to file a report. What is the order of the RGRO? But I have given to your lordship, my lord.
no, RGRO report order, my lord, already annexed in the petition.
Ma'am, I am taking the preliminary point. Therefore, I know what I have to say. And my submission will be Once he approaches the RGRO, he has to follow the second procedure, that is before the learned ombudsman. Straightway cannot come to before this honorable court, my lord. And this is another, my lord, copy of the, I have forgotten to hand over. নাম দিতে হবে না?
Yes.
Only point, short point involves page 15. Page 15. In electricity act, if I consume a small unit.
Page 15.
Page 15.
15.
15.
Yes.
Right hand side, the invoice number, then the previous reading.
Invoice number?
Invoice, then invoice, then column, previous reading date.
Yes.
14223.
Yes.
And current reading date 11224.
Correct.
After 8 months, the reading was taken. If I consume, their procedure is 3 months. If the reading was taken by 3 months, then the lesser, the small unit. If I consume small unit, I pay the unit charge is small. If I consume higher unit, then I pay higher unit. My only request is that when page 17, the split the bill I will pay. After 8 months, you page 17, kindly see. I made a representation, kindly split the bill and I will undertake to pay.
How at this stage the bill can be split?
We as per if why the consumer pay the higher charge? As per his obligation.
See, after 1st April 2023 till 1st January 2024, have you paid the bill?
But that bill, after
You not paid the bill.
As such,
And when the bill was raised?
Raised after January 2024.
When the bill was raised?
21st January 2024.
21st January 2024.
Then disconnected.
When it was disconnected?
After 31st January to
31st January. So where is the bill? Your 1st January. Where is the bill?
Bill, there's a page 15. This is the bill 1,66,296.
1,69,000.
69,226. But due date, right hand side 1,67,000 before due date. Total 1,69,220.
220.
220.
220. Correct.
This is 8 months bill.
Correct.
But you split the bill, I will pay. Because
if the bill will be splitted, the amount will be reduced. How?
But because 3 months, if I consume a small unit, then I will pay the unit charge is small. Then I will, if I consume high huge unit, then I will pay the huge amount. Regarding the charge of the
why you not ask the bill for the why you are sitting tight over the matter till February?
But I made a representation.
When you made the representation after the bill was raised?
After bill was raised.
Then before that, since you are consuming the electricity since April 2023?
Yes.
Correct. You are satisfied with the electricity provided to you. When the bill was raised, then you are telling that the bill is why you have not asked the bill from May, June, July, August, September? If within 3 months it has not been
Their obligation to.
their obligation, if they have not given, and you are telling that if it is given a composite bill, it will be higher. So it is your duty to ask the bill within the 3 months or within 4 months. Why you not ask for?
My
So how at this stage the electricity bill say?
that he,
Then the installment may be given. Installment.
How much installment you pay?
Plus
Say,
6 installment.
6 installment, 1 lakh is what is your business?
No, malad is school. Malad the
business.
the school. Malad.
What is school? Primary school or middle school? English medium is school.
In a remote area, malad is medium.
English medium school is good.
Now, malad, out
Out.
now, malad, till today outstanding is 3,74,343. Now, malad, what happened, malad? My landed friend is showing to your lordship page 15.
Yes.
But if your lordship see once, but he is showing to your lordship page.
Subsequently,
Kindly see
when
page.
the bill was your electric connection disconnected.
No, they after when did not pay this bill, then malad.
Okay, you do one thing. Whatever the bill as on the date of disconnection, you pay within 4 installment.
Yes.
Well, like, in the interim measure, you can reconnect that. If within 4 installment, if you will not pay and continuing with the current bill, then you take up.
Yes,
Kindly-
after my payment of first installment, reconnection will be.
Yes, on the very well, when you pay the first installment, so
Within 15 days. Malad.
15 days.
Oh.
My, it is a,
Running the school.
if your lordship see,
You're telling you're
No,
asking for
within
the
7
urgent.
Malad, within 7 days.
my, if your lordship see the, well, the picture of the school, total outstanding is on 11
No, no,
June.
date of disconnection.
No, my, not that. 1 lakh
Why?
more.
After the disconnection, how you can raise the bill?
No, after not disconnection, my, he is enjoying, my, kindly see, my, I cannot go.
When the electric connection was disconnected,
10th February 2025.
10th February 2025. So till January 2024, this is the bill up till 1st January
But
2024.
thereafter, my lord, he approached before the landed ombudsman.
Hmm.
Before the landed ombudsman, my lord, everything has been shown because that time line was not disconnected. What he said,
That's why I am telling you the date when the line was
10th
disconnected.
February. Kindly see the second page. I have handed over to your lordship. The single page, my lord. Kindly see point number 11.
As there was no bill dispute.
10 and 11.
10th of February 2025. It's 1 year.
He is what he is telling is not.
1 year. Can you see your disconnection was done on 10th of February, sir?
My lord, if your lordship see the regulation, my lord, it's
Your disconnection was done on 10th February.
But as per date of disconnection, if any malad the outstanding malad that for
No.
10th of February
If
2020.
malad is disconnected 10th February, 10th February is the
You do one thing. I am fixing day after tomorrow. You bring the total
but
bill.
day after tomorrow, my lord, I will not be here. Can it be on next week, my lord?
Monday, you bring the total bill. What is the outstanding till
date of
when-
disconnection.
But till date of disconnection is, my lord, kindly see.
That if
it is there, but the total bill, so that I will give the total exact amount in the order. So in future, you cannot dispute all these things.
My lord, subject to correction, my lord, if your lordship see, my date of disconnection is 10 February 2025.
Correct.
Till that date, the outstanding is 3,74,343.
This is correct.
Yes.
no, he produced malad the bill and the
This
next
is there.
But this is the original,
what?
my lord. This is the
Report is
instruction.
there.
Report is there.
Report is there.
malad bill may be produced before.
Bill, what is the bill? It is there. The report is there. Record or not? The petitioner has filed the present writ application, praying for direction upon the respondent number 5 to revise the bill dated 21st of January 2024 and split the billing amount in accordance with the standard 3 months billing cycle, and further allow the petitioner to pay the revised bill in 4 installments without any additional charges. So the counsel for the petitioner submitted. The reading was taken on the bill was raised on 1st of April 2023, and thereafter the second bill was raised on 1st of January 2024. though as per law, the authority have to raise the bill within 3 months. As the authorities have raised the bill after the period of 8 months, and as such, the total due amount of the electric consumption charges has increased up to rupees 1,69,220. And if the bill is to be splitted by 3 months, the amount would have been less. Full stop. Counsel for the petition submitted. As there is the bill raised by the authorities, counsel for the petition submitted, the petition has raised the dispute with regard to the bill raised by the authority, due to which the petitioner could not pay the electrical consumption charges as in terms of the bill raised by the respondent authority dated 1st April 2023, 1st January 2024. Thus, and due to which on 10th of February 2025, the electric connection has been disconnected. So the counsel for the petition submitted, the petition is running the school, and due to disconnection of the electric connection in the school, the petition is facing difficulty run the school. Learned counsel for the respondent has submitted the report. And submit that after the raising of the bill, the petitioner has approached the RGRO against the said bill, but the RGRO has dismissed the claim made by the petitioner. And thus the petitioner had to approach the ombudsman challenging the order passed by the RGRO, but instead of the same, the petitioner has filed the present writ application. Thus the writ application is not maintainable. He further submits that as the petitioner has not paid the electrical consumption charges till the 10th of February 2025, and as such, the electric connection has been disconnected. He further submits that if the petitioner will pay the total electric consumption charges, the respondents will reconnect and will provide the electric connection in the premises subject to payment of the reconnection charges. At the learned counsel for the respective parties peruse the materials on record. This court finds that initially the respondents raised the bill up till 1st of January 2024 for a total amount of rupees 1,69,220. But the petitioner has not paid the said amount and has challenged the said bill before the RGRO. The RGRO has found that the bill raised by the authority is correct and has not interfered with the bill. So, this court finds that as the petitioner has not paid the bill raised by the respondents, accordingly, the line was disconnected on 10th of February 2025. From the report, it reveals that as on 10th of February 2025, there was a total outstanding due of rupees 3,74,343. The petition submitted. The petition will pay the said amount within 4 installments.
6 installment.
Kindly see once my
3,000 and as well as current bill.
my note. But kindly see column number 9. Initially, he filed an application that permit him to pay 6 installments. He did not pay single installment.
In your petition, you have raised the 4 installment. Pay the amount by 5 installment. Accordingly, the petitioner is directed to pay the total outstanding due of rupees 3,74,343 within in 4 equal installment. The petitioner shall pay the first installment along with the reconnection charges to the concerned authority by when you will pay.
Within 7 days, first installment and reconnection.
That's why. By today we are on 12. So 20th. By 20 November 2025. If the petitioner paid the first installment along with the reconnection charges to the authority, the authority shall immediately reconnect the provide the electric connection to the petitioner in the premises of the petitioner. And full stop. It is made clear that subsequently the petitioner shall pay the further three equal installment month by month, that is on 20th December, 20th January and 20th February 2026, along with the current bill, if any, raised by the authority.
Along with the current consumption.
Current bill raised by the current consumption bill raised by the authority. WPA number solution disposed of.
Grateful.
But the report submitted by the respondents be kept in the report. Yes.
My lord, I am appearing on behalf of the respondent bank, my lord. At the very outset, my lord, I would beseech my lord, to take up this matter on next Monday, subject to my lord's sanction, my lord.
Why?
Because, my lord, the instructions that I have received, my lord, let me be very candid, my lord. I am not very satisfied, my lord. I want to be very satisfied. I have taken up this matter with the higher authorities of the bank also, talking with the higher authorities of the bank also, my lord. So, my lord, only for 2 days accommodation.
I'll come back, my lord. As per the prayer made by the counsel for the respondent, case is adjourned. Let the matter appear on.
Your Lordship, I am for the state.
Let the matter appear on 18th. Tuesday, I am fixing on Tuesday.
I'm grateful, my lord.
18th, under the heading urgent motion. 18th, under the heading urgent motion. Yes.
Grateful, my lord.
All 3, I am appearing for the petition.
3, I appear for the state respondent.
Malad already served.
Where is the affidavit?
Malad deputy service, Malad, that is on Malad received not, Malad dispatch. Dispatch.
Not received. You are appearing for?
Madam, I appear for the state respondents in this matter.
And you are also appearing now? No.
Malad allegation against the respondent number 14 to 18 to made construction by filling up a pond which is used as a pisciculture for more than 200 years, and Malad already in earlier occasion, as per written complaint made by the petitioner, PLRO.
What number?
Respondent number 14 to 18.
You are appearing for all?
14 only.
14 only.
If your lordship kindly see for a moment, page 21.
Let us copy be served.
Sarthak থেকে তো পেয়ে যাবে।
Served copy.
From Sarthak it was available.
Have you taken the instruction?
Yes, I have taken the preliminary instructions. The preliminary instructions suggest that, my lord, our inquiry was held. And in the inquiry, my lord, may I hand over a copy of that, just a 2 lines inquiry report. My lord, kindly excuse me, my lord, it's a my lord, PDF copy, which is the second part, second page, is not that, but kindly takes up the second last paragraph. As per the inquiry report, there is no illegal filling of the pond is found, but an earth road on the bank side of the said pukur, where a small quantity of earth is filled up. This is absolutely a preliminary inquiry, although
okay, you do one thing. You serve the copy to the what he is appearing for the only one. What about the other?
Malad other dispatch, Malad
Filed with further affidavit of service on the next date. But in that application, in that notice, you mentioned the date of today only.
Already I mentioned. Malad another order maybe Malad passed that fixed another date. I served another notice.
I am fixing on next Wednesday.
Wednesday.
You saw the copy?
Yes,
and
in the
you also inform the next day to the other private respondents. In the meantime, you take the report.
Absolutely.
Yes.
So very grateful.
The petitioner has filed the affidavit of service, but it is found that only the late petition has been sent to the private respondent, but it has no acknowledgement. Accordingly, the petitioner submitted. He will file a supplementary affidavit of service on the next date. The counsel for the private respondent number 13 is appearing, and he submitted that he has instruction to appear in the matter. The petitioner will supply the copy of the writ application. He will accept this. Accordingly, petitioner is directed to serve the copy of the writ application to the learned advocate who is appearing for the respondent number 13. By tomorrow?
By tomorrow.
By tomorrow. Good. The Learned Counsel appearing for the state has filed the report, but this court find that a detailed report is required to be filed. Accordingly, the state respondent is directed to file a detailed report. List the matter on 18th of November 2025 under the heading urgent motion.
Opposition if required.
Let me see. On that day, let me see the report.
Well,
If
urgent
required affidavit, then
urgent server copy as well as
the petitioner is directed to inform the next date of hearing by way of communication to the private respondents who are not appearing before this court today,
yes.
and to file affidavit service on the next date fixed.
So very grateful.
Great.
So very grateful.
Ram for the state, madam.
Yes. What is the application for?
This is an applicant for substitution, my lord, of the respondent number 4. But application for substitution of the respondent number 4, my lord. Let service is not complete, my lord, let there be a direction for service.
Respondent number 4.
Yes. Dilip Kumar Dotto.
আমাদেরকে কপি দাও নি বোধহয় স্টেটকে দেওয়া হয়েছে আপনি শিওর
Vidyut Kumar Nandi.
আচ্ছা
Respondent number 4. Dilip Kumar Datto.
Dilip Kumar Dotto.
He died.
He died.
So where is your application? When he died?
31st July 2023, my lord, paragraph 2, page
Yes.
5. My
And when you file the application?
lord, there's a delay of 394 days, my lord. Filed on 28th November 2024, my lord. My lord, my date of knowledge.
When you came to know?
November, my lord.
Huh?
Date of knowledge, my lord, page 6.
Page 6.
Yes,
15 November.
15 November, my lord.
15 November came to know. And when the application was affirmed, filed?
Filed, my lord, on 28th November 2024.
2024. Yes. So these are the two legal heirs.
Yes.
Both are sons.
Yes,
No wife, no daughter.
no, my lord.
Ram for the state. The private respondent is the main contesting party.
The petitioner has filed the present application being CAN 1 of 2024, praying for recording the death of the respondent number 4 and substitution the legal heirs of the respondent number 4. Counsel for the petitioner submit that the respondent number 4 died on 31st of July 2023, but the petitioner came to know about the death of the respondent number 4 only on 15th of November 2024, and immediately on 28th of November 2024, the petitioner has filed the present application. Had the learned counsel for the petitioner peruse the application, this court find that it is a specific case that the petitioner came to know about the death of the respondent number 4 only on 15th of November 2024, and immediately on 28th of November 2024, the petitioner has filed the present application. Accordingly, the petitioner is being granted liberty to delete the name of the respondent number 4 and add the legal heirs of the defendant respondent number 4 as mentioned in paragraph 3 in the present application within a period of 1 week. Period of 2 weeks. 2 weeks, and to file and to serve the amended copy of and to file the amended copy of the writ application to the legal heirs of the respondent number 4 and to file affidavit of service on the next date fixed. List the matter on 4th of December 2020.
Grateful.
My lord has been kind enough to direct them to sub the copy to the added respondent. Substituted respondent.
Let that
কবে আসবে?
that's how you pass an order, serve the copy.
এই
4th December. Under the heading
My lord, I appeal.
Sir, before my learned friend starts, yesterday, my lord, I had also said that they are settling. That those letters also I have annexed, and I have also taken instruction, my lord, that my lord, I have also again given my recent OTS, and they are saying give further documents. We are willing to settle. So I don't know, my lord, why at the same time
No, my lord,
I have annexed those documents. They are saying it's
this
under
cannot be settled. The guidelines itself says fraud matters cannot be settled. That's the bank's constraint, my lord. I don't know, my lord, what letters my learned friend is talking of. It's not pleaded, not annexed to the writ petition. Therefore, I don't know.
Then may I just show that?
Which page?
I'll show. My lord, kindly takes, my lord.
Letter that you are talking.
Yes, yes. Page 99 of my writ
That-
petition.
that.
Page 99. All the letters, my lord, which I have given from 94 to 106. One of their reply, 99. And today also I took instruction that after that it's still going on.
I shall show, my lord, the constraint of the bank, my lord.
Page, my lord.
You are writing to the, you have written to the assistant manager.
No,
This
there
is your letter.
theirs is there.
No, letter. The page 99 is your letter requesting for OTS.
Yes, I will show their letter. Yes, kindly see 95. I am sorry. Bank of India to me, 13th August 24, 95. We require CA certified latest director and guarantor net worth for further processing of compromise in the account of such and such. Please provide us urgently. And my lord, after that, there I have given my lord these documents where I have annexed everything that they have been asking from time to time. Even I have called for my clients, my lord. Today they are saying that recently also they have received a letter from them saying, give us further documents. This is under consideration. So I am saying this.
Have you taken instruction?
No, my lord, my lord, I shall show, my lord. I have noted her point, my lord. May I reply, my lord?
It's not like I have not annexed anything.
Yes, I stand corrected on that. I stand corrected.
I don't usually mislead the point.
My lord, on the last occasion, my lord, I had shown, my lord, the first ground taken was that the notice itself stated that this is fraud has already been classified, my lord. But my lord, if the letter is read in entirety, my lord, we'll see this was really an identification, and my lord friend's client was given an opportunity to explain, because my lord, the allegations which my lord friend did not place in the show cause are extremely serious, my lord. It's a case where money has been taken on the pretext of being used at one instance, but it has been, in fact, my lord, used at some other purpose, one. And secondly, my lord, the money has been siphoned out of India to Hong Kong, my lord. So they are serious, my lord. There are 27 instances of fraud which was set out in the show cause notice, none of which has been replied to. So, my lord, no answer to the allegations of fraud.
Have you served the forensic report to the petitioner?
Yes, my lord.
After the so-called notice.
Even they had it, my lord, all along. Also, my lord, letters are there. I shall show, my lord. Well, that's not perhaps really argued, but they have it because, my lord, on forensic report, my lord, proceeding before the NCLT was also conducted, my lord, and ultimately, my lord, this was done, my lord. Now, my lord, the real issue which was argued yesterday was that the bank has not followed the procedure under the master circular, particularly of issuing a early warning signals and red flag account was not. Now, my lord, kindly takes, my lord, the circular, my lord. This perhaps is misconceived. Why, my lord, I say this, my lord? Kindly takes, my lord. The circular starts at page 107, and my lord, the relevant circular cited by my learned friend yesterday was clause chapter 8, clause 8.3 at page number 125.
Yes.
It says a red flag account is one where suspicion of fraud activity is thrown up.
From your reading?
Well, I'm reading 8.3.1 at page 125.
8.3.1. Yes.
So this was placed yesterday. A red flag account is one where a suspicion of fraudulent activity is thrown up by the presence of one or more early warning signals. These signals in a loan account should immediately put the bank on alert regarding the weakness or wrongdoing which may ultimately turn out to be fraudulent. A bank cannot afford to ignore such early warning signals, but must instead use them as trigger to launch a detailed investigation. Then 8.3.2, an illustrative list of EWS is given for the guidance of the bank in annexure 2 to the circular. Bank may choose to adapt the relevant signals from the list and also include the alert signals based on their experience, client profile, business models. The EWS are so complied by your bank would form the basis for classifying the account as RFA. This was cited and it was alleged it has not been done. But what has not been shown is the next clause at page 126, 8.3.3. The threshold for early warning signals and red flag alert is an exposure of rupees 500 million or more at the level of bank, irrespective of the lending arrangement, whether solo banking, multiple banking, or consortium. All accounts beyond 500 million classified as RFA and frauds must be also reported to CRICL data platform together with the dates on which the account was classified. As such, as of now, the requirement is in addition to the extent requirement of reporting to RBI mentioned in 3.2. The modalities for monitoring a loan fraud below 500 million threshold is left to the discretion of the bank. However, the bank shall continue to report all identified CMFC and as RBI as well. Now, here the threshold, the total loan was less than 10 crores. So the requirement of red flag perhaps is not mandatory in the case at hand. So therefore not done. And in this context, kindly sees, I am showing copy this. This is from the website of the IBBI and uploaded by the liquidator. And this shows the exposure was amount. Kindly see this. The second entry is Bank of India. At a copy down.
Yes.
Yes. And the sum covered by guarantee was 86,999.0.9. So about 9 crore was the exposure.
Can I have a copy?
Yes, please. And even the offer which my learned friend gives is about 6.5 crores.
Yes.
So here the threshold. So no requirement. This is one. Second, my learned friend was very vociferous in arguing that no personal hearing was given to my learned friend's client, and therefore this vitiates the entire proceeding being against the principles of national justice. For this, my learned friend had cited a judgment of this court, which is क्या नाम था उसका? Prashant Bothra. This judgment, with respect, has been overruled by division bench. I know my learned friend will not mislead court, but perhaps he had missed it. This has been overruled by a division bench by Justice Devanshu Basak's judgment. So this perhaps cannot be relied upon. Prashant Bothra has been overruled. I know my learned friend, she will never cite a case which she knows has been overruled. So I will give you. Copy and drop kore dao. Let's kindly takes this judgment, it's a detailed judgment where the judgment of Justice Sabyasachi Bhattacharya has been overruled.
Can I have a copy?
No. The copy ache ki? नहीं उनको WhatsApp कर दो ना. No. I shall come to this. Kindly, just for reference, kindly takes paragraph number 49 of the judgment, which I shall argue for a different purpose. But the judgment is overruled. It's very evident. Kindly comes to paragraph 49. Of this judgment only. Yes, this is I shall show on a different aspect. What the division bench holds in case of frauds. It starts with section 447. Section 447 of the Act of 2013 has treated fraud involving public interest on a different footing, prescribing a much higher minimum punishment than fraud not involving public interest. Aspect of involvement of public interest has to be kept in mind while dealing with an investigation directed under Section 212 of the Act involving recovery of public money. NPA has been judicially recognized to be cost to the economy. Reference may profitably had to transcore effects to recover dues involved NPA, therefore has a public interest ingrained. This I arguing because the small infractions which may have happened in the procedure, perhaps will always weigh down when it's in comparison with public interest involved in this case. Now, the next argument was that no personal hearing was given. My friend had relied upon Rajesh Agarwal's judgment. I shall also rely on that judgment. The relevant paragraph which was placed does not anywhere, my lord, say that personal hearing has to be given. The judgment only says, may I show that judgment? Paragraph 95 of Rajesh Agarwal was placed, my lord. In fact, paragraph 98 was the conclusion, my lord. Paragraph 98 at page 47 of
8.6.
Yes, my lord. Principles of natural justice demand that borrower must be served a notice, given an opportunity to explain the conclusions of the forensic audit report, and be allowed to represent by the bank JLF before their account is classified as borrower. That's the requirement. Now, this, my lord, judgment does not anyway says personal hearing is required. The question, my lord, came into for consideration before Delhi High Court, my lord, Bombay High Court, my lord. This is a judgment, my lord, I shall cite. This is, my lord, Anil Ambani versus State Bank of India, my lord. So, appears to be, my lord, unreported, but it's a neutral citation is there, my lord. I'm also giving a copy to my learned friend, my lord. Very well. My learned friend has it, my lord. Kindly, my lord, takes paragraph 37 of the judgment. It's at internal page 39 at the bottom, my lord, if you find the page numbers.
Yes.
May please, my lord. In fact, subsequent to judgment of Rajesh Agarwal Supra, the State Bank of India preferred a miscellaneous application before the apex court, expressing apprehension that the said judgment may be construed as mandating a personal hearing in every case. The apex court, by an order of 12th May 2023 in miscellaneous application in civil, so clarified that earlier decision of 27th March 2000 only upheld the judgment of the High Court of Telangana, and that the operative directions are confined to those summarized in para 81 under section E, which is related to section to the paragraph that we read, because that's and the same is reproduced in para 8 here in paper. The next kindly comes to 39. A perusal of the master directions of 2024, as also in 2016, my lord, nowhere contemplates a personal hearing. The same provides an opportunity of being heard as per the direction of apex court in Rajesh Agarwal. The master direction 24, read with the decisions of Rajesh Agarwal, require an opportunity to submit a representation before classifying a person or entity, followed by a passing of a reasoned order. Thus, the right available is that of making a representation and not of a mandatory personal hearing as contended. Even otherwise, in the present facts, considering the petitioner had submitted his response to the impugned SCN as well as subsequent representation, and further, since there was no response to the last communication addressed by the petitioner to the respondent SBI, the respondent SBI was well within its power to pass the impugned orders. It is pertinent to note that the apex court in its judgment in Rajesh Agarwal has not held / observed that an opportunity of being heard necessarily includes and means an opportunity of personal hearing. It talks about audi alteram patum, adherence to principles of natural justice. Significantly, no request for personal hearing was made in this case also. No request for personal hearing was, I shall show what request was made. No request for personal hearing was made by the petitioner at any stage. In any event, the grant of a personal hearing is not as a matter of right in every case unless specifically mandated by statute or rules. The principles of natural justice cannot be applied in a straitjacket formula. Their application depends on the facts and circumstances of each case. In the present case, as long as the petitioner was afforded an adequate opportunity to submit his objection in writing, the requirements of fairness and compliance with the principle of natural justice stood satisfied. Now, my lord, kindly takes, my lord, what did my learned friend in reply to the show cause said with regard to personal hearing, my lord? Just, my lord, for a moment, kindly comes to page number 151 where the reply starts, my lord. And straight away come to page number 153. Last paragraph.
Yes.
Moreover, the classification of company's account as fraud was set aside by the order of 18 July 2023. In the event the bank wishes to re-examine, the notice have to be served to the company, and an opportunity of hearing must be given to the company in liquidation, not to Miller and Friends. They did not want it. So they want a notice to the company which has gone into liquidation. So kindly considers the stand taken. There is locus standi of ex-director of the company under liquidation to provide any assistance. In this regard, a liable to reply to the show cause. So this is the stand taken, that you give a notice of hearing to the company in liquidation, not to me. Yes. Now, Millet, in this, apropos this, Millet, I wanted to cite one Supreme Court judgment, Millet, on the requirement of personal hearing, Millet. Millet, may I hand up the book, Millet, or Millet, kindly. This is Millet Jadeveloper. You have it. You read. I have a soft copy. So, Millet, may I just place this? Millet was considering the willful defaulters circular. Millet. This is relevant. Why? Millet, I shall read, Millet, a portion of the judgment. Millet kindly comes to paragraph number 15 at page 798 of the report. Millet.
Yes.
Here also the court was considering whether personal hearings should be given. Millet. The next question that arises is whether an oral hearing is required under the revised circular of 1st July 2015. We have already seen that the said circular makes a departure from the earlier master circular, in that an oral hearing may only be given by the first committee at the first stage if it is so found necessary. Given the scheme of the revised circular, it is difficult to state that oral hearing is mandatory. It is even more difficult to state that in all cases, oral hearings must be given, or else the principles of natural justice are breached. A number of judgments have been held. Have held that natural justice is a flexible tool that is used in order that a person or authority arrive at a just result. Such result can be arrived at in many cases without oral hearing, but on written representation given by the parties, after considering which a decision is then arrived at. Indeed, in a recent judgment of Gorkha Securities versus State NCT of Delhi, this court has held in blacklisting cases where the serious consequences ensue. Once a show cause notice is issued, an opportunity to reply is afforded, natural justice is satisfied, and it is not necessary to give oral hearing in such cases. Now, Millet, kindly consider in this circular on willful default, there is a provision, Millet. In our case, the circular on fraud, there is no such provision for giving a personal hearing after they have been given an opportunity to explain these circumstances.
Yet in this case, they held that personal hearing is not mandatory.
So, despite this, the court held it's not mandatory; it has to be given in all the cases. So, it's not which goes to something which goes to the root of the matter. Now, one other aspect was argued yesterday was the composition of the bank's authority who had issued this notice. Now, in this regard, the circular is very clear. It does not prescribe an authority who shall do, but unlike the circular on willful default, the circular on willful default by the RBI, willful default circular, I wanted to cite to argue in this circular, this is circular of willful defaulter. The RBI in this circular has very categorically stated who shall comprise as the identification committee, who will be the members of identification committee, and who will be the members of the review committee. And so, since the authorities are designated in this, I shall show, Millet.
So, whether the person who issued the notice and issued the order is the competent authority under this regulation?
Yes. In the circular regarding fraud, it's only the bank who has to do it. Whereas, Millet, in master directions for willful defaulter, Millet, I wanted to show this, Millet, why this is not necessary. Kindly, Millet, takes Millet. Yes, my lord, kindly takes the definition clause at page number 6
Of this
of the willful defaulter. Yes, my lord.
6.
Page 6, my lord. My lord knows in willful defaulter there are two layers of examination. One is identification committee and then the review committee. And kindly comes to para G, definition G, identification committee definition, my lord. Has found, my lord? Has found, my lord?
Para 6.
Para J, the definition clause, my lord, at page 6. So clause 3J, 3(1)J defines the identification committee. Page 6, numbering at the bottom, my lord. है क्या इसमें?
3.1, 3.3, J is not here.
Oh, I'm sorry, my lord. My does not.
3.3,
क्या दिए हो तुम? ये तो मैच नहीं कर रहा है. I'm sorry, my lord. I think I gave a wrong copy, my lord. This is the definition circular. Yes, but this is the circular. I'm so sorry, my lord. Relax, relax. My lord, kindly takes play page 6. Identification committee is defined, my lord, of this circular that I just hand up.
Yes.
Identification committee means committee constituted by the lender for identifying a willful defaulter and shall comprise of, in case of commercial banks and AIFIs, a whole-time director other than managing director, a chief executive officer of equivalent official, and two senior members as members not more than 2 rank below the chairperson of the committee. So, my lord, the constitution is defined. Similarly, my lord will find the constitution of review committees is paragraph R, 3R. Review committee means committee constituted by a lender of for the purpose of reviewing the proposal of identification committee and shall comprise of, in case of commercial banks and AIFIs, whole-time director who is MD and CEO, CFO or equivalent official of the lender as chairperson and two independent directors or non-executive directors or equivalent officials as members. So, my lord, here, whereas, my lord, in contrast, if my lord takes this fraud classification circular, it does not specify any specific officer to issue a show cause or the final findings.
No, if you come to the identification of committee.
Yes, my lord.
J.
Yes, my lord.
Correct. Commercial bank other than the foreign banks, AIF whole-time director other than the managing director or
Yes.
chief executive or equivalent officer as chairman of the two senior, not more than 2 ranks below of the chairman. In case where the only one whole-time director, then the MD and CEO or equivalent officer, such whole-time director may be part of the review committee. If the post of MD and CEO, the officer vacant, in such case, officer 1 rank below the whole-time director or the senior officer as member, not more than 1 rank of the chairperson of the committee. Who has passed the order here?
Yes. Yes, my lord. My lord, this circular that has willful default circular clearly specifies in clause 4 that who shall issue show cause,
That's why
who shall, whereas in the fraud classification circular, there is no such requirement. That's what I'm trying to explain. The circular does not visualize that this particular authority shall issue the show cause notice or this particular authority shall issue the final findings of fraud classification. This is where it is distinct. My little friend said that a zonal manager has issued. All that is required is that the bank has to do, and now it kindly comes, what is required? A fraud monitoring group has to do it under clause 8.3, my lord. And in this case, fraud monitoring group was constituted and has issued the order. Kindly comes to the final order at page 155 of 7th August 2025, 24. The final order is there, my lord.
Just a minute.
Last yes, my lord. Few pages, my lord. এটা নিচে লাগিয়ে দিন তো খুলে গেছিল my lord. The remaining portion is here, my lord. It can be stapled together, my lord. I'm so sorry, my lord. কি দেখাচ্ছি না আমরা? হ্যাঁ
Yes.
Well, it kindly now takes my lord the final order of 7th August at page 155, the impugned order.
Yes.
24, my lord. The and straight away comes to my lord page number 162.
Yes.
Paragraph 6. The competent authority has felt that the borrower notices has to be given a chance to make their submissions in the interest of natural justice. Consequent to which, a show cause notice dated 28 February 24 was issued to the noticee, herein seeking their written submissions on the findings, observations of the forensic audit report, internal investigation report. The show cause notice was served on the noticee on so and so, detailing their observation, finding of the forensic audit report and the investigation report. In response to the show cause notice, the notice have made written submissions as a letter. Pursuant to receipt of the written submissions, the noticee is within 15 days of issuance of show cause notice. The fraud monitoring group of the bank has carefully examined. So this fraud monitoring group had been constituted. They examined and has carefully examined the forensic audit report and internal investigation report,
Yes.
the written submissions of the noticee received, and then the FMG have come to the conclusion based on the above findings that the account of Mrs. Swati Mining Private Limited is fit to be classified as fraud. Also, next paragraph is relevant, minute, because it is also alleged that there is no grounds. Kindly takes paragraph 3 at page 163. The above indicates clear diversion or siphoning of funds and utilizing the funds for purpose other than for which it was granted, thereby causing wrongful loss to the bank and wrongful gain to the noticee, with the intention to defraud the bank, causing loss of public money. The committee shall also committee also finds that noticee number 2 to 4, where the promoters, directors, partners of the company LLP who were promoters, directors, and partners at the time when the transaction had taken place and cannot be without their consent or connivance. Further, the notice number 4 have not been able to prove the transaction had taken place without their knowledge or consent. This, in light of uncontroverted stand, the allegations made have not been denied or disputed. Now, let huh? But what is also relevant is I shall also show why FMG is required. What is the purpose of? Although in this case the bank was not required. Kindly, Millet takes the regulation 8.3.6 at page internal page 20 of the. I shall show 8.3.6 is that
Of this circular.
8. Same circular, yes. No, Millet, of fraud classification. 126 Millet. 8.3.4.
Yes.
The modalities for monitoring the loan fraud below 500 million threshold is left to the discretion of the bank. However, the bank shall continue to report all identified accounts to CFMC RBI as per the existing cutoff. 8.5. After 7 lines, the officer 7-8 lines. The officer responsible. 8.3.5.
Yes.
7th line. The officer responsible for the operation in the account by whatever designation called should be sensitized to observe and report any manifestation of EWS promptly to the fraud monitoring group or any other group constituted by the bank for the purpose immediately. To ensure that the exercise remains meaningful, such officers may be held responsible for non-reporting delays in reporting. So here also 8.3.6, the FMG or any such designated committee shall classify the account as RFA, and details of RFA account shall be put up before the CMDC every month.
Correct.
So here, so there is no infraction of any guidelines as such.
Yes.
Now, the only thing that remains to be dealt with is that why the bank is not accepting their OTS. Kindly comes to 8.12.3 page there. Page same circular of fraud 8.12.3 internal page petition ka page.
Yes.
It has it no compromise. No compromise settlement involving a fraudulent borrower is allowed unless the conditions stipulate that criminal proceeding will be continued. So it's not a right that my friend can claim. It's a nationalized bank, my lord. It's a case of great fraud, my lord. CBI investigation is going on, my lord. At this instance, my lord, compromising perhaps might dilute the investigation, and it's a bank's prerogative dealing with public money to decide. You can't enforce it as a matter of right in court that you have to accept me because I offer payment. So it's a discretion left to the bank. And in my respectful submission till date, there's nothing that the bank has accepted the OTS. And perhaps this is a difficulty in why they cannot accept here.
Yes.
There's a clear bar under their guidelines.
Yes.
Now, only one point remains is my learned friend said that this petitioner had left the company in 2018 November. But all the allegations of fraud are prior to that period. Therefore, I want to file a comprehensive reply to this application. Kindly give me 1 week's time. I shall prepare and file my opposition. Now, as short as 1 week would be good enough, and this can be heard. And I vehemently oppose any stay as of now.
Yes.
I was requesting, my lord, after this hearing, there is, my lord, final disposal. What is the point of?
Very well.
I'll
My lord, we can
face the
dispose it of then.
consequences, whatever.
Very well.
What is the reply? If you want, you file the short.
No, if my lord is satisfied, well, I can proceed.
If you want, you file the short note, no problem.
I shall file a short note. Yes. I'll be obliged.
My lord, in reply, my lord, I wish to, my lord, say a few things. Get those judgments. Lord, what my learned friend has, my lord, said in reply, my lord, he is basically, my lord, argued 5 things. I'll deal, my lord, individually. First, my lord, is error in the show cause notice. My lord, there is no plausible explanation, my lord, which my learned friend has given.
But I forgot to cite one more case, my lord, on this. Just forgot. Patni. Only one judgment I wanted to cite on this infraction aspect, my lord. I'm sorry, I should have cited this. एक बार दिए दो 1 minute quickly. This judgment, my lord, I was at the receiving end in this judgment matter, my lord. Suresh Kumar Patni was a State Bank of India, my lord, where a similar argument was made by me and it was turned down, my lord. Kindly, my lord, takes my lord, paragraph 22 of the judgments. Para 22 of my lord sees, my lord. Coordinate benches judgment. A writ court cannot go into weigh the sufficiency of reasons given by an administrative or quasi-judicial authority. What is seen is whether there is some reasons, however small, in support of the finding. This is so that it is only a bank and the lender, given their special relation, that can access as whether any default on the part of the borrower is willful or not. A writ court does not possess such expertise. The writ petitioners have not been able to demonstrate as to how they have been prejudiced by such alleged act or omission on the part of the respondent. Assuming for the sake of argument that there are some infractions of procedure on the part of the bank, although the court does not find any, it is now well settled that every infraction of the principles of natural justice would not ipso facto vitiate the proceedings. The petitioner must be able to demonstrate clearly the prejudice suffered by reason of such infraction. Hence, even if one accepts the submissions of Mr. So-and-so that there has been some minor infraction of natural justice or procedure, no prejudice appears to have been caused to the petitioner by such infraction. Here also, there is nothing which says that because of this infraction, this is the prejudice I have suffered. Nowhere pleaded, nowhere argued. Those are my respects.
Yes.
My lord, that is still not a reply on the show cause notice. I am on, my lord, show cause notice. The show cause, kindly, my lord, just take my point on show cause notices that they are already predetermined. Despite, my lord, kindly takes page 142.
142.
144.
Yes, 142 starts. 144. Yes.
Yes. Kindly, my lord, see the subject. Show cause notice seeking your submission on re-examination of your account consequent to classification of fraud. So here, what they are saying is you have already been classified as fraud. As a consequence of that, you are now being re-examined. So my fraud classification, which was set aside by the single bench and upheld by the division bench, my lord, remains. There is nowhere in the letter where they say that we have followed the order of the division bench and the single bench, and we have removed that classification, and we are doing it afresh. The language of the division bench order, my lord, is afresh. Kindly, my lord, takes that order of the division bench. My learned friend had replied on, has relied on that. Page 93.
Paragraph 14.
The last part. I'll just.
Page 93, para 14.
Yes. Your lordship, my lord, will see the last line. Proceed afresh. With which, my lord, presupposes that I am clean today. It is not a consequence of my fraud classification, but it is a consequence of a clean slate and, my lord, a fresh proceeding. Now, this is here. It's a bank, my lord. They are saying serious fraud. And this is the language of the letter, my lord. Some branch manager is sending. Kindly see, my lord, the same thing again at page 150, paragraph 3, which has been classified as fraud. The third line. Provide your written submission with regard to your account, which has been classified. The only English language meaning of has been classified, my lord, is it is already done. This cannot be identified, to be identified, nothing. It means exactly what it is. So on this, my submission, humble submission of your lordship was that it's a predetermined mind where you are classified. You are quoting, my lord, some observations of the forensic auditor. You have not given me the copy of that forensic audit report. Yesterday a submission was made. Today also, my lord, they have not satisfied, my lord, to your lordship, that these allegations where it is contained, they have given me. Kindly, my lord, see the allegations once. Let me just say, serial number 1, as per accounting data provided to the forensic auditor, company has adjusted the receivables of 19 crores of various.
What is the date of the forensic report?
2020.
2020.
And this was prepared, my lord, in the NCLT proceedings. There was, my lord, operational creditor, my lord, filed something, and there, my lord, they had prepared. And, my lord, I have annexed the NCLT order in the application which was filed, my lord, under the PUFE application, my lord, in NCLT. When, my lord, in these proceedings, when you allege fraud, they make an application, my lord, alleging preferential transaction, and avoidance transaction, fraudulent transaction. They have not relied on this report there.
Yes.
So today this forensic auditor, my lord, where are these documents to me? How am I to reply, my lord? I ask myself. I am just taking an example, my lord, just showing as per accounting data provided to the forensic auditor. Kindly see, my lord, serial number 1, page 145 in that table.
Yes, I got it.
Where is that data that you provided to the forensic auditor? If I don't see that data, how am I, my lord, to respond to that? Forensic auditor received some data from the bank. On the basis of that data, came up with a report, and I am being declared fraud, my lord, on the basis of that report. And everything done by the bankers. Forensic auditor under their control, IBC proceeding under their control, everything. Number 2, borrower had indirectly connected with such and such company, and past directors were directed. Who are the no name given? See the vagueness of the allegation. Some directors of your company was connected with directors of another company, because of which you are fraud. My lord, I ask myself, if this letter is today given to rand people, how are they going to, if it comes to your lordship tomorrow, is it possible to reply to this? We are all, my lord, banking with bankers. Then 3, it was observed that the borrower company had made payments to Concast during the entire period 2015-16 and purchase transactions of
whether you have given the reply to this pairwise observation of the forensic audit which is mentioned in the so-called snippet.
So I said you provide me this data 2015-16, whatever you are, my lord, saying, you provide me the data and then I will reply. This is permissible. I have, my lord, shown a judgment where if I receive a letter like this, my lord, I say you give me this data, what you're saying, and substantiate it, then I will reply. I have not shied away, my lord, from replying. But if I today say no, nothing, I am not done, that will be a vague response. Kindly, my lord, take my response. On the show cause, my lord, I am saying that this tabulated, this is the tabulated, this is not something, my lord, which is falling from then. Kindly see page 153, my lord, my reply.
Yes, you have pointed out paragraph 3.
I am saying you, unless and until you provide such details, I am unable to provide any further details in the case. The company is in liquidation. I don't have the relevant documents to reply to the show cause notice.
Yes.
So, and my lord, once the company, my lord, goes into CIRP, a resolution professional is appointed, my lord, who lordship knows, and they take over the management of the company. All data is with that RP. Even my lord liquidator today, he has all the data. So 2015-16 records, they are saying financial records you provide. My lord, if they don't provide, I am not, my lord, obligated to answer. And on this, my lord, I have cited Hemant Kanoria, my lord, your lordship has seen, and that still remains, that is still there, that you must provide. Even Rajesh Agarwal, my lord, Supreme Court says, show cause notice, along with that, you have to give the material. And Hemant Kanoria, my lord, specifies what steps are to be taken. You ask for documents. If they are voluminous, then you give an inspection. After that, my lord, I'll reply. Then I'll say that I will file an additional reply. Nothing, my lord.
Okay.
Now, and kindly, my lord, see now my reply, and after that, so on the show cause notice, my lord, this is my response. Next, my lord, forensic audit report also. I am saying, my lord, that not submitted. Not only forensic audit report, none of the data which is there in that table, assuming forensic they don't give, but 15-16 financial year.
This data, this is the observation and finding of the forensic report.
Audit
If you
report.
get the forensic report, you will get the total details.
Yes, it's a voluminous forensic they should have given. Now, my lord, RFA, my lord, is not mandatory. That's what my learned friend said. Perhaps, my lord, the interpretation which my learned friend made out of the circular is not correct. Kindly, my lord, goes to page 107.
Page number?
It starts there. My learned friend replied on, my lord, 8.3, page 125.
Yes.
Now, 8.2, if your lordship sees the objective,
Correct.
it is to prevent. Now, post-liquidation, my lord, nothing can be prevented. Early detection. It cannot be, there cannot be a question of early detection, my lord, now. Prompt reporting to RBI, the system, etc., etc. So this circular, the purpose of this circular is, my lord, I have shown, my lord, loan cycle, the term loan cycle. In 8.2, it appears, my lord, fourth last line of this.
That you have
cycle.
mentioned, yes.
Yes. So, if a circular is for a particular purpose, it must be invoked or used for that particular purpose.
Correct.
And, my lord, your lordship knows, my lord, the statutory principle, my lord, what has to be done in a particular way, my lord, must be done in that particular way.
Correct.
You cannot choose to do something else apart from this. So this circular was a preventive measure. This was never meant to, my lord, do a post-mortem post-liquidation. Why, my lord? There are other provisions under the Companies Act.
Their contention is as per 8.3.1 and 8.3.2. And further, so 8.3.3 and 8.3.4, it is more, if the fraud is more than 500 million, then this will.
I'll show that. But
That is the
there is no
condition.
answer to this, because I am today, my lord, at a post-liquidation stage.
Correct.
And there is no answer to this, that how this circular is applicable. There has to be first the law which is invoked and consequences from there. So I am saying that you are not entitled to invoke this. The court has said, my lord, do it afresh in accordance with law. It cannot be not in accordance with law. So number 2 is there is no answer to that. Now RFA, my lord, kindly sees 8.3.1, my lord, the last line is says that a bank cannot afford to ignore the EWS, but must instead use them to trigger a launch into an investigation into an RFA. Now, EWS, my lord, are there at page 139. This is annexure 2.
Yes.
Which is also, my lord, referred to in 8.3.2.
Yes.
Kindly see early warning signals which should alert the bank officials about some wrongdoings in the loan accounts,
Correct.
which may turn out to be fraudulent. So this is a stage where the bank is monitoring my activity and seeing, nothing to do with forensic audit report, that to stop me from becoming fraudulent, they should do these checks and balances. And this is, my lord, universally for all. Nothing to do with 1 crore. 1 crore person is also fraud. 5 crore is also fraud. Now, my lord, that part. 8.3.3. Threshold for EWS and RFA is an exposure of 500 million. My lord, I understand that is 50 crores or more at the level of a bank, irrespective of lending arrangement. All accounts beyond 500 classified as beyond 500 million classified as RFA or frauds. So this is, my lord, above 500 million who have already been classified as RFA or frauds must also be reported to credit data. Must also.
Yes.
So the first part, which is 8.3.1, 8.3.2 is a general.
Correct.
That you see EWS, you do RFA.
Correct.
8.3.2 illustrative list of EWS is given. Banks may choose to adopt EWS so complied by a bank would form the basis for classifying an account as RFA. 8.3.2 last line. This is general for all.
Yes.
This is also, kindly notes the word also, all accounts beyond 500 million which have already been classified as RFA after that exercise of EWS must also be reported to CRILIC data platform. It is not something that will only be sent to CRILIC. Now, my lord, I will explain this further. So it is not something that only 500 and above will be RFA and I will be straight away, my lord, fraud. All accounts beyond classified as fraud must also be reported to CRILIC. As of now, requirements are such. 8.3.4. The modalities for monitoring of loan frauds below 500 million threshold is left to the discretion of the banks. However, banks shall continue to report all identified accounts to CFMC RBI as per existing cutoffs. Now, this discretion, my lord, will be used as what? It does not say that they can just straight away classify. There must be some policy.
But you,
The tracking of EWS in loan accounts should not be seen as an additional task, but 8.3.5, but must be integrated with the credit monitoring process in the bank so that it becomes a continuous activity and also acts as a trigger.
but you kindly come to 8.3.3.
8.8.8. Now, my lord, I'll come to that. 8.8, 8.3.6, my lord. The FMG or any designated committee shall classify the account as RFA and the details of RFA accounts shall be put up to CM. So here also there is no classification. It says shall.
That's why I'm telling 8.3.3, the last line. As of now, the requirement is in addition to the extent requirement of the reporting to the RBI as mentioned. Kindly see the paragraph 3.2. Your answer is there.
Yes.
Kindly see the paragraph 3.2. Banks need to furnish the fraud monitoring in individual fraud cases, irrespective of the amount involved, to the RBI electronics using the
3.2.
3.2.
Illustrative.
Yes.
List of EWS is given for the
No,
guidance.
3.2 of this.
Oh, 3.2. Reporting of fraud. Banks need to furnish fraud monitoring return in individual fraud cases, irrespective of the amount involved, to RBI electronically using FMR in XBRL system supplied to them within 3 weeks from the detection. So first they have to detect under the EWS, my lord, whatever, my lord, that process is, schedule 2. And then, my lord, they have to proceed with classification of my status.
Yes.
Issue me a show cause notice. My lord, without RFA, my lord, the banks can, they have to, my lord. Kindly, my lord, the other, your lordship has to read that part with the other.
Next, what is the next point? Next answer to the
Now, also, my lord, I had relied on this point, 8.8.
8.8.
Yes, that is the procedure. If the bank is a sole lender,
Correct. You already pointed out.
Yes. And my lord, 8.9.4. Now my learned friend has shown this no compromise 8.12.3. This, my lord, is under the penal measures for fraudulent borrowers. In general, penal measures as applicable to willful defaulters would apply to fraudulent borrower, including the promoter, director, etc. So I have to be classified as a fraud and that has to be upheld here. And then if that is the case, then my lord, no compromise settlement involving a fraudulent borrower is allowed unless conditions stipulate that the criminal complaint be continued. So this is also qualified. It is not like kindly similar 8.12.3. Compromise they can enter into 8.12.3, which they are doing now.
Yes. No compromise settlement involving fraudulent borrower is allowed
Unless
condition
it
stipulate that
criminal complaint. So if there is a CBI case pending or any police case pending, they can say I'm taking the money, but the criminal proceedings will continue. That's exactly, my lord, what it says. And this, my lord, has been a bone of contention. It's gone to Supreme Court that if there is, your lordship will know this criminal side better, my lord, that non-compounding, compounding. So if there is no murder involved, no rape involved, you settle the matter.
yes.
Bank frauds, you also criminal complaint can go. So this is that. Now next they say, my lord, oral hearing, my lord. Now, my lord, next point, my learned friend has not answered that issue that I raised, that a forensic audit report solely, my lord, cannot be the basis of the show cause notice and ultimately, my lord, the finding also. If your lordship, my lord, sees this order, the final order, which they say is an order, 7th August 2024,
162.
which is 156.
Yes, 156.
Here also, my lord, the first 3 persons, no show cause notices were issued to them. Randomly, only 4, my lord, had received the notice.
No, but the so cause notice, kindly come to the so cause notice.
Yes, kindly.
Page 144.
144.
It is addressed to 3.
3. Now only 1, my lord.
Amit Kejriwal is the one.
1, my lord, is
Chandra.
serial number 4 at page 156. And 2, Sudhir Chandra Mondal does not appear in the order. I don't know who these people, my lord, they've just randomly sent. Show cause notice, serial number 2.
Correct.
This person is not reflected in page 156. At the time of argument, he said he's a director. Now 3, Mr. Hari Mohan Mondal. This person is also, my lord, not there in 156. Then number 1, Swati Mining receives an order saying you're fraud. But kindly see their show cause notice last paragraph at page 150, para 4. This notice is not being issued to Swati Mining as it has already been liquidated and dissolved by the Honorable NCLT. And so I am, my lord, I can in writ court, my lord, jurisdiction show the lacuna in the procedure adopted by them.
Yes.
The erratic manner in which, my lord, this whole exercise has been conducted.
So this Swati, it's okay. Then Samrat Chakravarti.
No show cause notice, but order given.
And Girja Thakur.
No show cause notice, order given.
Yeah.
Amit Kejriwal is the only person who is common. This will show, my lord, lack of application of their mind.
Whether they have challenged this order, no.
My lord, I am not aware. And I don't know. I will not, my lord, I don't know if they have annexed, if they challenge, and these 2 persons in the show cause notice, I don't know who they are. And my lord, now this kindly see, my lord, para 4, 157.
Yes.
My lord, my submissions before your lordship, my lord, was there is no reasoned order. Leaving aside everything I have argued till now. Kindly see the first 157, my lord. First paragraph 2. These are the notices. This is facts. At the request of the company, such and such granted credit facility. Para 3. Account of the borrower has turned NPA and such and such. Para 4. Conducting forensic audit, internal investigation, issuance of show cause. This is, my lord, notice, whatever was in the notice. Para 5. Findings of the forensic audit or internal investigation were placed before the competent authority. They have not said, my lord, who is the competent authority. Competent authority after perusal, this is facts, narration of facts. After perusal of the inquiry has had some feelings that there are suspected fraudulent connotations in view of the following observations, findings in the conclusion of the forensic audit internal investigation. So the same thing was said in show cause notice also, if your lordship sees, my lord.
But in reply, my lord, the case is being re-argued.
Saying that there is no response
Reply only on law.
You already argued, yes.
that there is no reason.
That you already argued on.
These are not reasons. And reasons, my lord, are mandatory, my lord, which I have said. Rajesh Agarwal, my lord, I have relied on certain paragraphs. And, my lord, this Prashant Bothra, which my learned friend has said, my lord, has been overruled. I had relied on 2 paragraphs, 21 and 22.
Which one?
In that Prashant Bothra, my lord, forensic audit report is not a paragraph.
Yes.
Paragraph, my lord, this was a judgment, my lord, where the petitioners had challenged lookout circulars and issued by, my lord, SFIO. Here, para 21, 22, my lord, it says that FAR, my lord.
No, this is the Prashant Bothra set aside by the division bench.
Yes, but that part, my lord, FAR, my lord, is not an evidence, is a conclusive evidence, my lord. There is no, my lord, discussion.
So each paragraph has to be separately set aside.
Yes.
That's what she says.
Very well.
The entire judgment has been set aside.
Now, my lord, I will then, in that case, my lord, rely on just 2 judgments to show that FAR, my lord, is not conclusive evidence.
Because if you come to the appeal court order 101 paragraph 101 of the appeal court order of the.
I will not.
Have you gone through?
101, my lord, was.
Of the Prashant Bothra appeal court order.
I have 2 judgments.
Yes, Mr. Singh has.
Yes, my lord. So it says that mainly on the basis of the fraud declaration, LOC, my lord, should not be.
No, LOC by a bank in terms of the memorandum must not be made dependent on the account being declared as a fraud in terms of the master direct. Correct. Now, in your case, they have relied upon the forensic report. Now, your main question is that the forensic report has not been supplied to you.
They have been on forensic audit report. They have.
No, they are no. You have been not supplied with the forensic report. In the so-cause notice, they have relied upon the so-cause notice with regard to the forensic report, and in the judgment, in the impugn order also, they only on the basis of the forensic report it has been produced and passed an order declaring the fraud.
Yes, and therefore and the forensic audit report they are relying, they have specifically said everywhere. And I am saying, my lord, I had relied on that. There are 2 more judgments, my lord, that this cannot be the sole basis. They have to, forensic audit reporter may say anything. And if they have not produced that report also, which has some limitations, this is the data provided by them. So I have not been in a position to reply. That is, my lord, there.
Okay.
And now, my lord, last point they said, oral hearing, my lord. They are saying that this is not mandatory. Now, my lord, Bombay, Anil Ambani is saying that, but Anil Ambani, despite, my lord, is making those statements, it is considering, my lord, the 2024 circular. If I may just show that judgment. And your lordship is not bound to follow that because we have Hemant Kanoria, my lord, which I relied on of our High Court. I am only replying now. Yes.
Bani, only with regard to the whether the personal hearing is to be given or whether that is a mandatory.
That was not given. And I have mentioned that you give me the documents, you give me this. But are kindly similar para 15
Of the Ambani.
of this Sanil Ambani.
Paragraph numbers will not.
Para 16. 15, 16, both, my lord, they refer to the master directions of 2024. We are concerned with 26, 15. 15, 16. Para 15, para 16, my lord, 17. All, my lord, master directions of 2024.
Might be, but
Para
whether the master direction which you relied upon, it provides that the personal
and conflict division bench of Delhi High Court says personal hearing is necessary.
No, not cited. Please, if you not cited, don't say.
No, it is mentioned here.
No, but you have not cited it.
No,
If you have not cited, how will I deal with this?
My lord, I have cited already Hemant Kanoria.
Yes, Hemant Kanoria is here. Hemant Kanoria is of the single judge bench of this court.
No, IDBI. No.
Hemant Kanoria is the single judge bench.
Yes, and I have recorded division bench Delhi.
Division bench Delhi you have provided, no?
That was Bombay. This is Delhi.
No.
IDBI.
No.
So you answer on this. Lord, kindly see.
You're citing cases in reply, then I'll have to make further.
To bring it to your lordship's notice. Your lordship are high.
Should have brought various things to notice. You have not brought, including your reply, the fact that you received the forensic audit report. You suppress that letter.
Kindly see.
After giving the show cause notice, bank replies to them, forwards the forensic report. They suppress this in the writ petition, Millard. This is a letter, Millard.
What letter, Millard? This is letter.
Yes. Of course, that's why I wanted to file an affidavit. Millard, kindly take this letter. It was sent by post as well as by email, Millard. The forensic audit report has been forwarded and they have not suppressed. They completely suppressed everything. Give them a copy.
Let me give me a copy, please.
You suppress everything and then come to court.
A copy, please.
Give the copy.
No copy.
May I just see what my
No, I'm giving you a copy.
This will not para 1820.
So specifically in reply to the show cause notice, we said take a copy of the forensic audit report. Not only, and this letter has been suppressed.
IDBI, which paragraph you are relying upon?
Yes, 18, 20, 21, 22, 23.
18, 20, 21, 23.
22 and 23.
Yes.
This is unbelievable.
These are 2025. Delhi bench judgment is of 2020 up to this.
Yes.
What is the date?
There. I am saying today this is before your lordship. Bombay says no personal hearing. Delhi says personal hearing required. And our High Court single bench, your lordship is also there in single bench, my lord. Usually, my lord, protocol says your lordship must follow our High Court and pass. Your lordship is not bound to follow the other High Court. Your lordship is not bound.
Yes.
Kindly see, my lord, Hemant Kanoria, para 64 to 68.
Yes, I have taken note of it.
That is clear. It says
Correct.
personal hearing date must be fixed.
That the form is how the procedure has been given in that paragraph.
Yes. What is the procedure?
Correct.
And it stands. And if it's such a serious case, my lord, I will not be given a personal hearing. And no reason. Now this, whatever is handed over, my lord, kindly see the letter.
Yes.
16th April letter.
4th, 18th April 2024.
18th April. 16th April.
I have not been given any 16th April. On the top, my lord, is.
Which one?
I have this one.
This one.
That I don't know. 16th April is not a letter.
Kindly take 16th April letter, my lord, on the letterhead of Bank of India.
No, my lord. This
This letter has been completely suppressed, my lord.
May I answer?
Here, my lord, the bank writes, in response to the show cause notice, forwarding a copy of the forensic audit report. The same letter is also sent by email. Everything has been suppressed in the writ petition.
No. This one, the 16th April, replied to a letter dated 21st of March 2024. 21st of March 2024.
The reply is annexure, my lord.
Yes, it is
310.
March. But where is this? Because where is the service of this letter they are showing?
Kindly see, my lord, the email.
Let me-
Same letter is sent by email also. Kindly see, my lord.
And where is their annex? Kindly, my lord, let me answer. Well, they have not annexed anything in the letter also.
Kindly see, my lord, the email also has a.
Where are you saying the letter that I am annexing the copy?
The other email.
So, my lord, in this 16th April, there is no averment that I am hereby giving you a forensic audit report, my lord, and this letter, my lord, was also not.
Of course, please read it properly. Kindly looks at paragraph 2. There is a clear averment. Please read and then reply.
Yes. They have said it, but this reply 16th April, my lord, they have, my lord, not shown any service of this. What service, my lord, they are showing is 18th April 2014. This email. Sorry, 2024.
Yes.
Send by email also.
Kindly see, my lord, what is the email? To such and such. Now, my lord, the other persons are not given. Forwarded this message on Friday, such and such. Retention. Previous email, 10 years, I don't know. Then, a copy of Lord Mr. Amit Kejriwal PDF. One PDF. So, if it is one PDF, and assuming if it is this letter, so the forensic audit, my lord, is still not there. Let them open the email right here and now and show.
Yes.
And if this was genuine, my learned friend would have pointed it out before. Please find attached. Kindly see. Mr. Amit Kejriwal, sir, please find the attachment of reply of your letter against re-examination attachment. Doesn't say that, Milord, this one page, last line. Sir,
Please find attachment of reply of your
letter dated 21st March 2024 against re-examination of the classification of fraud. So they are giving me a reply, if at all. I have taken instruction, my lord, that we have not received. And this email ID also, I don't know. Anyway.
Have you received this mail?
That I don't know. Well, on my email IDs, I have shown.
Have you received this mail?
No, I don't know. I have to.
Then you have to take instruction because.
Yes, I'll take. But this does not mean they've given me the forensic audit report.
This letter, paragraph 2 states that the copy of the forensic report is enclosed herewith. Correct.
Yes.
And they are telling that so there is.
This letter does not have any service as such.
That's why. So now they are telling that it has been sent by mail.
So yesterday I took instruction from my clients, my lord, about the forensic audit report receipt. They are saying we haven't. We have asked, we haven't. He's checked through all the mails and he said FAR was not served. And this email, my lord, this letter is just a letter. There is no service. I have not, my lord, received this. This email, my lord, also says that they are only giving a reply with an attachment. This
Yes,
attachment.
Mr. Singh, how you can say that the report has been supplied to him?
My lord, I have instruction. This has been sent by email. This letter.
Instruction that she has not received. You have instruction that, but this letter does not reveal that it was served, and this letter does not reveal that the forensic report is, because kindly see the.
Well, that attachment can be comprehensive with a file can have the letter and the annexure together also, no, my lord. So, my lord, what I suggest is, my lord, let me file an affidavit. If my lord wants, I'll put on record whatever banks have. But this perhaps, I thought that they were not taking it seriously because they have the forensic audit report since the NCLT proceedings.
That is different thing.
Yes.
Whether they are
So-
having or they are not having, but the procedure.
So
is
also, my lord,
you have to follow your procedure.
yes, yes.
You cannot say you are having the forensic report. That's why we are not able. We are not required to supply.
Well,
the
I,
forensic
prima facie, I have shown letters
So that
which
is the
sent by
main
email.
question here, whether you have supplied the forensic report or not. If you say this mail contains that forensic report, because you are stating that please find in attachment of the reply of your letter dated 21st of March.
Yes.
That this 3-page letter consists of the what is a 308 KB.
That's the size of the file.
That size of the file. Then
Yes.
that is to be ascertained.
Yes.
Size of the file. The size of the file contains the what forensic report consists of how many pages?
I'll have to check that.
Then,
Then they'll let them file an affidavit and show.
correct.
If for that, but today, my lord, I have prima facie more than
No,
satisfied that
no, I'm sorry. Prima facie, my lord, there is no case at all.
Okay. Any further?
Yes, my lord, I have found 2 decisions where forensic audit report, my lord, is not a conclusive document and cannot be the basis of
Not always.
show cause or final audit.
You have not given a single reply response to the allegations made. It's an uncontroverted allegation have to be accepted.
Is there, and if your lordship.
Not always.
Yes, forensic.
But in the so-called reply, why you not given the pairwise reply in the though they have given
Yes.
point wise of the forensic report, why you not given the reply to that point
Not
wise?
because in my report.
And why this email was suppressed? They should have said that they have not received any response from.
No, kindly, my lord.
This email has been suppressed by the
Not
petitioner.
suppress, my lord. Kindly
have
see
not.
my reply, page 142. I have said post liquidation. This is my main point.
How soon you will file affidavit?
But I think give me 10 days time, my lord, I'll file it. Because it's a Raipur, the branches from Ranchi, they will have to come in their form.
But in my
Need 10
reply,
days time.
I have fundamentally raised that issue that post liquidation you cannot do this.
Okay.
And whatever you have given there point wise, my lord, how will I reply point wise if I don't have the material to reply? And I've denied everything. In my reply, kindly see, of course, my lord, kindly see my reply 151. It's not like I'm saying, yes, I have done all that. Kindly see, I am in
You are stated that forensic report is required to give the reply. Paragraph 150.
the entire reply. I've given a 5-page reply. It's not like
Nothing on merits.
there's no reflection of anything I have said here, my lord, in the order. Whatever, at least something I've said, they should have said in the order.
Okay.
I am in receipt of this.
Okay.
My lord has seen Suresh Patni's judgment. Kindly note paragraph 12 also that I have cited.
Yes,
Paragraph 12 is very clear.
It says the reasons, my lord, there are.
No, that's not. Oh, please. Para 12 is not what is not on reasons. My lord.
Saying there
Kindly
is no
takes
reason.
paragraph. Arey bhai. To bolte dao to. Kindly takes, my lord, paragraph 12 of Suresh Patni's judgment, my lord.
Paragraph 12.
Yes, my lord. I had cited 22. My lord, kindly also takes note of para 12.
Yes.
May I just.
That's all.
Yes, my lord. Good. I'm deeply obliged.
Hearing concluded. So it is the final, or can I dispose of it?
My lord can.
Hearing concluded. See
Then your lordship will not take note of what was handled.
No, then in that, if my lord does not want to take note of what
Yes,
only
but
one said, then allow me to file an opposition, my lord. Then allow me to file an opposition, my lord. I have
lordship can
prima facie shown that I have responded.
lordship decide. I will leave it to your lordship's, my lord, good conscience that a letter being handed over without proof, my lord, does not prove service.
No, email is there.
Yes.
Which has been suppressed completely.
All the next one.
My lord, I appear on behalf of the writ petitioner, my lord.
Hmm.
My lord, it's a very short point is involved. My client, in usual course of business, my lord, his employee had wrongly remitted twice an amount of 20 lakhs and 5 lakhs to a wrong RTGS account. The amount was transferred by RTGS real gross time settlement, as my lord is aware. Instead of the account number 8005, my lord, of his client, it was transferred to account number 8025. My lord will kindly see that's at paragraph 11. We only want a refund of that amount because the account of my client, my petitioner's client, and also where it has been wrongly remitted is with Yes Bank. We wrote letters to SBI, that is our client's banker, SBI has written a letter to Yes Bank that kindly refund the amount. My lord, when we wrote to Yes Bank, there was no reply from Yes Bank. We applied to Ombudsman. Ombudsman, my lord, that letter is very important, my lord. Will kindly see, my lord, page 37, my lord. My lord, page 37 is my complaint, my lord. Sorry, my lord. And the letter, the order is at page 41.
Right.
Page 41, my lord.
GST. GST.
My lord, all we want is the refund of that amount, 20 lakhs and 5 lakhs, back to the petitioner's account. My lord, may I read it? The complaint raised issue regarding wrong RTGS transfer, 20 lakhs. In this regard, comments was sought from the RE, Yes Bank, and it is observed from the RE submission, my lord, that is Yes Bank, that the bank received the debit consent from the beneficiary account holder. However, they were unable to transfer the disputed transaction as a hold was marked in his account due to notice received from Commercial Tax Authority. My lord, that's why Commercial Tax Authority has been made a party. The RE submission was shared with the customer via email dated 17 March 2025 seeking his comments, if any, that is between the Yes Bank and Commercial Tax Officer. On the last day when the matter was taken up, my lord will kindly see the last order. Commercial Tax Department was supposed to come with instructions as to why are they withholding.
Yes, my lord,
That's
I am
a short
appealing
point,
for the
my lord.
GST.
My lord, as to why are they holding? Because Yes Bank, my lord, it appears from the Ombudsman order that Yes Bank is ready to remit back the amount. So we have written letters to Commercial Tax Office also, my lord, but there's no reply. And my lord, Ombudsman has been pleased to reject my complaint.
Yes. What is your answer?
Yes, my lord. Here, my lord, two things. Before start with the allegation raised by the writ petitioner, my lord, this writ petition is suffer from misjoinder and non-joinder of party. Why, my lord? There is allegation that certain amount, initially 20 lakhs, after 4 months, again 5 lakhs, has been sent to another account. That person who is the account holder, he has not been made party in the proceeding. Now, my lord, what happened? If your lordship allow me to say this, if generally, my lord, this department is, my lord, suffering from various racketeer. Here, my lord, 79(1)(c) notice issued to the one, my lord, Sai Fertilizer Private Limited. He is the account holder of that account where, according to the writ petitioner, certain amount 20 lakhs and 5 lakhs has been sent to. Now, my lord, where this DRC 13, my lord, if you lordship see, my lord, allow me to hand over that DRC 13, my lord.
Our client has no connection with this cipher.
My lord, I have a doubt.
The amount has been gone to one of the accounts.
Right.
And you finally realize that wrongly it has been sent because of the change in the number.
My lord, 8005, 8025.
There's a difference in the account.
Yes.
So the S Bank is telling that he has not.
My lord.
Is no difficult.
My lord.
But the person in whose account has been transferred, he has to be heard.
My lord.
What is it? Whether that amount of that person, if we say it is not, then okay. If we say it is their account, then the Commercial Tax Authority will take appropriate step whether how this amount is coming. Then the matter will be solved. If tomorrow, the third person, if the court will pass an order, tomorrow third person will come. No, this amount is my pending, whatever it is. Then
another thing, my lord, from the various documents.
Yes.
Very briefly, my lord. I understand what's falling from your lordship. Perhaps the individual in whose account this has been credited should be represented. May I indicate that's perhaps not, my lord, required here.
Why?
I'll indicate why, my lord. 4-5 documents I'll show, my lord. Kindly bear with me. My lord, all that has happened here is, my lord, the end 4 digits of the, my lord, actual beneficiary where this amount was to go, my lord, was supposed to be 8005. Instead, what was typed in is 8025. The problem is with that 05 and 25, my lord. The 2 accounts, we have an account with SBI, the petitioner, my lord. From the SBI account, this has been remitted 20 lakhs to Yes Bank, 5 lakhs to ICICI Bank. Both in this account, because that one digit here and there, 2 and 0. That's the mistake. We realize it.
Now, who has deposited that?
We, the petitioner, by mistake. Petitioner in that third party account, we don't know the name. It was only a mistake while we do online transaction.
No, the amount which you wanted to deposit, but the number was wrong. You want to deposit the amount in your own name.
No, my lord.
Own account.
No, it was in some account and client's account, which was not remitted there. We come to know it later because the client, we immediately indicated that this is the amount which has been remitted to your account. The client says it's a mistake. We have not received anything. Then we inquire. While we inquire, we know that the person whom we had deputed, the petitioner had deputed, my lord, to do this remittance, he made a mistake, a careless mistake, my lord, which cost the petitioner 25 lakhs odd. Careless mistake, my lord.
Correct.
So today, all that we did then, we wrote our bankers, my lord, SBI. We wrote to SBI that please make sure this amount comes back to us. We are not at fault. It's a mistake. It's a bona fide mistake. SBI immediately takes steps. Our bankers, my lord, we have no complaint because they immediately took steps. They wrote to, my lord, Yes Bank that please, this is what has happened.
Both the amount went to the Yes Bank.
One to Yes Bank.
Yes Bank. One from the SBI, one from ICICI.
Both to Yes Bank, my lord. So we wrote to Yes Bank. The SBI wrote to Yes Bank. The reply from Yes Bank was that this particular account, I can't really give you back the money because we are under instructions from the authorities that there is a freezing of this account. Nothing to do with us.
The amount is freeze now.
The amount is in that account which is frozen.
Amount is freeze.
Yes, my lord.
Entire account, my lord.
That account, Yes Bank, stands frozen. Unfortunate, my lord. Our luck was bad. Nothing else. Had this been in an account, my lord, there was no proceeding, no attachment, we would have got it back. Now, my lord, today, we take steps immediately. We write to Yes Bank, we write to SBI, we even approach the Ombudsman. The reply that we get from the Ombudsman, and that is why the writ, my lord, because we stand remedialist now. The reply from the Ombudsman is, we could have given this, but this is beyond our ambit. Because GST is, my lord, involved now.
Yes Bank is ready to refund.
Today, my lord, the only way that they can keep this account, this amount, and not give it back to us is if the GST confirms that you have a proceeding which is pending the petitioner, my lord. If they have a proceeding against the petitioner, they have to bring records. If there are no records, they can't take the stand. So in my very humble submission, my lord, that individual, whoever account, my lord, has gone to, will be an unjust enrichment. And today, my lord, what has fallen from your lordship is that perhaps they should be made a party here. My lord, I would have bowed down if that amount was not frozen, the account was not frozen. Today, the account is frozen, my lord. So even if they come and say something, that will not be of any relevance because they can't take that amount out. Their account is frozen. The only party here, my lord, who are, my lord, the necessary and proper parties, because for us to, my lord, make that claim is the GST authorities. Because the bank is under, my lord, the bank will immediately give it back. Perhaps Yes Bank will also take the stand that I'll give it back to you, but I am under instructions from the GST authorities. So all that is required, my lord, is either for the GST authorities to take a stand that there is nothing that is left, you get it back, or the only other way that they can oppose this prayer is if they can come and will not indicate that there are proceedings against the petitioner, nothing else. So that is the reason, Lord, when the matter was first taken up, there was a direction that they come with a report. With instructions, my lord.
Only instructions.
Paragraph 5 of the order dated 28th of October 2025. That's a small prayer I have. It's a very small matter, can be resolved provided, my lord, the GST authorities indicate that yes, this cannot be withheld.
Which
and
order? Which order?
Well, this is the order of 28th of October 2025. My lord.
That's one number 1.
Paragraph 5.
That's one number 1 to 4.
That's the GST authorities, my lord. Because they have to either come with, my lord, this instruction that there is no case pending against us or initiated, or that there is something pending and something is initiated. If they say that there is something which is pending and initiated, I will not bow down.
That is correct. But if the amount is okay, you are deposited, but one amount has gone to the third party.
My lord.
Correct. So whether the third party is not required to be heard.
Lord, very respectfully may I submit this. not required to be heard because, my lord, the third party is no longer in control of that account. So today, my lord, if it's a frozen account,
On the application of the third party, it's not been frozen. The bank has frozen the amount when they, yes.
that is the reason.
I'm
So the
appearing
amount
bank-
will not go to the third party.
I'm appearing for banking ombudsman. Probably I can come of some assistance to this honorable court because when the complaint was lodged with the banking ombudsman, we followed it up immediately with Yes Bank. Now both the accounts, both the correct
You are
account,
appealing from whom?
I'm appearing for Reserve Bank. So banking ombudsman comes under me. I'm representing both. So when the complaint was lodged with the banking ombudsman, ombudsman immediately took it up with Yes Bank. Now both the concerned accounts, the correct account and the incorrect account, they come within the domain of Yes Bank. So Yes Bank, what we learned from Yes Bank on the basis of the follow-up that we did was, Yes Bank had received a confirmation of debit request by the concerned Sai Fertilizers account where it was wrongly remitted. So Yes Bank has given that in writing to Reserve Bank of India also. The only factor which stood in the way was the notice of the concerned tax authority by which there was freezing of the concerned account to the extent of 18,49,237. That is the amount. And the transaction which took place is beyond that. Now, admittedly, the money which has been remitted has been admitted by both the account holders as wrongly credited into that account.
So there is not.
So there is no dispute. They are not the necessary or proper party. The entire dispute has been shortened much because of the fact that there has been a clarity given as on date by the Yes Bank.
Correct.
Now it is for the tax authority to make the submission, because for banking ombudsman also the hands are tied. We have taken the steps and we have communicated to the petitioner also that this is what we have heard, and look, we can't do anything because there is no deficiency in service so far as the bank is concerned. Bank has done its due diligence. Now it is for the tax authority to satisfy your lordship.
Why?
My lord, here, my lord.
If the other party which we have taken this time,
Yes, my lord.
there is no dispute between that. So
No, my lord. Here, my lord, if your lordship allow me. Whenever a certain amount your lordship sent me in my account through online mode, whatever mode, my lord, when it reached to my account, it will be my money. Means this is the money of Sai Foundation. There is a proceeding initiated against Sai Foundation since claim 2018-19. And the notice for recovery issued 2023 means, my lord, their account, not only the mentioned account, entire other account which related with that PAN number has been freezed. Under such circumstances, only this Sai Foundation can, my lord, intimated us that no, this money is not my money. My lord, he is the correct party to say, no, this is not my money. Even then, my lord.
He has given the letter to the bank. The bank will supply
My lord,
to you.
no. Sai Foundations probably did not make any. No.
Sai Fertilizer,
Oh.
which is the wrong account in whose account the money has been remitted, he has informed its banker.
Correct. Yes, bank.
Late, my lord, my lord, my lord, from their notice, what
Lord, we have
it will
also got
appear, my lord.
Yes Bank is being represented, my lord.
May I understand debit concern? I apologize.
They have accepted that we have to give this money back. That's Yes Bank's stand. That we are ready and willing to give this back. Is confirmed, ma'am, my lord.
So I am making submission on the basis of the instruction. The
Yes, there is.
There's nothing in
There is,
dispute there.
probably, my lord, one appeal has been preferred by the Sai Foundation, probably, my lord, before under section 107. So that is pending.
That's a different matter altogether.
That maybe is
That against their own proceeding.
With regard to this amount, the Sai, what is the Sai Fertilizer has already given that he has no objection. It may be debited back to the account.
Question is my
money. He can't.
My lord, question is here, my lord. they have to approach the court with proper, my lord. Kindly see 107.
Petitioner
My
approach.
lord, 107. Kindly
Yes,
once, my lord. My lord, kindly once, my lord, read 107.
107 is an appeal. May I only interject once? 107 is a GST appeal, my lord, which is from a GST proceeding either under section 73 or 74. But that's for a different proceeding against that individual.
Any notice, my lord,
We are in
issued
no way, my
under
lord, connected to that.
79(1)(c), this recovery proceeding. Any order passed there under?
Against whom?
My lord, any person, any
Against whom the proceeding has been initiated.
If they can show it is against us,
Initiated. When
my
it
lord.
was initiated.
My lord, long back, that is, we initiated 2023, my lord.
2023? 2023.
Yes, my
Correct. So what is the order passed?
My lord?
What is the order?
Order passed to freeze their account with a certain direction that it is observed that you hold or likely to hold a sum of rupees so and so 18 lakhs and odd for or on account of the said person in account number so and so and or any other account under the same PAN and or name.
Correct.
This was the order passed under section 79(1)(c).
Correct.
I don't know, my lord, whether this, my lord, Sai Fertilizer probably preferred an appeal under 107, my lord, means an appeal is pending. My lord.
Correct. That is with regard to the Sai Fertilizer.
Yes.
This amount is not of the Sai Fertilizer. This amount is wrongly remitted in the account of Sai Fertilizer, and he has confirmed with the bank as it is not my amount. It is not my amount. It is the amount of the other. It can be debited.
My lord,
So
that,
how you
my lord,
can,
that
how you can claim that amount
my
now?
lord, that instruction or that information, it should be with GST authority also. Yes, my lord.
They're
No.
supporting unjust.
It has been given.
No, no, no.
The very moment Lordship, we received the debit consent from the high fertilizers, we have informed the same to the GST authorities and we have asked for instructions whether GST is now.
So, the petitioner is trying, RBI is trying, SBI is trying, Yes Bank is trying. The only party not trying is the GST authorities.
Page number 2 and the reply by the tax authority on the first page.
Yes, it is there.
I think, my lord, I don't have a.
No instruction. You are making
Yes.
submission before this court.
My lord, may I?
Any proper instruction you are coming
You are,
before this court.
my lord, allow me to see this.
See the
And also very, very limited prayer, my lord. If your lordship kindly takes up page 19, the first prayer, we have prayed that this release of hold mark on the account for Yes Bank and my lord ICICI Bank is all that we have prayed for. And my lord, the remittance, consequential remittance. Consequential remittance of this 25 lakhs. Once the permission is given, and this permission is, my lord, because there's nothing by the GST authorities. So if it's an order of the court, they have to, my lord, comply with it. That's all that we are praying for.
If your lordship allow me a 2 days time at least to take instruction in this regard, my lord.
No instruction.
I don't have this document with me.
How you can say once the bank stated that he has deposited the amount, but wrongly it has gone to, so what the tax authority will do? Can you attach the amount of this person if there is any due of the fertilizer?
I'm very grateful. That's the point.
Here, my lord, the amount mentioned is 20 lakhs. We doubt is coming from the issue that once he paid 20 lakhs, again after 4 months, again paid 5 lakhs. Same account, same mistake repeatedly they are doing.
Not
So,
that
my lord,
benefit out
can
of
allow me to
it's
take
a mistake by the
in this regard, my lord, whether from so and so.
The proceeding initiated in 2023. And the money has been
24 December.
25.
That is why, my lord, 2023 notice issued, then again, even then this account are freezed because money is not in the account.
If suppose,
My lord.
what you will do if it is proved that this is the money of the petitioner, it is not the money of the fertilizer, how the tax authority can say, no, whatever it be, amount has come to the account, the tax authority can realize that amount.
My lord,
If
here,
by mistakenly the amount has been changed,
my
you
lord, that
only
is
you only can issue the notice to the person if they have not paid the tax in terms of this transactions. Nothing
my lord,
else.
when amount come, my lord, in a account, means the account holder is the owner of that money, my lord. This is their money, my lord. It is this question whether this money come from mistake or through different way. That is, we need separate intimation, my lord. We don't have this.
Then how you can say this come on this account only to avoid the payment to you in terms of the tax recovery? They are giving consent for returning back the amount. It is a contention that it is the amount of the fertilizer only to avoid your proceedings. He has given the consent. What you are making the submission?
My lord, we can, my lord, assume this.
Assume.
Yes, yes.
That's why. Otherwise, why you are making the objection?
That is why I used my lord racketeer, my lord.
We had also written to them at page 44, my lord. They have not replied to it. The GST authorities are also, my lord.
My lord, kindly take this matter, my lord, on tomorrow, my lord, so that I can take instruction in regard to this notice. I don't. I did not.
But kindly pass an order of the court.
Information about this, my lord.
It is your authority.
This is, but
Your authority has not given an instruction to you.
My lord, I have to take instruction. My lord, it's GST, my lord.
Then this is not your authority. This is not the mail of your authority.
My lord, they probably is not a part of read petition. That is why probably they missed it.
This copy, we can't have this copy.
It is the Yes Bank. Yes Bank immediately. Yes Bank inform you.
My lord, tomorrow 10:30, ma'am. My lord, may I come back on tomorrow 10:30?
Come tomorrow. Come tomorrow.
I have some personal difficulty tomorrow at 10:30.
But there can't be any instruction. But kindly pass an order of the court, my lord.
At time all parties will be available. I will fix that as per the convenience of the party.
If it's pending for long, but kindly.
Yeah, I will dispose of. No problem.
Monday, if it is not much of a problem.
No problem, man. Tell your convenience time. I will fix.
Monday.
My lord, any day, my lord, subject to.
Any day that's convenient to your lordship.
Come on,
My lord,
14th.
10:30.
14th at 12 noon. 14th at 12 noon.
14th, my lord.
Consul
Lord, may the letter be kept on record, my lord.
My lord,
Letter be kept on record. May I have my lord's kind leave?
Please give that communication.
Yes, my lord, I'm handing.
May I have my lord's kind leave?
Yes, yes.
Deeply obliged.
12.
Learned Consul appearing for the Yes Bank has handed over 2 documents. That is one with regard to the communication of the remittance of 20 lakhs the account of.
May I be?
Yes, yes. In the account of Jai Fertilizer. What is the name?
My lord, Sai. My lord, is Sai Fertilizer.
Sai Fertilizer.
Private Limited, my lord.
Private Limited. On the basis of the same, the GST authorities have also sent a reply to the Yes Bank. The Yes Bank has also. Where is the another letter?
My lord.
Acha, this.
Debit 30 December 2020.
The Consul for the Yes Bank has also also shown a letter issued by give that letter. Sai Fertilizer issued by Sai Fertilizer Private Limited dated 30 December 2024, intimating the bank, confirming the bank that the amount credited in its account is not of the Sai Fertilizer, and requested the bank to debit the said amount in the account of Jai Fertilizer and return back the said funds. The Learned Counsel for the GST authorities has prayed for time to take instruction. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 14th of November at 12 noon under the heading Urgent Motion.
Grateful, my lord.
Your lordship had pleased to fix item 39 at 12th.
39.
39.
Yes, call the 39.
I am for the petition.
I am for the respondent licensee company.
Yes.
Well, lordship need not look into, my lord, the volume of the papers, my lord. I will not trouble your lordship with all those. My lord, I will tell your lordship very briefly, my lord. Lordship has seen, my lord, or my lord, the dispute is with DVC. My lord, the petitioner before your lordship, my lord, is a consumer of DVC, my lord. Factory is run by them. Now, several customers or most of the customers of my lord DVC have, my lord, grievances against DVC regarding the tariff, the determination of tariff by WBRC. Matters are, my lord, still pending before this honorable court, before a division bench possibly.
Yes.
Now, today we are not on that, my lord. As on date, my lord, it would be, my lord, I would show your lordship that, my lord, there is really nothing new. Except, my lord, the disputed portion. My lord, if your lordship is pleased to come to, my lord, one order, I am cutting it short, my lord. There are several facts, but I don't think, my lord, that my learned friend will say that, my lord, I have suppressed anything or I have not placed something, my lord,
Telling that suppressed.
not relevant. Now, my lord, kindly come to, my lord, page 150. An order of a division bench of this honorable court of 8th April 2025, my lord. Second volume.
Yes. 150.
150, my lord. It starts, my lord, the second volume.
Yes.
Now, kindly come to page 155. Or, my lord, 154, my lord, kindly come. Paragraph 3. The learned senior advocates appearing for the applicants would submit that there are two limbs to the order dated 10th February 2025. The first limb directs payment of 50% of the arrears based on the tariff as determined in the order passed by DVC within a period of 60 days from the date of receipt of the server copy of the order. They submitted that 60 days period comes to an end on 11th April 2025 and all the applicants are ready and willing to comply with the said direction. The intention that they seek before this court is with regard to the second leave or the modification possibly that they seek with before this honorable court with regard to the second limb of the direction while granting a stay. The balance 50% of the demand based on the tariff or condition was imposed directing the consumer appellant to give unconditional bank guarantee from the scheduled bank within 60 days from the date of receipt of the same. The applicants would contend that so far as the second limb of the order is concerned, the consumer appellants are ready to pay instead of furnishing bank guarantee but requires reasonable time of at least 6 months. That was opposed. Kindly come to paragraph 7. After hearing the learned senior advocates for the parties for a considerable length of time, the court is of the view that since the consumer appellants are ready and willing to pay the remaining 50% instead of furnishing a bank guarantee without modification of the earlier direction would only extend the time fixed to comply with the second part of the direction by granting 60 days time from the date of receipt of the server copy of this. Now this was complied with. After that, my lord, a further claim came from DVC, my lord. If your lordship is pleased to come to, my lord, page 161.
Yes.
Kindly come towards the middle, my lord. Lordship will find, my lord, it's a email from DVC. Respected sir, madam, please note that the Honorable Appellate Tribunal of Electricity has modified the interim order dated such and such by its order dated such and. In view of the above mentioned order dated 11th August 2025, please note the following. Principal area amount in respect of the tariff order issued by the Honorable WBRC on 17 June 2022 is 65,88,000. This was the demand made by DVC by this mail. Now, my lord, my client approached them. The DVC, my lord, agreed to take this money by installments. My lord, if your lordship is pleased to come to, my lord, paragraph 30, first volume, my lord. Page 19, 19.
Yes.
Subsequently, the petitioners, without prejudice to their rights and contentions, issued a letter to DVC requesting the latter to accept the payment of the amount of rupees 65,88,031 in equal monthly installments. Such prayer of the petitioner was allowed by DVC, and the petitioners were thereafter requested to make payment of 50% of the aforesaid sum of rupees 65,88,000 upfront and the remaining 50% in tranches. Now kindly turn the page. Paragraph 31 was the upfront payment. Apropos to the above, the petitioners made upfront payment of 50% of the arrears to DVC in the following manner. Then paragraph 32. Thereafter, the petitioner made payment of the sum of rupees 16,47,000 to DVC towards the remaining 50% arrears. The details and particulars whereof are given, my lord. This not paid, my lord. I would say, my lord, checks were issued. 14th October has been paid. I'm sorry, my lord. I made a mistake.
No, this one, thereafter the petitioner made the payment of 16 lakh.
Yes, that is also, my lord. I don't think that there can be any dispute about that. So the balance was 16 lakhs of rupees, 16 lakhs and odd. At this stage, my lord, there comes an order of APTEL. My lord, if your lordship is pleased to come to, my lord, the APTEL order, my lord, which is page 178, second volume.
117.
178. The order starts at page 178, my lord. Lordship will kindly come to page 234 directly.
Yes. Paragraph
167, my lord, the bold, the top.
Yes.
We therefore find it just and reasonable to set aside WBRC's erroneous approach of treating the entire T&D cost as attributable to firm consumers without taking into consideration each generating station's allocation of power supply to firm consumers, the quantum of wheeled power through open access, and the supply of power to bilateral beneficiaries. As also, kindly come to page paragraph 169. The excess recovery shall be refunded or adjusted as the case may be, with carrying cost to the command area consumers accordingly within the next 6 billing cycles. Now, my lord, this is an order, my lord. Your lordship will find an order of 15 September 2025. Now, kindly come to the next, my lord, page 236.
Yes.
Paragraph 178. In view of the above, we set aside the recovery of the cost of units utilized in own premises, including construction power, as a pass-through in the consumer tariff and direct WBSC to ensure that such cost is not borne by the consumers. Then, my lord, kindly omit a few pages and kindly come to page 242. Kindly come to, my lord, paragraph 200. (184).
240.
Sorry, kindly give me a minute's time, my lord. Yes, my lord, kindly once come back to page 238. Paragraph 184.
Yes.
Accordingly, we hold that both the State Commission and DVC have earned in loading the entire T&D cost exclusively on command area consumers without due allocation and in recovering cost for units utilized in DVC's own premises through consumer tariffs. The matter deserves to be rectified in ongoing and future tariff proceedings with strict adherence to the regulatory principle and equitable cost allocation to uphold the interest of consumers and the integrity of the tariff regime. Then, my lord, kindly come to 242.
Yes.
Paragraph 200, my lord. In view of the above, we hold that the appellant is entitled to carrying cost at simple interest equivalent to such and such plus 250 basic points on revenue surpluses determined to be refundable but to them as a result of true up or APR exercise for the period such and such to such and such. The carrying cost shall be calculated from the date of excess recovery, that is the date when the surplus was collected or became due to the consumers, till the date of actual refund or adjustment. For the foregoing reasons, the ordering portion. For the foregoing reasons as stated above, we are of the considered view that the captioned appeal in the batch have merit and are allowed. Accordingly, we set aside the impugned order, remanding the matter to the State Commission for passing consequential order, strictly in conformity with the finding and directions made herein above. Need not add that the matter is pending for very long. The Commission is directed to pass fresh order within 3 months from the date of this judgment. We further direct the State Commission to ensure that the consequential financial impact arising under the remand shall be passed on to each affected consumer of the command area within West Bengal or DVC from whom excess tariff has been recovered through 6 equal installments, either by adjustment in future bills or through refund in case the consumer is not drawing power from DVC. Now, this is the order of appeal, my lord, passed on 15th of September 2025.
Yes.
Now, on the basis of this, my lord, I make a representation. With them, my lord, kindly come to page 243.
Who are you?
I am one of the consumers, my lord, who has to deposit, my lord, the further sum of rupees 16 lakhs, which I have shown. Now, kindly come to page 243.
Yes.
Now, this is the representation I made on 9th of October 2025. With reference to order number such and such, passed by the Honorable Appellate Tribunal Aptel on 15 September 2025, we would like to bring the following to your attention. As per the said order, the entire tariff for the period such and such was challenged and the Honorable Tribunal has directed WBRC and DVC to revise the tariff and issue revised bills within 3 months. Furthermore, the Tribunal has instructed that any excess amount deposited by the consumer towards electricity bill during the above period must be refunded or adjusted in future bills. In the light of the above, we kindly request your office to withhold the following checks issued by us, my lord, that is 27 September. This has been encashed.
Already encashed?
Yes, first one.
First one?
Yes.
20 September.
No, the payment has been made, yes.
That's why that has been.
Payment has been made.
Second one is not in cash.
Second one is, my lord,
It was encashed yesterday. It's for encashment yesterday.
it was
Before yesterday.
after, my lord, service possibly, my lord. It was placed for, my lord,
Presented.
presented.
Filing of the reputation and after filing of this representation.
Now, next, my lord, as the matter is currently under consideration in the court, we believe it would be prudent to pause further payment until revised bills are issued and the refundable amount is determined. Please also note that we have already cleared approximately 85% of the area dues for the period such and such. Given our current financial position, we are unable to make any further payment, etc. Then, my lord, we would
Refund of
request
26 lakhs.
that's, my lord, further, my lord, it's not here, not there. Today, I am not, my lord, on that. Now, my lord, this was, my lord, the representation made on 9th of October, my lord. I don't think that, my lord, there was any response to this. There was any response to this, my lord. What I receive is, my lord, a disconnection notice, my lord, which is at page 310, volume 3. Despite our prior reminder, the third installment of such and such towards liquidation of area tariff remains
Whether
unpaid.
the appeal order is under file, any SLP is filed?
Yes, DVC has.
SLP filed?
Yes.
And any interim order is there?
Not yet.
Not
Yet to be heard.
2 months have passed. Despite our prior reminder, such and such, accordingly, second paragraph, this notice is hereby served vis-a-vis for payment of rupees 16,47,000 in terms of section such and such within 15 clear days. That is by such and such. That is by 12th November 2025 from the date of issuance of this notice. Please be informed that post-dated check number such and such drawn on central bank amounting to such and such will be presented for liquidation as per the installment scheme. You are requested to ensure sufficient fund in your bank account to facilitate smooth clearance of the said check. In the event of dishonor and if payment is not received by 12th November, your electricity supply shall be disconnected. Now, my lord, I make another representation, my lord, page 311. Now, my lord, I say that as per my calculation, my lord, I am entitled to, as per the appeal order, I am entitled to a refund of 2 crore 32 lakhs.
2 crore? 2 crore?
2 crore 32 lakhs. I say that, my lord, in my mail of 7th November, my instruction is no response to this also.
Yes.
Techie. Oh. Now, my lord, after the writ petition was affirmed, my lord, on 10th of November, my lord, my client receives another notice, my lord. Copy though. May I, my lord?
Show the copy. Give the copy to the other side.
I'll.
It's a disconnection notice.
No, please kindly come to the second paragraph. Please be informed that post-dated check drawn on such and such, amounting to rupees such and such, was presented.
Dishonored, that's why. Dishonored and dishonored, so that's why.
I was given time till 12th. It was presented on, my lord, 10th. After the service of the writ petition, or my lord, getting the notice of the writ petition, this was done, and it was dishonored.
Yes.
Now today, today, my lord, the short question is, my lord, I am regularly paying, my lord, the current dues.
What is a prayer in the main writ petition?
Yes. My lord, kindly come to, my lord, page 34.
He put it for encashment before service of the resolution.
Acha. Okay.
Yes.
Kindly come to prayer D, my lord. This is the main prayer basically, and my lord prayer H.
Yes.
I'm sorry, my lord. I made my lord it was presented for encashment before the writ was served on 10th. Now, today, my lord, what I have said is two things, my lord. According to me, my lord, I have a claim of about 2 crore 32 lakhs on the basis of the Aptel order. They have not denied that. They have challenged. They say they have challenged it, pending before Supreme Court. Very well. Now, apart from that, my lord, they don't say that I have, my lord, liable to pay any further amount. They have a security of, my lord, with them, security deposit of 1 crore 15 lakhs. Now, my lord, I am regularly paying the current monthly bills. There is no default there. Now, my lord, I can also ensure, give an undertaking that, my lord, I shall ensure that current monthly bills would be paid as per the bills to be raised by them. Today, my lord, what I am saying is, my lord, kindly, my lord, stay, because if the Aptel order is, my lord, there, my lord, I get a refund, and not a refund of 16 lakhs of rupees, much more. Now, let them not disconnect, my lord, let them allow, my lord, my client to survive. That is, they have sufficient funds, security deposit of 1 crore 15 lakh. They would say security deposit is for, my lord, the current bills. I will ensure, my lord, lordship can record an undertaking that my client will ensure, I have taken instruction that they will not make any default in payment of, my lord, the current monthly bills. Okay. And, my lord, lordship will let them, if they want to file any affidavit, my lord, let them come up with the affidavit, let them say whatever they have to say.
Yes.
Out of 64 lakhs, my lord, I have paid 48 lakhs. And
16 lakhs. 16 or
16 is due.
Lord, I will not pray for, my lord, affidavits, because I would pray for dismissal of the writ today itself. Because I would show, my lord, this writ petitioner is not entitled to any relief from the court.
Why?
And, my lord, first of all, my lord, the order which Mr. Mitro is relying upon, the Aptel order, in terms whereof Mr. Mitro's contention is that his client is entitled to refund. My lord, that order, Aptel order, is in respect of tariff period 2009 to 2014. There is an adjudication that consumers would be entitled to refund. Who are those consumers? Consumers who are part of the appellant association who was there before the, my lord, Aptel. In the writ petition, there is not a single averment that this petitioner was also a consumer forming part of that association. One. Two, my lord, the Aptel order also clarifies, and I'll show it, my lord. Aptel order also clarifies that based on this direction for refund, WBERC is going to determine, a mechanism has been framed by which WBRC is going to determine what is the refund amount for each of the consumers who are part of that association. Once that determination is done, and, my lord, I am informed, DVC license is informed, there is a question of, my lord, making payment. In the meantime, if I succeed in my challenge or in my prayer for interim relief before the Supreme Court, there is a stay. So this contention, the last submission of Mr. Mitro, that 2.39 crores is, my lord, odd is due to his client, I am disputing that. I am also disputing this, that his client is not a regular defaulter. Even last month, I just now took instruction from DVC. Even last month, he was a, my lord, defaulter. The language used in the WhatsApp communication is a seasoned defaulter. Now, my lord, on suppression, my lord, what has not been, my lord, disclosed in the writ petition is an affidavit of undertaking which has been filed by this petitioner pursuant to, my lord, after, my lord, withdrawal of a prior writ petition. My lord, let me, my lord, show, my lord, only two documents which is not there on record. What had happened was, my lord, there is an Aptel order of 11th of August 2025. This Aptel order pertains to tariff period 2018 to 2020. So 18-20 is the concerned period. Disconnection notice is also for 18-20. Aptel, by this order, has determined, or, my lord, made an arrangement, interim arrangement, for the consumers to survive. What was the arrangement? 50% you have to pay cash immediately, 50% by way of bank guarantee. This was the APTEL order. My lord kindly takes note of the APTEL order, which is 11th of August 2025. My lord, this order is dated 11th August 2025. I am troubling your lordship for the time being only with the conclusion. Kindly comes to page 39 of 39. At the foot of the page, lordship will find the page numbers.
Yes. Page?
My lord, 39. The conclusion. According to us, according to DVC, my lord, he was liable to pay full amount because he was not a member. Yet, my lord, we had given this benefit. So I will not, my lord. Conclusion: for the aforesaid reasons, interim order passed by this tribunal on 29 July 2022 is modified. There shall be stay of arrears insofar as appellants herein are concerned, on condition that they pay 50% of the arrear as determined in terms of the impugned order of WBERC and furnish a bank guarantee for the remaining 50% within 3 months from today. They shall also continue to pay the current dues in terms of the order impugned in this appeal. Needless to state that failure to comply with the aforesaid order would result in automatic vacation of the interim order now passed by us, and it would be open to the second respondent DVC to recover the entire arrears from such defaulting appellants. So this is the order that was prevailing from the appellant. My lord, we issue them the disconnection notice, which is at page 161.
This order is passed in which proceedings?
My lord, this order of APTEL is in connection with, my lord, the challenge before the APTEL was to the tariff determination for the period 1820. There, APTEL, this is an interim arrangement because pending the decision final adjudication on the appeal, APTEL provided an interim measure of protection to the consumers for them to survive.
Yes.
This was, my lord, the arrangement was 50% cash, 50% BG. Now, my lord, we issue them a disconnection notice because he was not, my lord, a part of the, my lord, association. Lordship kindly comes to page 161. We refer to this APTEL order. It should be in volume 2, my lord. Mr. Mitro just now possibly 161, yes. Please note, my lord, this is from DVC to the, my lord, petitioner. Please note that the Honorable Appellate Tribunal for Electricity APTEL has modified the interim order of 29 July 2022 by its order dated 11th August 25. In view of the above mentioned order dated 11th August 25, please note the following. Principal arrear amount in respect of the tariff order issued by WBRC on 17 June 2022 is 65,88,031. And next is DPS, delayed payment surcharge, will be applicable as per regulation. Accordingly, you are requested to pay the outstanding principal arrear amount as on 17 June, rupees so-and-so within 15 clear days, that is by so-and-so, from the date of issuance of this notice in terms of 56(1) of the Electricity Act and clause 4.1.1 of the regulations 2013. Then, my lord, 162, failure to comply with the above direction may result in DVC taking appropriate action as deemed fit, including disconnection of power supply. Now, my lord, they challenged this, my lord, disconnection notice in a writ petition. My lord, this is the writ petition, and these are the prayers, my lord, of the writ petition. Kindly takes prayer D, my lord, of the, my lord, writ petition. An order staying, lordship sees prayer D.
Yes.
An order staying the operation of the order dated 6 September 2017, being annexure so-and-so, and the subsequent retail tariff order dated 17 June 2020.
Which page?
My lord, this should be page 36.
Yes, an order staying the operation of the order dated 6 September 2017.
My lord is, I'll place the order. Read in the nature of mandamus, lordship has prayer D.
36, yes.
Yes, 34.
Okay, 30, yes.
A writ in the nature of mandamus commanding the respondent to immediately or forthwith set aside, cancel, revoke the disconnection notice of 12th August 25. This is the notice which is at page, my lord, 161 of the present writ petition.
Notice dated
12th August 2025. I have a full copy of the writ petition. That notice was annexed. I am carrying that also.
This is a notice dated 20.
Yes, Lordship will see the date, my lord. At the, my lord,
That is the 22nd, 20th August.
না 161 এ 12th August কোথায় আছে? My lord, in the middle of that page where, my lord, the names of the, my lord, recipients are mentioned, Lordship will find in bold sent Tuesday 12th August 2025. At page 161, my lord, I am referring to. Since it's an email communication, the date is in between of that.
Correct, 12th August.
Lordship has got that, my lord, date 12th August. So this 12th August notice was the subject matter of challenge in the prior writ petition.
No, but date in the nature of mandamus C, prayer C which you are referring to.
Prayer D I am referring to.
C, first you come to the C.
Yes.
Pass and subsequently tariff of it. D, what is the D?
D is, my lord, challenging the disconnection notice of 12th August 2015. So this was the subject matter of challenge in the prior writ petition.
Yes.
Now, my lord, order passed in this writ petition. My lord, at 172, kindly comes to page 172, volume 2.
Yes.
This petitioner was represented by someone else as paid for by advocate for the petitioners seeking withdrawal of the petition. Let writ petition be dismissed as not pressed.
Yes.
Not even a liberty, my lord, reserved to challenge this notice or, my lord, the other notices which are really follow-up of this notice.
Yes.
My lord, after this order, we receive a letter from the petitioner. Subject to being corrected, this letter is also not disclosed. My lord. This is a 20, my lord, the dismissal happened on 27th August. The dismissed as withdrawn or not pressed. 27th August, we received this letter from the petitioner. Request for outstanding demanding payment of so-and-so in installment. We are writing to you regarding the outstanding demand of so-and-so of order dated 11th August, appeal number so-and-so. We would like to propose an installment payment plan in 4 equal monthly installment within 4 months, detail mentioned below. So they also don't understand that the protection given to the DVPCA association by APTEL, 50% cash, 50% guarantee, they are entitled to that. On the contrary, they say their outstanding of 65 lakhs or not, they would pay in 4 installments. Correct. Now, the 4 installments they propose. Now, after this, they file an affidavit also. Well, this affidavit is also not disclosed in the writ petition. This is 3rd September, that is August. This is 3rd September 2025. Kindly takes, my lord, this is a very short affidavit, my lord. I will, my lord, place the clauses. We have received notice dated 12th August 2025. My lord, sees the date of the notice, same disconnection notice, requiring payment towards outstanding principal arrear amount in respect of the tariff order issued by WBRC on so-and-so within 15 days. The said notice clearly mentions, in case of non-compliance within the stipulated period, supply of electricity shall be liable for disconnection without further notice. We undertake to pay the outstanding amount in full in 3 monthly installments as scheduled below. First installment, 50% of outstanding area due on 30th August already stands remitted as on the date of signing. Second installment, 25% of outstanding due on 27th September. Third installment for 25% due on 27th October. This is their affidavit.
Yes.
Then 5, we unequivocally accept and undertake that post-dated checks will be submitted against the installment amount as per scheduled date. In the event of default in payment, DVC shall be fully empowered to invoke the same without any further notice. We unequivocally accept and acknowledge that in the event of default in payment of even a single installment by the respective due date, DVC shall be fully empowered to disconnect electricity supply without any further notice as per the said notice and applicable law. This undertaking is furnished voluntarily to comply with the regular provisions. Now, after this, my lord, the first installment was paid. My lord, there is an email of 27th August, 28th August 2025, my lord, which we had, my lord, issued in favor of this petitioner, proposing, my lord, the manner in which they would pay.
Yes.
My lord sees this email is dated 28th August. We acknowledge receipt of your communication and this is, my lord, preceding the affidavit, because affidavit is 3rd September. This is, my lord, 28th of August. We are saying DVC, my lord, third line. DVC is pleased to inform you that your request has been reviewed. Copy though. Your request has been reviewed and you are hereby granted the facility to pay the due principal arrear amount of 50 lakhs so and so, after considering payment of 15 lakh which you have paid on 27th August towards arrear dues in 3 installments. So out of that 4 tranches, my lord, 15 lakhs received. So, my lord, 3 installments further, my lord, we indicate. First installment date is 30th of August, then 27th of September, then 27th of October. Now, after this, my lord, we received that, my lord, affidavit. The second installment.
So in terms of this, the affidavit was filed.
In terms of this, the affidavit was filed. Now, my lord, the second installment, which was the due date was 27th of September 2025. This was, my lord, dishonored. এটা dishonored and October dishonored. এটা sure. Third money. My lord, gives me one moment. My lord, I think I am making a mistake.
No, this October payment is due.
Yes.
September is clear.
September was defaulted initially. Thereafter, my lord, they have paid on 14th of October by way of a bank transfer. So they violated their own affidavit. My lord, their bank statement is also disclosed, my lord. We have received this. Kindly takes note of the entry, my lord. Relevant entry at page 176. This is their bank statement they have disclosed. My lord, at 176, from the foot of that page, lordship takes note of the 7th entry. 14th October 2025. To transfer RTGS Damodar Valley Corporation 16,47,008. Lordship has found that?
Yes.
This is, my lord, the payment, the second installment amount in terms of this email which we had given them time till 27th September. They pay on 14th of October.
Yes.
Now the third installment was due on 27th of October 2025. Now in the meantime, this 15th September order of APTEL has come. This 15th September order, based on which this petition is being presented, is in connection with, like I said, the tariff period 2009 to 2014. It has got no connection with 18 to 20.
How you can say?
Yes, my lord.
2009 to 2014. The order speaks so.
My lord, that is, there is a subsequent order of the APTEL which has clarified this. My lord, permits me to place another order, because this is your lordship's query, that how can you show that it was for tariff period 2009 to 2014. ওখানেও লেখা আছে একটা জায়গায়, ওটাও বার করো। My lord, there is a subsequent order of APTEL 7th November 2025 permits me to place this order also, which, my lord, takes note of that 15th September order. My lord, kindly comes to page 6 of this order.
So this is another case.
Yes, in respect of another tariff period,
Correct.
where this, my lord, similar stances were, this is for 1820 only, where, my lord, this stand was taken and, my lord, this clarification was issued that this was for tariff period 2009 to 2014 and there is no connection. Because people wanted, what is the consumer stand? Consumer is saying, look here, I am entitled to a refund in terms of a 15 September APTEL order. So don't ask me to now pay. Give me a set-off or allow DVC to adjust.
Correct.
My lord, internal page 6 of this order, which I just now placed, 7th of November, kindly takes, my lord, that order first. And then I will show from this order also, the one which has been disclosed, it is page 6. My lord, from the top, my lord, the first para, starting the relief sought for.
the relief sought for in the IA seeks to link compliance with the order passed by this tribunal dated 11th August 25 with the order by which the commission is required to pass consequent on remand as directed by the tribunal in the subsequent judgment of 15 September 2025. Or in the alternative, for compliance with the directions issued by this tribunal on 11th August 2025 to be made subject to the outcome of the order to be passed by WBRC consequent on remand. Why this paragraph, my lord? Because APTEL said on 15 September that WBRC, it is remanded to WBRC, they will determine, then they will indicate what is the refund amount. So, my lord, IA was filed saying that link this together and so that the adjustment can be claimed by consumers. We are of the view that neither of the aforementioned courses can be followed for more than one reason. Firstly, the order of the tribunal dated 11th August 25 is in terms of the earlier order passed by the tribunal dated 17 January 25 and the order of the Supreme Court dated 14th February 25. The said order dated 11th August 25 has admittedly not been subject to challenge by the appellant by way of an appeal to the Supreme Court. Consequently, the order dated 11th August 25 would continue to remain in force till the appeal is finally heard and decided. Secondly, the order dated 11th August 25 was itself passed in exercise of powers conferred under the second proviso of Order 39. I'm skipping this part. Now, my lord, kindly turns the page 7. After the first 3 lines, yet another reason why compliance with the order of the tribunal dated 11th August cannot be linked to the order to be passed by the commission consequent on remand order passed by the tribunal on 15 September is that the second respondent has the remedy of preferring an appeal against the order passed by this tribunal on 15 September 25, which remedy Sri so-and-so counsel appearing on their behalf states has been availed by the second respondent by filing a civil appeal before the Supreme Court. I was the second respondent, DVC. Even otherwise, the earlier order passed by the tribunal dated 11th August 25 relates to FY 1819 and FY 1920, whereas the order of the tribunal of 15 September relates to FY 2009-10 to FY 13-14. So, my lord, these two cannot be linked. This contention by the, my lord, DVPCA, the association, this contention was there before the APTEL, also rejected by the 7th November order. So, my lord, relying upon that order today, you cannot say, I am entitled to a refund, so please link it with my disconnection notice and say that DVC should adjust. My lord, 2 more, my lord, facts and I complete if lordship permits me, my lord.
Yes.
I'm sorry, my lord, my lord, after this, my lord, the third installment, which was due on 27.
Fine. You have made the judge hungry.
Then, my lord, I shall.
Continue.
My lord, I know, my lord.
No, continue. How much time will take?
5 more minutes, my lord. 5 more minutes. My lord, page 243, my lord, kindly comes to volume 2, page 243. Yes. I am very grateful, lordship accommodated us as at 12:30, my lord, because I was stuck, my lord, at 2. I was addressing in a division bench, my lord.
Yes, next.
My lord, 243, my lord. This is the document issued by the petitioner addressed to DVC.
Correct.
Dear sir, with reference to order dated so-and-so and batch passed by the appellate tribunal for APTEL, we would like to bring the following to your attention. As per the order, entire tariff for the period 9 to 25 was challenged, and Honorable Tribunal has directed WBRC and DVC to revise the tariff. My lord, this statement is incorrect. It is not 9 to 25.
Why you not given reply to this? The claim which you are asking, that is not in connection with the this financial year of 19-20-24.
The representation. My lord, there could have been a reply to the representation, my lord, but if Mr. Mitro agrees to put in this money, which is due, I have taken instructions that I will not, my lord, I have to disconnect tomorrow because by end of day today, they have time to make this payment. I showed, my lord, their, my lord, first challenge to the disconnection notice. I showed their affidavit and, my lord, their, my lord, dishonor so far as the second installment is concerned.
The 16 lakh.
It is only with regard to that part, the last installment part, which is due.
1647.
Yes, with, my lord, it will accrue some interest, my lord, because it was payable on 27th of October. Today we are on 12th of November. My lord, if they agree to make this payment together with the current dues, my lord, we will not disconnect tomorrow. That is my clear instruction. But otherwise, my lord, I would try and persuade your lordship not to, my lord, pass any interim protection in favor of this consumer, because then, my lord, lordship would open floodgates for all consumers to come here, taking, my lord, refuge under that order, that 15 September order, which is now clarified by 7th November APTEL that you can't link both. My lord, that event has not occurred. WBRC has not determined what is the amount that is due. So, my lord, they are not entitled to, my lord, any interim protection. I was carrying, my lord, 2 judgments, my lord, on the issue of suppression and not coming with clean hands, my lord, just for the sake of.
Can your client deposit the amount? Let the affidavit file. It will be decided on merit.
Without prejudice, let them deposit. And I had given a reminder on 28th October, immediately after 27th October.
2:30, you take instruction.
Can it be at 3 in that event?
Yes, my lord, 3, my lord. Very.
I'll tell your lordship, my lord, the
matter nahi hai. 3 fix hai kuch. I will take 3. Come at 3, take instruction. If you plan, then I'll pass
Judgment
order.
clear.
This is subject to outcome of this court. Outcome of the writ application. Take instruction.
My lord, 2 judgments I am just handing up. My lord, I'll give a copy.
Let first Mr. Mitra come with the
Yes, my
instruction.
lord, if he agrees to, my lord, deposit the money or, my lord, pay this money, then, my lord.
Come, otherwise, then I have to decide. My lord, 3 baje rakho.
Sorry to keep your lordship hungry.
Thank you.
Yes.
Maybe, but I am appearing for the petition. My affidavit of service. My lord, the petitioner before your lordship, there are two petitioners before your lordship.
Who is for the respondent? No, I am for the statement.
My lord, I'm telling your lordship, my lord, the short issue, my lord. The petitioners before your lordship, my lord, they are operating a partnership firm by the name of Hynix Logistics. Now, my lord, the respondent number 6, my lord, who is the private respondent, he was inducted as another partner. Right, my lord? Thereafter that, my lord, the partnership composition was changed, where 75% rested with the petitioners and 25% was given to the respondent number 6. Now, thereafter, my lord, the respondent number 6 wanted an absurd amount, my lord. I'm not quoting before your lordship because it's a factual aspect, an absurd amount for going out of the partnership firm and demanded that money. Due to which, my lord, there was a difference of opinion between the partners and the private respondent number 6. Now, my lord, subsequent to that, my lord, the private respondent number 6, what he does, my lord, he initially initiates an application under section 9 of the Arbitration and Conciliation Act, my lord, praying for freezing of the 2 bank accounts of the partnership firm. Now, as per the partnership agreement, both the petitioners are allowed to operate the partnership of the bank accounts. He was not allowed to operate. But, my lord, he thereafter preferred a petition for freezing of those 2 bank accounts. Now, your lordship may kindly have the first annexure, my lord, which I would like to rely upon. Your lordship may kindly takes up page number, my lord, 53. My lord, before that, if your lordship may kindly have page number 55, his own application. But these are all matters of record. I will not say anything outside the record, my lord.
Yes.
Page 55, my lord, is his own application.
Yes.
Lordship may kindly sees what is the application praying for. The prayer portion is at page number 59. Hence, it is prayed that the learned court would be pleased to grant interim protection, thereby granting an order of injunction against the opposite parties, restraining them from withdrawing any amount from the account numbers 105605003811 and 27055000157 lying in the Bidhannagar Salt Lake branch ICICI in the name of so and so. My lord, both these 2 bank accounts, Lordship can takes note of. Now, my lord, what are the orders passed? Lordship may kindly have page number 53.
63, 53.
53, my lord. Yes. My lord, has it, my lord? My lord, page, lordship kindly sees first application, my lord, was filed, date was fixed. 4th of September 2025. My lord, I seen that order, page number 53.
Yes.
2nd of May, he files the application. No interim order was granted. Second order, 4th of September 2025. Today is fixed for service return. Petitioner takes no steps and found absent on call. It appears from the record that the petitioner is not at all interested in proceeding with the instant case. It is already 3:45 p.m. No further time can be given to 26/11/25 for show cause by the petitioner as to why the case shall not be dismissed for non-compliance with the court's order. Nothing done. Now, my lord, what he does instead, my lord, seeing that he will not be able to get a favorable order, my lord, he purportedly writes to the banks with regard to freezing of these 2 bank accounts. What he could not do directly by the court, he does it indirectly. We come to learn when these 2 bank accounts, which are mentioned there, were frozen. My lord, may kindly have thereafter, my lord, my legal notice. My lord, as page number 62 onwards. We write to the bank, my lord, my lord, I will not take much of your lordship time, my lord, page number 62.
Yes.
Your lordship kindly sees, my lord, the order was passed prior to that. Now, on 15th of September 2025, the ICICI Bank writes to us that this is to inform you that we have marked debit freeze of your account number so-and-so on the basis of complaint of fraud received by the third partner Dinesh Sagar Gupta on 12th September 2025. My lord marks that date. It is post the order which was passed, asking him to show cause. But similarly, my Axis Bank account, that is the other bank account, was also frozen, though they did not give any intimation to that. My lord, we sent 2 legal notices.
My lord, may kindly have page number 64. And thereafter that, page number 66.
Yes.
My lord, insofar as it will be, my lord, I have to be, my lord, very clear, my lord, before your lordship. Insofar as, my lord, the ICICI Bank is concerned, my lord, that has been defreezed by them on the basis of our representation made. In respect of the other bank account number, which is there with the Axis Bank, that has till date been frozen. My lord, it is aggrieved by this, my lord, we have approached your lordship. My lord, for defreezing of this bank account.
Whether notice is served.
My lord, we have served, my lord.
Axis Bank.
All delivered, my lord. My learned advocate on record, my lord, is
Yes.
more deeply.
My lord, I am for the state, my lord, no allegation against us, my lord. The allegations made in the petition, my lord, can be basically applied by the private respondent, the bank, and it appears, my lord, that there is a dispute, my lord, which has been already arbitration matter was pending, and thereafter, my lord, from the record it shows, my lord. My lord, we can base answer.
Who generally appears for the Axis Bank?
And
You have
Axis
any
Bank,
idea?
my lord, is a private bank, my lord. How the
Correct.
reputation
My lord,
is
I am very handicapped. My lord. Anyways, this is a my lord, new stream for me. My lord, that is why I am unaware, my lord, as to who appears.
So, my lord, I have received one instruction from the police, my lord, but it does not reveal anything.
My lord, that means there is no case which is registered against me, pursuant to which the bank could have, my lord, done anything.
You lost me, my lord. Please, my lord, I can.
वो तो यहाँ पे नहीं है ना, वो तो अपना कंप्लेंट है.
Yes. What can be done?
And
My lord, I am, my lord, what,
Axis
my lord, what,
Bank, my lord, is a private bank, my lord. I don't understand.
I understand, my lord, what is foreign.
The petition is mentioned. Those
Not
are-
maintainable.
My lord, those are my.
Not maintainable.
My lord, how it is maintainable,
Yes.
my lord, it is
My
the
lord,
private
I don't, my lord, my lord, now, my lord, with regard to this aspect, my lord, is that first and foremost, my lord, whatever I have submitted is from the records. My lord, I have shown to your lordship what he could not do directly, he did it indirectly. My lord, in these circumstances, when he could not get a favorable order from the learned court, my lord, what was the need, my lord, to do this? Secondly, my lord, the bank could have issued me a show cause or could have asked for a clarification. We could have done that. My lord, if your lordship so desires, we can, my lord, intimate.
Passing an order directing the Axis Bank to submit the report. I am fixing next Monday.
Deeply.
And you serve the copy to the
I will do
Axis
that,
Bank. If they will come with the report, if it is,
Very well.
they will not come, then not.
Very well, my lord. My lord, may kindly fixes that time, my lord. I could only beseech that. Your lordship was pleased to grant leave in this matter.
The petitioner is aggrieved with the action of the Axis Bank on the ground that on the complaint of one of the partner of the petitioner partnership company, the Axis Bank has freezed the account of the partnership company. And when the petitioner has made a request to the Axis Bank, the Axis Bank has not defreezed the said account. According, the petitioner has filed the presented affidavit. The petitioner has filed affidavit of service showing the service of notice upon the respondents, except the state respondent, none appears on behalf of the respondents. This court is of the view before passing any further order, a report is required to be filed by the Axis Bank. Salt Lake branch, Axis Bank?
Yes, my lord. I'll just, my lord, verify it for your lordship.
Axis Bank.
My lord, this is C.N. Roy Road branch.
Having the office at Axis Bank Limited, having the office at C.N. Roy Road branch. Axis Bank Limited, C.N. Roy branch at ground floor, 28/5, C.N. Roy Road, Tiljala, near 42A bus stand, Kolkata, West Bengal, 39. The Axis Bank is directed to submit the report with regard to freezing, submit a detail the bank has freezed the set and why the bank has not considered the representation submitted by the petitioner for defreezing the bank account. Let the report be filed by 18th of November 2025. Let the matter appear on 18th. 18th is any date, time is?
But could it be on 19th, my lord, subject to your lordship's leave?
19th 2 PM देखो खाली है.
And state is represented.
Very good.
Hon'ble.
Give your name. 19 2 PM. Any matter is fixed? No. 19th November at 2 PM. It is made clear that on the petition is directed to communicate this order to the Axis Bank for compliance. It is made clear that on the date fixed, if the Axis Bank failed to file the report and to appear before this court, and failed to file the report, appropriate order. Under the heading, yeah, urgent motion, a new motion. Under the heading, urgent motion. Yes, next.
Well, item number 8, I'm appearing on behalf of the petitioner lordship. This is my evidence. Status.
For the
Petition.
what is the grievance?
My lord, my grievance is that my mother is the original license owner of a liquor shop, and thereafter, all on a sudden, my mother transferred the license to my younger sister, in spite of depriving me and my brother. And I have made representation before the district magistrate and all the competent authorities. They have never adhered my representation, and they transferred the transferred the license to my younger sister. So I am appearing before your lordship.
What right you are having? A mother choice, mother
Yes,
transfer.
yes, I know. Only consideration of representation. Lordship. I have to be very candid before your lordship. The only consideration, later formal order be passed by the competent authority.
So what you will do? How the writ petition you maintain here?
I know that
You know,
petition is
then you file that.
but this is
Instead of
not
that,
my brief. This is not my brief. Upon instruction of my colleague, I am before your lordship.
the mother's bar license, mother has transferred in the name of her another. Who are you? You are one of the daughter.
One of the daughter, elder daughter.
You are the elder daughter, and transferred in the name of younger daughter.
Yes.
How many daughters are there?
2 daughters, 1 brother.
One brother. What the brother say?
Brother is not at all interested. Brother is not at all interested. But when the license is handed over to transferred the younger sister, that brother raised objection.
So you want to continue this? You withdraw.
Withdraw the writ petition.
No. We counsel for the petitioner. Press for withdrawal of the writ application.
Yes, yeah.
Accordingly, WPA 8397 of 2023 dismissed as withdrawn.
Okay.
Next.
Your Lordship, in 9 and 10, Your Lordship, may I have the leave to appear virtually, Your Lordship?
Yes.
Your Lordship, I'm appearing for the state, Your Lordship.
Okay.
No, my lord, I am just bringing the facts very shortly. Now, my lord, as per the tender floated, my tender was accepted
I completed the job. Bill has been submitted. Some of the money has been given, but
Yes, absolutely.
now, my lord, kindly, I am just placing, my lord, 2-3 orders. Your lordship,
You are-
kindly to.
My lord, may I indicate one thing, my lord? So far, more than 100 matters, my lord.
My lord,
we have
every
disbursed the
occasion,
payment.
my
No,
lord,
no, my
this
lord, no,
point is
kindly
taken.
appreciate.
Every
My lord,
occasion,
whole,
lordship.
no,
Let
my
me.
lord,
This is
whole,
my
no, my lord,
petition, my
may
lord. Let
I-
me place, my lord.
Let me, that's a second. My lord, more than 100 matters, my lord, we have disbursed money. It is not that we have not disbursed anything. I am seeking some more time because it has been calculated and routed through various process. So that's why, my lord, it is not a case, my lord, that we will not pay him, my lord.
Yes, you tell me how much time you required. I dispose of this in by that time you dispose of 4
My
weeks,
lord,
6
my
weeks,
lord,
8 weeks.
give me 5 weeks time. 5 weeks. In the
Now, my
meantime,
lord,
my lord.
I think, my lord, this is my writ application. He has overstepped
My lord,
this.
if- my
Lordship,
lord, if
kindly,
not, my lord-
let him finish. Let him finish. Lordship, kindly have a look. Order dated 9th of July 2025.
Where is page number?
My lord, this is on the file, my lord.
Order
Yes,
date
order.
of this court.
Yes.
9th July, yes.
My lord, got it.
Yes.
It has been brought to the notice of the court that the finance department has already secured fund from which the dues of the petitioner may be paid. 7 days time has been sought for.
Correct.
Now, my lord, kindly have a look. 8th of August 2025. All the time they have taken on this ground.
Correct.
I am just placing, my lord, the relevant portion. My lord, the 8th August 2020, my lord, got it.
Yes.
Learned counsel representing the state submits that papers and documents in respect of the instant case have been traced out recently and steps are being taken to clear the dues of the petitioner at the earliest. 8 weeks time have been sought for. In view of such submission, release the matter on such and such.
Today I am disposing of giving 4
My lord,
weeks,
kindly, my lord.
giving 4 weeks time. If
Lordship.
time, then you have a.
My lord, kindly do not.
Yes, my lord.
My lord, I am with folded hands, my lord, I am requesting, my lord, let it be. Again, my lord, this.
Disposal, if this court will dispose of, then you will have good.
I know
to get
for
the
contempt.
Lordship.
For contempt.
Lordship.
Now, my lord,
Yes.
they will come again, my lord. Let for the my lord, for
My
the
lord,
sake.
you
My
got
lord.
orders from this court, but they
Yes.
are not complied with.
Yes.
Correct. Now let the mandatory order be passed for
Lordship.
No, not consideration, my lord. Let them pay it within 4 weeks.
Correct. If you are entitled, they will pay.
Yes,
My lord,
that has
I'm
been
grateful.
admitted. That has
I am
been
grateful.
admitted here.
The court, yes. Where is your work order?
My lord.
Where is your work order?
My lord, work order is. My lord. My lord, page 13.
Request
Superintendent of Police.
accommodation to all facilities are provided. What is the work order?
This is the work order, my lord, for the temporary, my lord, the construction of the for the election purpose.
Achha. The petitioner, the grievance of the petitioner in the present date application that the authorities have issued the work order to the petitioner and the petitioner has executed the work assigned to the petitioner. Subsequently, the petitioner has submitted the bill and part payments have been made and part payment is due. Subsequently, the petitioner has made several representations to the authority, but till date, the authorities have not released the said amount. Learned counsel for the petitioner draw the attention of this court to the several orders passed by this court, wherein the authorities have taken time to take appropriate step for release of the payment due, but till date the payment has not been paid. This court find that learned counsel for the state appearing for the learned counsel for the state submit that the authorities have already taken steps and some time is given, the authority will verify the bill and will make the payment. In view of the submission made by the counsel for the respective parties, the writ petition being WPA number 3974 of 2024 is disposed of by directing who is the competent authority who will release the payment.
Your Lordship, Home Department. Your Lordship, just.
But work order has been issued by the superintendent.
No, superintendent will not disburse the money, my lord.
Superintendent will not issue.
Not disburse the money, my lord.
Secretary Home
Secretary Home, my lord. Secretary Home, my lord.
That says that it has been allotted
And
in the
respondent
order.
number 3, comma, the secretary within bracket, secretary, comma, home, police department, government of West Bengal is directed to consider the case of the petitioner, and if the case of the petitioner and the petitioner is entitled to get any dues, comma, the same may be released within a period of 4 weeks from the date of receipt of this order.
My lord.
They have filed, my lord, the supplementary affidavit with the record that says, my lord, how much I am entitled.
Correct. They will consider whatever.
Yes, my lord.
You
Yes,
blessed
my lord.
for all these things.
My lord, another payer, my lord, my lord, order dated 8th August 2025. Lordship, kindly record this.
I recorded several orders passed, but
Yes.
That's why disposing of the return, directing to consider
your lordship has directed to consider.
And if you are entitled to release the amount within
They have
4 weeks.
accepted I am entitled.
Let this
in the order itself, my lord, this is there, my lord. 8th August, my lord.
My lord, one line may be added, my lord. One line may be added after verification the bills. Because there are, my lord.
If he is entitled to. If he is
Yes,
entitled to.
My lord, lordship.
Alright. Doi.
9 and 10 both.
Similar issue, my lord. Grateful, lordship.
Grateful, lordship.
Grateful.
Deep here.
May it please your lordship, my lord.
Yes.
Lord, this is concerning a license to run, my lord, a sawmill. Lord, I'll just take your lordship to 2-3 documents of the brief, my lord.
Which was the states?
Mr. Tarok Koron, he was there on the last day, day before yesterday.
And appeared.
My lord. Now, my lord, this is, my lord, continuing for quite some time. My lord, will kindly have a look at, my lord, page 28 first.
28.
28.
Yes.
My lord, in 20, my lord, the pages are arranged in a haphazard manner. I might have to take your lordship again to 23, 24, kindly not. Lord, on 21st January 2011, Lord, kindly see, I am applying to the District Forest Officer Nodia, Lord, for Lord, saying that the district inform after a long battle, we got our factory. Now we would like to start afresh. As such, we shall be obliged if you please renew our license and accepting necessary fees. So in 2011, we applied for renewal of license. Lord, if my lord kindly comes to page 24, page 24. Not 24, 25. I'm sorry. But there were 2 issues, one for shifting, one for renewal. I'm just showing the renewal aspect now. Page 25 is the answer of page 28. Kindly find enclosed the above mentioned letter of from self-explanatory. The case in brief is that observation recommendation given below. Case history: the managing director of Calcutta Winner Industry has applied for issuing no objection certificate to the DFO Jalpaiguri division for accepting renewal fees and issuing no objection certificate to the DFO Jalpaiguri renewal fees with appropriate penalties, but the unit was closed since 1997 as per his own version, and the renewal of license was made up to that period only. The applicant mentioned in his letter that he used to apply for renewal of license in more or less every year, but there is no supporting document in favor of his settlement. I cannot deny also that no renewal of license for a long term closed unit can be considered by divisional level. Moreover, he has mentioned that they have already shifted the machine to Moyanaguri, Jalpaiguri. Observation and recommendation. In such background, the undersigned is not in a position to consider the matter of renewal of license for such a long period more than 13 years after the expiry of the validity period, and also for a closed unit since 1997 whose machineries are already shifted. So they cancelled the prayer for renewal because it was closed, not the renewal was after a long gap. But then in between, I made an application for shifting of my that your lordship will get at page 24. Can you take the earlier page? Kindly see the subject first, shifting from Kollani to Jalpaiguri, and see, my lord, at the bottom of the page, copy to DFO Jalpaiguri the request to issue fresh license. Now, I have shown your lordship the refusal to renew. Kindly have a look at refusal to shifting. Kindly take page 31A of your lordship's brief. I don't know whether your lordship's copy is readable. My copy is absolutely not. Sorry, 31A, my lord, kindly takes.
31A, yes.
Is it readable? Will kindly see the last paragraph. Since the license of your unit has lapsed long back for non-renewal, therefore no permission for shifting could be allowed. So I applied for renewal. They said long time gap will not allow renewal. I applied for shifting. They said since there is no renewal, we cannot allow shifting. That was the situation. What happens after this? Page 32A. My existing license, but these are all in 2012. So renewal was not given. Kindly see in 2016, serial number 3, Calcutta Vinyl Industry. The license at the top, my lord, kindly see license of the following wood-based industries of Nodia is hereby cancelled. Just above the box. Yes. Then serial number 3, Calcutta Vinyl, 13th December 2016. Calcutta Vinyl Industries Private Limited, 13th December 2016. They cancelled my license. So initially renewal refused, then shifting refused, cancellation. Then can you take?
If there is no renewal, how the cancellation will come?
That's my first point. If you did not renew in 2016, you could not have cancelled. It doesn't end here. Kindly take one page of this, page 34. This is in 9th December 2021. My lord has kindly got that.
Yes.
Kindly see what they are saying. Subject shifting, then what they are saying. Kindly note enclosed copy of the note sheet referred to with the enclosure. There was a note sheet, there was a meeting. I have been directed to request you to please initiate action for pending renewal of the unit as per agenda number 4 of the minutes of the SLC meeting held on 26 November 2011, forwarded to the authorized officer and that this memo number so. So, what was it? Kindly see, this was directed to shifting by Calcutta Vinyl Private Limited. So, for me, the chief conservator of forest was writing to the divisional conservator of forest that please take up the application for renewal. So in 2011, you said I can't renew long back. 16, you said cancel. 2021, you yourself took up the application for renewal. Lord, then Lord, page 36. A notice of hearing was given. So they took up the issue. Notice of hearing was given. 24th December, they can't say that there was no hearing, no deliberation. Then, my lord, an order comes. Page 37A. So, all earlier actions, Lord, they have given a go by taking up the issue. Kindly see 37A, 13 January 2022. Subject Calcutta Vinyl. Not kindly take not paragraph 3 onwards because earlier all the same facts. The authorized officer of Nodia, Murshidabad district and divisional forest officer Nodia Murshidabad division cancelled the license dated so 27 December 2016. In the above circumstances, the license of the said sawmill cannot be renewed from this end as per point number 4 of the minutes of the SLC meeting held at 26 November 2021, as the mill is currently not situated in this division and the license has given already been cancelled. However, the undersigned has no objection to him being given a secondary sawmill license to operate in Jalpaiguri. May be noted from this letter dated 9 December October 21 addressed to Honorable MIC that he has applied for fresh license on 31st May 2012 with proper fees, and DFO Jalpaiguri has recommended the case to the member secretary so and again on 5th June 2017 matter is being sent for further action. So my lord, my application for renewal in Nodia was rejected, but they say that you may have another unit at Jalpaiguri. But this is not concerning Jalpaiguri. That is in the name of the proprietor of a proprietorship concern, of the director. The director has the proprietorship concern. Here the company is before your lordships. So this was the rejection. Lord, they have referred about Lord, the point number 4 of 4th SLC meeting. My lord, has got that?
Yes.
Lord, that is in the next page, but next page may not be very legible. My lord may take page 76. It's typed copy, beta copy of the same meeting.
Page
76.
76.
76. The beta copy is there, my lord. It was annexed earlier also, page 38. But kindly have a look at this.
Yes. Serial number 4.
It may be in volume 2, my lord, page 76. Minutes of the 4th meeting of the state level committee held on 26 November 2011. On this basis, this was rejected. My lord, kindly have a look at agenda number 2. Issuance of general category license to sawmill and wood-based industries. The present status is given below. Total number of general category sawmill as approved by SLC 2296. Number of general category sawmill as on 27 December 18. The first date of meeting 2142. Number of general category sawmill license given on 30th September 2255. Then see the last balance of number of license to be given 41. Then we will kindly come to clause number 4.3 at page 78. Or we will take from page clause number 4, page 77 last. Renewal of sawmill license. Let us kindly go to the last line. It was decided that. Then kindly take the next page. Considering the pandemic situation, all authorized officers may complete the process of pending renewal in their division where due date of annual renewal is so and so. All pending renewal applications which are submitted there within 3 months due date but could not be, 4.2.2 I'm reading, could not be processed due to various reasons would be considered. All pending renewal applications which were submitted within 6 months and due date but could not be processed due to various reasons would be sent to authorized officer. Then 4.3, I'm relying on this. For all other pending cases, I don't come under 4.1 and 4.2. The wood-based industries may be allowed to pay fine of rupees 10 per day for the entire defaulting period, in addition to the application fee and renewal fee for each defaulting year, along with one-time processing fee as per rules. So what you decided, for all defaulting wood-based, 10 rupee per year fine shall be imposed and it shall be granted. On the basis of this, now kindly come back to 37A, you reject my application. And what is the ground given? 37A, what is the ground given? Kindly see again, in the circumstances, license of the sawmill cannot be renewed from the end as per point number so and so. Point number 4, I have shown point number 4. Just above that, they are saying my license was earlier cancelled in 16. So 12, you said no renewal. 16, you said cancellation. 21, you took up the renewal on your own. So that means that by that letter, at page 34, which I have shown, the chief conservator of forest letter, the cancellation was automatically revoked. They took up the renewal. When they took up the renewal, a right has accrued in my favor. In terms of clause 4, I am entitled. Why I am entitled? By 10 rupee fee. But I will kindly have a look at only one document. Page 47 kindly comes. One company, yes, page 47.
Yes.
Kindly see in the box name and address, Deepak Timber Industries. But I'm just given one instance. Please find herewith below the unit who is applied for annual renewal of forest for the year 2010, 2012 to 2020, 2022. In this connection, you are requested to verify the physical. Then kindly see license renewal valid up to 19 March 2010. So you have renewed it for Deepak Timber, which has license expired in 2010, from 2011 till 2022. 10 years. And in my case, you cancelled in 16. You reopened the issue in 2021. And on the basis of the same, you rejected. There were two issues.
No, this, please find the below unit which applied for.
Please find below unit who has applied for annual renewal of the forest license for the year 2010 to 2012 to 2020 to 2022. That means from 2010 to 2022.
You required to verify the physically and report the undersigned as to 4.1.
4.2, 4.2, 4.3.
Yes.
Then the next page, Deepak, as per our instruction, Deepak Timber, the license was renewed in terms of 4.
Where is that? If the license is given to the Deepak, he is operating.
But he is operating.
That is the verification whether the Deepak Timber Industries has been given license.
Not as per
the verification.
We got this document after, as per our instruction, it has been given. They are running the industry. In our case, this has not been done in our case also.
That's why if it is the verification, if after the verification whether they have given the license to them, that is the question.
But
now.
I have taken these instructions because we don't have the document. Since they are from the same industry, they say that Deepak Polymer is continuing in Calcutta. It is in Guru Soda Datto Garden Lane. It is continuing till date with this license. It has been extended.
Okay.
My lord may inquire from Mr. Karan. He will come back with that instruction. But what I am saying is, for Deepak Timber, who has applied from 10 to 22, imposing 4.1, 4.2, 4.3, you have taken up for consideration. And for me, you took up the renewal and you say, we can't do it because cancellation was in 2016. Yes. Now, we have challenged this order before your Lordship's Court in an earlier round of writ petition. My lord will kindly have a look at page 49. We challenge the order of rejection before Justice Sabyasachi Bhattacharya.
49.
49.
Yes.
Lord, just have a look at para 3 only, then I'll take it to Justice. It is contended by the petitioner that the first.
There is no 49.
It's the 49.
Oh, 49. Oh, yes.
13 January 2022. Then kindly come to the relevant portion. Page 53, last page 53 kindly comes. 1920. It is made clear, although the writ court is not inclined to interfere with, because without preferring an appeal, directly writ was filed, said cancellation, nothing in this order shall preclude the petitioner in the event the petitioner decides to prefer an appeal under section 8.2 of the 1982 rule. The merits of the cancellation have not been gone into, and it will be open to the petitioner to take all points before the appellate authority, from which will consider them. Lord, I preferred an appeal in terms of Justice Bhattacharya's order. Now, Lord, kindly see the order of the appellate authority. That is impugned before your lordships.
Where is that?
Page 94.
Yes.
This is impugned before my lord. Forest license of Mr. Swanso Calcutta Winner Limited, being number Swanso, was cancelled on 27 December 16 by the authorized officer, wood-based industry, Nodia, Murshidabad, Swanso. Subsequently, petitioner had applied for renewal of license, which was also turned down on 19 December 2022. That was impugned. Sri Sanjeevan Chatterjee received a secondary forest license in the name of Mrs. Kastho Uddog, Village and Swanso. Blood. He is a director. In his personal name, he got it. Company did not get it. Police Station, Falakata, Alipurduar, on 14 September 23. Order of the Honorable High Court, Calcutta, 29 February 24, passed in WPA number such and such.
Where from you are reading? 94?
Blood, page 94.
94 is the order of the appellate authority.
Yes. That is impugned before my lord. But I'm again placing it. I'm sorry, my lord. I should have.
Yes, no, continue.
Yes. My lord, I would say, my lord, kindly take note, page 94, fifth line from the bottom. Sentence starting with thus.
Yes.
Now, before that, entire reiteration of facts. Thus, after so long a time, petitioner cannot be permitted to reopen the cancellation of the license, at least by way of a writ petition. It is made clear that although writ court is not, Justice Bhattacharya's order has been quoted, writ court is not inclined to interfere with the cancellation. Nothing in this order shall preclude the petitioner in the event the petitioner decides to prefer the appeal by taking advantage of 8.2.
That's the order of the
that. Then kindly take the next page. Appellant, appearance of the appellant, then
95 order with
order and observation.
Order with reason.
Order with reasons. Whereas the forest license of Calcutta Winner Private Limited was cancelled on 27 December 16 by the authorized officer, wood-based industry, so and so, and whereas cancelled license cannot be renewed under the provisions of 5.4 and Rule 7 of the West Bengal rules, whereas the appellate authority under 8.2 of the forest establishment in compliance with the order of the Honorable Court dated 29th February 2024 by WB number so and so, the appeal had been admitted and the appellant has been given a chance. Then it's only one line. Whereas the appellant could not submit any further document or reasons for cancellation of license. Thus, I upheld the decision of the Nodia. No reason.
No, prior to that.
Prior to the two paragraph, cancel renewal. But I have a
license cannot be removed under the provision
yes.
5.4.
I have a very simple answer to this. The cancellation you yourself revoke page 37A. Cancellation was no longer there. If page 37A was not there, Lord, I am just giving you Lordship the chronology at the cost of repetition. 2011 I applied for renewal. 2012.
What is your
you reopen the issue.
My lord. First, your lordship kindly come to the cause title of this.
for whom?
I am appearing for the state forest officers. My lord.
One man. Mr. Nondi is here. I'm so grateful to lordship.
My lord. Your lordship kindly come to the first page of the REIT application. That is the page number 1 of the REIT application. This is Calcutta Veneer Private Limited Company represented by Sri Sivanjan Chatterjee. Sanjeevan Chatterjee. So ploy is this. First they apply for Calcutta Veneer. In the name, owner is who? This is also private limited company.
No.
This yes, this is private limited. This is limited this is private limited company. It is stated here. They themselves stated. Here, who is the owner? Sanjeevan Chattopadhyay.
Yes.
Please note that.
Yes.
And your lordship kindly come to para 3 of the REIT application.
Yes.
Your petitioner states that petitioner had its factory at Kalyani, Nodia since 1987 and the license was renewed. He himself stated up to 1998. This is his own statement on oath. Thereafter, he never ever applied and it was not been renewed. In 1997, the owner of the said company had some problem with their financial institutions. After the betterment of financial condition of the owner of the said company in 2011, got back the said factory. So he was not actually in a position of that factory since 1998 till 2011 because of some financial anomalies. The next para is very important. Your petitioner states that under the then prevailing situation, the management of the petitioner's company was not able, the management of the petitioner company, that is the owner, was not able to run the unit at Kurpai. It is his own, by his own volition, he could not run the institute. So that industry, that factory was stopped since 1998. It was not running. So if it is not running since 1998, there is no question of for renewal or for application. Your lordship kindly see. Therefore, the management of the petitioner's company had arranged a piece of land at Falakata. This was at Nodia district. And this Falakata is at Jalpaiguri district, near Darjeeling. Under Jalpaiguri Forest Division district Jalpaiguri, where the petitioner would ship the machineries. What they did, they took their entire lock, stock, barrel, everything from this factory, that Calcutta Veneer. Only the shed remains. And they went there at Falakata, they established a new factory there without informing the Forest Division, Nodia, from whom they got the license. And finally, the department waited for a few years, and finally in the year 2016, the license was permanently cancelled as because since 1998, no application for renewal and no factory was not running. And then they themselves have stated they have shifted all their factory materials, including machinery, everything to the Falakata. And they never applied to the division there. they started their factory, and then in the year 1911, they applied for a new license in their name, because here they started factory, the same person started factory in the name of Calcutta Veneer. There they applied for Casto Uddog, and thereafter a license was given there. They were running. That has been renewed time to time. That has been renewed. That Casto, they have jumbled up the things. That Casto Uddog and Calcutta Veneer.
Go behind the order passed by the appellate authority. Whether what are you making?
Yes, I'm coming. I'm coming.
Yes. What you are making the submission, that submission reflects in the impugn order. Tell me.
Yes,
whether you can go beyond the impugn order.
I'm not going beyond the impugn order. I am very much within the impugn order.
The facts which has been recorded by the appellate authority in the impugn order.
Your Lordship, kindly come to
Giving the lecture before the court will not serve the purpose. Show me the impugn order. What are you stating? 98 crores he has not applied for. 2011 he has not applied for. He has stipulated. Show me the ground in the impugn order. Then I will hear you.
My lord, I'm coming. I'm coming, my lord.
Yes.
And before that,
you have to restrict on the impugn order and to satisfy this court that the impugn order is correct. That's all.
Yes, my lord. My lord,
writ petitioner may say something, may say anything, but you have to be restricted and you cannot go beyond. You cannot put a new grounds in your argument beyond the impugn order, which the authority consider.
I am just narrating the facts. What is there?
That's why you come to the first. You show me the how you okay. If okay, I am accepting your submission. Why you have renewed in 2016? Why you are renewed in 2016?
That is not this factory. That is not this factory. That is Casto Uddog.
That's why where is the order? Where the appellate authority stated that has not been renewed? That is another factory.
My lord, let me place the impugn order first.
Yes, that's why come to the
yes,
order. Show me the impugn order that has been considered.
Yes, I'm coming. Mrs. Calcutta Veneer Industries Private Limited bearing number such and such was cancelled on 27th of December 2016. My very humble submission is that they have never ever challenged the order of cancellation before the court.
Yes.
They have never ever. By the earlier writ application, they have what they pleaded before the court, suppressing the material fact that the license was cancelled in the year 2016. Rather, they come up before the court after the cancellation for renewal of the license. The license, this is asking myself, I am asking myself,
correct, yes.
my lord, once the license is cancelled, can the factory owner, without challenging the cancelling order, apply for renewal of the same factory or not? This is a question to be.
Come to page 34.
My lord.
Come to page 34. Come to page 34 of the writ petition.
34 of the writ petition.
34 of the writ petition.
সব খুলে বেরিয়ে চলে গেছে।
I appreciate your submission. Yes, 2016, the license was cancelled. You are not challenged. Matter over. Kindly come to the page 34. You have given life to the cancelled license. Your authority has given life to the cancelled license. And subsequently, then again come to the other persons whose license has been cancelled to the has not been extended 2010. You have given the license.
There is a difference. That industry was running.
First give.
Here they themselves are admitted
without the license running. 2010 it has not been renewed. It is running. Can I record your submission?
My lord, what I had submitted.
2010, if the license has not been renewed, whether the forest, the sawmill can be run.
So for the Calcutta Veneer and Veneer Company.
Not I am telling Calcutta Veneer, that Deepak, what is the name of that? That Deepak Timber Industries. March 2010, that renewal has not been done.
And you have given the renewal in
No, my lord.
2021.
For that, my lord, I have to take specific instruction from the department.
And you take the instruction with regard to the page 47 and page 34.
Yes, my lord.
Why your authority? You file a report. Why the authority?
My lord, then your lordship kindly come to the first order of this writ application passed by the my lord, order dated my lord.
By this writ court, no?
By this writ court,
Yes,
order dated my lord.
Justice Bhattacharya.
9th of February 2024.
Justice Bhattacharya's order.
My lord, I have to arrange everything is my lord.
Page 83, page 81.
My lord.
Come to the page 81.
My lord, I am coming, my lord. But before that, your lordship kindly come to the order dated 13th of August 2025 of this court, passed by this court. What the learned senior friend has submitted.
Order dated?
Order dated 13th of August 2025.
Not annexed to the writ petition.
13th.
This is the order passed in this writ application.
No.
Yes, this is the order, my lord.
The matter was being heard by Justice Sinha, my lord.
This is by
yes.
Justice Sinha, my lord. Kindly give it back. Your lordship kindly come to
yes.
Order dated 18th of 2025 passed by the appellate authority such and such Nadia Murshidabad district and conservator of forest and joint director Sundar Subarban Biosphere Reserve. It is there, and then it surfaces therefrom that the license of the petitioner stood cancelled in the year 2016.
Correct.
The petitioner intend to obtain a fresh license. This is their submission.
Correct. That is something.
My lord, this has been
that is
esteemed senior counsel appeared on behalf of the petitioner and their submission. And what the third paragraph submission is that the application for a fresh license was made. And that's why they have given chance to file a supplementary affidavit. In the supplementary affidavit, nowhere they have been stated that they have applied for a fresh license.
Yes, sir.
My lord, we have filed the supplementary affidavit.
Let from supplementary affidavit, they have applied for fresh license, fresh application for the veneer after cancellation. Every occasion they are appearing, they are changing their argument, pattern of argument.
My lord, the honorable judge on the other occasion was on the view that whether a fresh license can be given or not, as because it came down from the honorable court that whether a fresh license can be issued or not. In reply to that, the submission was made. When a supplementary affidavit was sought to be filed, it is
a specific submission they have applied for.
Let my learned senior friend, my lord, make his submissions, then my lord start.
They have applied for fresh application. They are applied for fresh, my lord, license. This is their submission. This is came from the bar.
Yes. What submission? That to its senior advocate has made a submission before this court.
Because that
and you have made out another case before this court. And what is your prayer in the
pleadings in the writ petition and the submissions made today are similar. It is not beyond the.
I am not telling.
No, my lord, I'm just making my submissions, my lord. My lord, it came during the argument on the earlier date. It fell from the court that whether a fresh license can be issued in favor of the petitioner, because whatever it is telling, it is told that the director in his personal name has a secondary license. Over here, my lord, the petitioner, that is Calcutta Veneer Private Limited, he is not the owner, he is one of the directors.
No, kindly come to the paragraph 3 of the order dated 13th August. Have you got?
Yes, my lord.
And you see, read paragraph 3.
I have in the soft copy, my lord. We were directed to disclose that a copy of the fresh application. Kindly comes.
You have made a submission.
That the application for fresh license was made, but the same was
made.
Not been.
Please.
Submission is that an application for fresh license was made, but the same has inadvertently not been annexed to the writ petition. Leave has been sought to file a supplementary affidavit annexing the document in support of the submission that an application for fresh license is pending consideration. Therefore, the aforesaid submission of the petitioner has been schemely opposed by the learned counsel for the state. It has been submitted that in an entire writ petition there is no mention about the pendency of such application seeking grant of fresh license. Be that
okay, where is the supplementary affidavit?
But that is in on doc.
Yes, where is their application?
Yes, madam. Kindly comes to
page 6 of the supplementary affidavit.
6 of the supplementary.
Yes, ma'am. Kindly-
That is your first application. It is your
It
submission.
is not, my lord. We say, my lord, we do not.
I am asking you a first question.
Yes, ma'am.
This is your first application.
No, my lord. This
Then-
is the letter where it is acknowledged, my lord. The fresh application is pending.
This is the pending.
That application for fresh application. May I read it out? Para 4, my lord. As per advice of the deed.
Kindly see the date first.
Yes, my lord. The date.
What is the date?
19th of October 2021.
19th October 2021.
Yes,
Now
ma'am.
you come to the page 94 or the same supplementary affidavit. You say supplementary affidavit. Come to your this
94 volume 2.
94.
My lord.
Got it?
94. My lord.
94.
Yes, my lord.
What is the date of the order?
My lord, 18th of July 2024.
So how it can be a fresh application? How it can be a fresh application?
This order was not taken.
I am dismissing with cost.
No, my lord. Kindly.
Once you have challenged the order of the authority wherein your this renewal of the license has been cancelled, refused by the appellate authority.
Yes, my lord.
And you have challenged that order.
Yes, my
and
lord.
you made a submission before this court. You may file an application for renewal of the fresh application, and you are showing the fresh application on 2021, which has already been disposed of by the appellate authority in terms of the order
my
passed
lord.
by this court.
That is not the fact. That is why we kindly bears with me a few minutes. Kindly bears with me. Kindly bears with me, my lord. Few minutes. Let me. My lord, let me. My lord, kindly bears with me.
What bears me?
Kindly bears
Then
with me.
your meter starts. 1 minute, 1 lakh rupees.
My lord, kindly bears with me, my lord.
1 minute, 1 lakh rupees. I am hearing. Yes, start.
My lord,
58.
Kindly do not take me amiss. My lord,
Not amiss, sir. What is this? Your supplementary affidavit. This is a fresh application.
My lord, that fresh application came down from the court. Whether a fresh application.
Where is the fresh application?
My lord, we have.
Or you have made an application for review of the order or clarification of the order?
My lord, kindly. I do not get it. My lord.
13th August, you made a submission. You have made a fresh application. This court has given.
I have not made it. That is the submission that a fresh application is also pending.
Correct.
Yes.
Pending. If you not made an application, how it could be pending?
Yes, that was pending, but
So-
it is not. But kindly goes through the 2011. This is for the cancellation. This is for the cancellation.
Again, you read the paragraph 3 of the order. 13th August order.
My lord, submission is that an application for fresh license was
made.
Correct.
Correct.
Yes, my lord.
But the same has inadvertently not
been
annexed in the
writ
writ
petition.
application.
Leave
Now,
has been sought.
kindly come to the 5.
Yes, my lord.
Be that as it may.
Sought for filing the supplementary affidavit stands allowed.
Correct.
Let the supplementary.
So you file the supplementary
Yes,
affidavit.
my lord. File the
So where is the fresh application?
My lord, whatever document we could find, we had annexed them.
So where is the
here-
fresh? I am asking where is the fresh application?
My lord, this would show that the fresh application is pending, but that is what we are not on today. That is what we are not on today. We are challenged with the challenge in the writ petition.
You are not on today, but this court is on because they have taken the stand. You have made when your writ application is going to be admitted, you have made a specific submission before this court that you have made a fresh application. That's why court has given a liberty to file a supplementary affidavit disclosure, and you have also made inadvertently you have not filed the fresh application in the writ application.
Yes, my lord.
Correct, and you
Yes.
file the supplementary affidavit.
Yes,
and
my lord.
supplementary affidavit you have disclosed the application of 2021.
This is not the, my lord, this
is not a misleading to the court.
No, madam. We have disclosed that this is not the application.
Where it's mentioned? Where you mention in the
As per,
application?
madam, kindly allows me to read para 3 of page 6 of the supplementary affidavit, my lord.
Yes.
Yes, my lord. As per the advice of the deed and PCCB, we applied for fresh license to the DFO Jalpaiguri on 31st of May,
my lord,
2021.
Yes.
Yes. Jalpaiguri on 31st of May 2012.
Which paragraph?
Page 6, para 4, my lord. Para 4.
Hmm.
Para 4, my lord.
Page 6, paragraph 4.
Yes, for supplementary affidavit.
Page 6.
Yes, my lord.
That is a representation dated 10th of 19th October.
Yes, my lord.
2021.
That is what are you saying, my lord? That fresh application, that cause of action of the fresh application, till when from it is
This
pending.
is for another company, Kastu Udyog.
Yes.
Yes, my lord. May I be allowed to read it? as para 4, my lord, as per the advice of the then additional PCCF, we applied for fresh license to DFO Jalpaiguri on 31st of May 2012 with proper fees, and DFO Jalpaiguri recommended our case to Member Secretary SLC on 8th of July 2014 and again on 5th of June 2017, so that we can get a secondary license for pasting unit. But till now, nothing has been done from Aranyok Bhavan when we have shifted all our machineries to Jalpaiguri. So, my lord,
And my lord,
we
this
do
is
not-
for Jalpaiguri, not Calcutta Vineyard.
Yes, then.
Yes, my lord. We are including with some correspondence or renewal regarding renewal of license, issuance of fresh license, and copy of minutes of SLC 27th of February 2018, wherein you please find such and such. Now, my lord, we say that this
Petitioner has filed the
my
present
lord, kindly
application.
rejects the
Praying
kindly
for-
bears with me, my lord. This
Praying for
my lord, this writ petition is against an
for-
order of cancellation, my
an
lord.
order. Praying for an order for use recalling of the impugn cancellation notification dated 27/12/2016. 2016, as well as the impugn order dated 18th July 2024, passed by the appellate authority by rejecting the request of the petitioner for renewal of the license. Renewal of the license. License of what?
Forest license,
Renewal of sawmill.
Sawmill.
Renewal of
General category.
Sawmill license under general category. Full stop. The matter was taken up for hearing. Today, today, when the matter is taken up for hearing, learned counsel for the petitioner argued the matter at length. Full stop. Learned counsel for the respondent state had drawn the attention of this court to the order dated 13th August 2025, which reads as follows. This and submit that full stop. By referring the said order, the learned counsel for the state respondent submit that this is the specific case, and an appropriate submission was made before this court on 18th of August 2025 that the petitioner has made a fresh application for renewal of the license. And accordingly, on the submission made by the counsel for the petitioner, this court has granted leave to the petitioner to file supplementary affidavit. The petitioner has filed the supplementary affidavit by disclosing the representation dated 19th of October 2021, wherein the fact remains in terms of the order passed by this court on the previous round of litigation in WPA number 8544 of 2023, dated 29th of February 2023, the appellate authority had disposed of the earlier representation by rejecting the claim of the petitioner on
on the 18th of July
18th of July
2024.
18th of July 2024. Police. When the learned counsel for the state has pointed out the said contradictory statement made by the petitioner, and when this court has made a query before the learned counsel appearing for the petitioner, where is the, with regard to the fresh representation in the supplementary affidavit, as for the leave granted by this court, the petitioner has relied upon the representation dated 10th October 2021. This court failed to appreciate that the 10th October 2021, the representation dated 10th October 2021 has already been disposed of by the competent authority by rejecting the claim of the petitioner. This court find that on 13th August 2025, when the matter is taken up for hearing by this court, the petitioner has made incorrect submission
And on the basis of the incorrect submission, this court has granted leave to the petitioner for file supplementary affidavit disclosing the representation, fresh representation. But the petitioner has filed the supplementary affidavit disclosing the old representation which has already been disposed of. Considering the above, this court finds that now and then the petitioner is trying to mislead this court to get an unfavorable order. Thus, this court is find that this is the fit case wherein the writ petition is to be disposed of by imposing cost upon the petitioner. According, the writ petition disposed of by with the cost of ₹1 lakh. The petition is directed to pay the cost to the State Legal Service Authority within a period of 1 week from date. All the password matter.
Grateful, man. Grateful. Only that time period could be extended. That 1 week, my lord, could be that be fortnight.
What?
That cost, my lord. Kindly, my lord.
Sorry.
Is that 1 week on a fortnight, my lord?
All bar members knows I have two allergy. One is suppressing of facts, second is the adjournment. These two allergies I am having.
My lord, there was
and that cannot be cured.
Suppression, my lord. If kindly look.
Yes, yes. The court has held it is a suppression.
My lord, kindly increases the time for my lord. More fifth, my lord, fortnight, my lord.
Yes, yes.
Yes.
এই তোর পেছন থেকে চেয়ার টেনে নিয়েছি বোধ
My lord, I was on that letter of 9th of October at page 243 of volume.
As Mr. Mitra has taken the.
Not really, my lord, immediately. I cannot. I'll make my submissions, my lord. Kindly give me 5 minutes time.
Yes, no.
My lord, kindly takes volume 2.
Yes. Page.
My lord, 243. This is their letter and this date is important, my lord, 9th of October 2023. Because by this time, the 15th September 2025, by this time, the 15th September 2025 order of the APTEL relating to, my lord, tariff period 2009 to 2014 was already, my lord, there. So they were also aware of this order. Yet, my lord, their contention in 243 kindly sees, with reference to order number so-and-so and batch passed by the Honorable APTEL on 15 September 2025, we would like to bring the following to your attention. As per the said order, entire tariff for the period 2009-25 was challenged. Tribunal directed WBRC and DVC to revise the tariff and issue revised bills within 3 months. Furthermore, Tribunal has instructed that any excess amount deposited by consumers towards electricity bills during the above period must be refunded or adjusted in future bills. In light of the above, we request you to office to withhold the following checks. So they want withholding of the checks of, my lord, the 27th September and 27th October installment. My lord, after issuing this letter, since there was a default of the 27th September installment, they made that payment on 14th of October by RTGS. So, my lord, despite their initial contention or understanding of the 15th September order, they changed their stand. And I would say they waived their whatever rights, if at all they had anything under the 15th September order, they have, my lord, waived that. And that is why on 14th of October, they make that payment of the second installment amount. Now, regarding the third installment amount of 27th October, my lord, when they, my lord, defaulted in this payment because the check was not honored, I gave them a my lord, notice period of again 15 days. There is a letter of 27th of October. There is a letter of 28th of October. 28th of October, which is the subject matter of challenge, is, my lord, really a follow-up of 27th of October. So, my lord, 15 day again they had. Now, if your lordship now sees the prayer in the writ petition at page 15, volume 1, the main relief they are seeking in the writ petition, because the interim relief has to be in aid of this main relief.
Yes.
Page 15, lordship, comes to prayer B. Writ in the nature of mandamus be issued commanding respondents to immediately and forthwith consider the letter of 7th November 2025 issued by the petitioner being so-and-so and act in terms of the order dated 15 September 2025. You don't act in terms of the order if you understood that that order is giving you some right. You pay 14th October the second installment. And in any event, I have already made my submissions. 15 September order, by the reason of the APTEL 7th November order, it has been clarified that you cannot link the two issues at all. At the cost of repetition, one more paragraph which I left, my lord, in the morning session. My lord kindly takes the 7th November order once again, my lord, which I handed up. One paragraph from internal page 7 of that order sheet, my lord. It's at the foot of the page, my lord, the page numbers.
Yes.
Last paragraph. While we see no justification whatsoever in linking compliance with the interim order dated 11th August with the outcome of the remand proceedings pending before the commission pursuant to the subsequent order passed by this tribunal in appeal number so-and-so and batch dated so-and-so, considering the persuasive submission urged on behalf of the appellant, this tribunal should exercise equitable jurisdiction to extend the time for compliance of the earlier order dated so-and-so as the amount involved is substantial. We consider it appropriate to extend 3 months time granted for compliance. This was, my lord, categorical, my lord. APTEL is categorical regarding its 15 September order. You cannot link those two orders. And my lord kindly comes to internal page 8.
Yes.
Last paragraph. My lord, skipping the first 6 lines. We accordingly direct that the extension of 4 weeks granted by us and the direction for these consumers to remain within the area of supply of the second respondent shall be confined only to the 31 co-appellants, and this order shall not disable the second respondent, which is DVC, from proceeding against other consumers for recovery of the amounts due in accordance with law. I don't know whether he is a member of that association because writ petition does not contain an averment.
The petitioner was not there.
My lord, that's my on instruction. I am submitting this that my lord, he is not a member of the association, or at least, even if I am wrong in that submission, at least there is no averment in the petition that petitioner is a member of DBPCA who was the appellant before APTEL. So either way, my lord, even on merit, my lord, this order, my lord, cannot be, the 15 September order cannot be taken benefit of by the, my lord, appellant, by the writ petitioner today, on the ground that because I am entitled to some refund in future, if WBRC determines the mechanism, then so don't ask me to pay. This obligation to pay had crystallized much earlier by reason of the order passed earlier. And you understood that obligation. When I issue the disconnection notice, you challenge that. You then withdraw the writ petition, file an affidavit of undertaking saying that one single default, you are at liberty to disconnect. Then also I don't disconnect after the 27th September default. I still, my lord, permit them to continue because they paid, my lord, there was an assurance that payment would be made. 14th October, I realized. 27th October, which is the last installment, my lord, 15 days time, again I give them by reason of the notice. They don't avail of that. They come to court that they are not obligated. Now the stand taken is contrary to the letter of 9th of October.
Okay.
Therefore, my lord, according to me, my lord, no benefit should be given by way of an, my lord, interim order to this writ petitioner. My lord, one last paragraph my colleague wants me to, my lord, place off page, my lord, 8 only, the first paragraph. With a view to ensure of the same order, my lord, the one which I was placing, APTEL's order. Last page, my lord.
Yes.
First para, with a view to ensure that the second respondent is not left high, judgment, and dry in the interregnum, we direct that the extension of 4 weeks granted by us today shall be subject to the members of the appellant association continuing to remain within the area of supply of the second respondent. So benefit is to the members of that association only. And my lord, APTEL also recognizes that DVC cannot be left high and dry. I will go on continuing supply despite, my lord, the payments which are, my lord, dues in arrear will not be paid.
Yes.
And monthly bill is in excess of crores. It's not that they cannot pay. My lord, only one, my lord, current dues, yes. My lord.
It's in excess of 1 crore.
Current dues, taito one instruction. Taito. Huh? No, it's around 50 lakhs, I'm told. I stand corrected. 40-50 lakhs. So it's not that they cannot pay.
50 lakh for
1 month.
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 Yes. Industrial use.
35-40.
My lord, only one judgment because, my lord, that undertaking was not disclosed with the writ petition. This is, my lord, reported in 2022 12 SCC 815. This is on abuse of process of law. 12 SCC 815. A copy down. It is copy. So it is. My lord, comes through paragraph 10. It is paragraph 10, my lord.
Yes.
It is well settled that the jurisdiction exercised by the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary, and it is imperative that the petitioner approaching the writ court must come with clean hands and put forward all facts before the court without concealing or suppressing anything. A litigant is bound to state all facts which are relevant to the litigation. If he withholds some vital or relevant material in order to gain advantage over the other side, then he would be guilty of playing fraud with the court as well as with the opposite party, which cannot be countenanced. This court in Prestige Lights has held that a prerogative remedy is not available as a matter of course. My lord, paragraph 33 of that judgment is quoted. I am just reading out that para. It is thus clear that though the appellant company approached the High Court under Article 226 of the Constitution, it had not candidly stated all facts to the court. High Court is exercising discretionary and extraordinary jurisdiction under Article 226 of the Constitution. Over and above, a court of law is also a court of equity. It is therefore of utmost necessity that when a party approaches a High Court, he must place all the facts before the court without any reservation. If there is suppression of material fact on the part of the applicant or twisted facts have been placed before the court, writ court may refuse to entertain the petition and dismiss it without entering into the merits of the matter. My lord, I was praying, my lord, if lordship is entertaining the writ petition, kindly permits me to use an affidavit without an interim order being passed in favor of the petitioner. Otherwise, lordship may dismiss the, my lord, petition. Those are my submissions, my lord.
My lord, my learned friend started by saying that I am not a member of the association. Absolutely correct. It's not my case. Had I been, my lord, a member of the association, I would have been bound by the order passed by the APTEL on 11th of August. But kindly look into the order of 11th of August, my lord, which was handed over to your lordship, my lord. It's thickest bunch, my lord. Kindly come to, my lord, the page 39. The ordering portion, the conclusion.
Yes.
Conclusion. For the aforesaid reason, the interim order passed by this tribunal on 29 July 2022 is modified, and there shall be stay of arrear insofar as the appellant herein are concerned, on condition that they pay 50% of the arrears as determined in terms of the impugned order of WBSC, and furnish a bank guarantee for the remaining 50% within 3 months from today. Now, my lord, kindly one more paragraph, my lord, but page 2. Oh, kindly come to, my lord, page 2 of the order.
Yes.
The last paragraph. On appeal number such and such being listed for the first time, an interim order was passed by this tribunal, adopting the interim order passed by it earlier, etc. Sorry, I made a mistake, my lord. I was reading out wrong. Page 2. Yes. The relevant facts. Kindly come to the fourth line. By the said order, WBSA had determined the tariff applicable for distribution and retail supply of electricity for the second respondent DVC for financial year 18-19 and financial year 19-20. This was the scope, and your lordship has seen, my lord, the order of APTEL that you pay 50%
And 50% of
secure 50%. That, my lord, now kindly come to what was communicated to me, my lord. My lord, kindly once come to, my lord, page, second volume, my lord, page 161.
Yes.
Page 161.
Yes.
This is, my lord, the demand they made. This is the demand they made, my lord. Kindly come to the second paragraph. In view of the above mentioned order dated 11th August 2025, please note the following. Principal area amount in respect of the tariff order issued by the Honorable WBSC on 17th is such and such. DPS will be applicable as per regulation. Accordingly, you are requested to pay the outstanding principal area amount as on 17 June, that is such and such, within 15 clear days from the date of issuance of this notice, not in terms of the APTEL order. APTEL order said 50% and 50% bank guarantee. That is not, they are not saying that. They are only saying that this is the amount payable.
Correct.
Now, they also, my lord, subsequently, I have said, my lord, it has been said that I have suppressed facts. Greatest of respect, my lord, I have narrated everything, that there were discussions between the parties, and on the basis of that discussion, my lord, the entire amount was to be paid, my lord, in installments. That also, they also agreed to that. But there was no suppression. Kindly see the undertaking which I had given, my lord. Was there any question of the letter and the undertaking they have referred to? I write a letter after that, my lord, on 27th August.
Yes.
What do I say? We are writing to you regarding the outstanding demand of 65,88,000 dated 11th August.
Which letter?
Sorry. Sorry, my lord, later there is a letter of 27th August from Arjun Dash. We are writing to you regarding the outstanding demand of 65,88,031 of order dated, and we would like to propose an installment payment plan for 4 equal installments, not in terms of the APTEL order. Quantification, yes. Not payment, not in terms of the APTEL order. Then, my lord, they rely on this, my lord, the undertaking. Now, Lordship has seen the letter is of 27th August. The undertaking is of 3rd September. It says, I have received notice. Said notice mentioned in case of non-compliance within the stipulated period, supply of electricity shall be liable for disconnection without any further notice. We have undertaken to pay the outstanding amount in full in 3 monthly installments. That was again modified. Ultimately, it was paid in 4, my lord. The initial, no, not 3. But kindly come to, my lord.
No. 27th August, then you just change. Okay.
Yes.
No, this is September 2025. August 2025, you have given a 4 installment.
4 installment, then, my lord, I say 3 installment.
3 installment.
Very well. After that, I make payment. Then, my lord, comes the order of, my lord, the APTEL, which says about the, my lord, refund. So, my lord, I'm sorry I really could not understand where was the suppression. This undertaking, my lord, became wholly irrelevant, my lord.
No, if you are not the member and you are not the party to the APTEL,
yes,
can you take the benefit of that?
I'm sorry.
Can you take the benefit of that order of the APTEL?
15th September is applicable on all consumers of command.
15th September is not, my lord, on the basis of, my lord, the association. It's for all.
No, 15th September is for all.
15th September is for all. Kindly come to that order, my lord. Page 178.
Correct. $178.
Yes. Kindly come to 243.
178 is the Damodar Valley, Sri Ambe Ispat. You are not a party. You are not a party.
No. Kindly come to 242, my lord.
242.
Sorry. 243, my lord. I'm sorry, my lord. I made a mistake.
Yes, 243. 243 is their letter.
No, my lord.
Your letter.
Kindly come to the page immediately after 242, my lord. While marking, my lord, possibly the number has been missed.
242A.
Very well. 242A. Kindly come to 200, my lord, 200, paragraph 200, paragraph.
In view of that, we hold the appellant that the appellant is entitled to carry a cost of simple interest, so and so, so and so.
Yes.
Whether you are the party in that?
The appellant?
You are the appellant?
No. No.
You are not the appellant.
No.
You are not the party in that. Kindly come to the page 178. It starts. There is a cost title.
Yes.
You are
Yes.
not the party.
But this tariff order, my lord, becomes binding on all.
I don't think so, because there is one.
It has to be in rem. My lord, they cannot, with respect, my lord, it cannot be said that, my lord, a portion of the, my lord, consumers would get benefit of the tariff order and the rest of it will not. I will tell you, lordship, why, my lord. My lord, kindly once come to, my lord, one earlier order of Aptil. Kindly come to, my lord, page 74 once. Kindly come to volume 1, page 74.
Yes.
Kindly come to, my lord, page 75. Last paragraph at page 75.
Yes.
We feel that the impugned order may nonetheless impel other similarly affected parties to approach the tribunal by independent appeals on identical grounds, thus leading to multiplicity of proceeding. In order to preclude such flood of appeals coming in, we feel the interim relief granted in the earlier two matters be not only adopted for the purpose of appeal at hand, but also suitably modified so that there is no need for the other similarly affected parties for approaching by fresh appeals. So, my lord, the orders of appeal, my lord, this relates to, my lord, the tariff order. The tariff orders are binding on all the consumers and also on DVC. Now, my lord, if DVC, it is binding on DVC, my lord,
yes,
they cannot discriminate. There cannot be, the DVC cannot discriminate amongst its consumers.
Yes. Yes. Next.
Only by let kindly come to yes. Kindly come to 242A once. The ordering portion, third paragraph. We further direct the State Commission to ensure that the consequential financial impact arising under the remand shall be passed on to each affected consumer of the command area within West Bengal of DVC.
Yes.
From whom excess tariffs have been recovered. Now, it's not their case, my lord, that I am not one of the, my lord, consumers within the command area. It's not their case, my lord, this excess tariff has been recovered from me.
Yes.
3167 have been invoices also we have disclosed.
Now, kindly come to the 7th November order, which has been sought to be relied on. Yeah. Kindly come to the page 4 at the bottom.
Yes.
Kindly see, my lord, what was the application. I number such and such is filed in appeal number such and such by DVC Power Consumer Association and others, seeking modification of the order by this tribunal on 11th August. I have not sought for modification of this order. 11th August order said 50% now and 50% bank guarantee. I have not sought for. I was not bound by that order. The installment was, my lord, a completely independent and private arrangement between DVC and my client.
So, okay, the remaining amount which is due to 16 lakh 47, whatever it may be, subject to acceptance, subject to.
My lord, I will tell your lordship, my lord. Today I do not say that adjust it. I am only saying that withhold the amount. And my lord, my learned friend ultimately, the DVC ultimately agreed that my monthly bill is about 35-40 lakhs. Now, my lord, let them file affidavit. My lord, I undertake, my lord, security deposit is, my lord, 3 months security deposit is obtained to protect them. Now, my lord, today as I have already submitted, my lord, if I go on, I undertake to go on making payment of, my lord, the monthly dues in time. Now, my lord, they would have the security deposit in hand, 35 lakhs per month. I am today asking for, my lord, 16 lakhs and odd.
Correct.
Nothing further. They are protected. I have to, my lord, run my business also. That is why, my lord, I am.
That is correct. You have to run the business. You have paid the 16.
I have.
You have issued the check. Then now
I have that. That is true now, my lord. If the, my lord, the authority passes an order which is not stayed till date, my lord, 2 months have passed. It is not stayed. Now, my lord, am I not entitled to, my lord, if I may ask myself the question, my lord, am I not entitled to, my lord, seek benefit of that order? And I do not say, again I say, I do not say that give adjustment. I say don't do anything right now. And finally, kindly look into, my lord, my learned friend submitted, my lord, kindly come back to that order of 7th November.
Yes.
Kindly come back to that order. Kindly come to the last page.
Correct.
Last page, well. With a view to ensure that the second respondent is not left high and dry in the interregnum, we direct that the extension of 4 weeks as granted by us today shall be subject to the members of the Appellant Association continuing to remain within the area of supply. I also do agree to do that. They granted 4 weeks time in spite of saying that no, it cannot be done. Modification was given. That is, my lord, the earlier page.
Yes.
Kindly come to, my lord, page 7, the last paragraph. While we see no justification whatsoever in linking compliance with the interim order dated 11th August with the outcome of the remand proceeding pending before the Commission pursuant to the subsequent order passed by the tribunal in such and batch dated such and such. Considering the persuasive submission urged on behalf of the appellant that this tribunal should exercise its equitable jurisdiction to extend the time for compliance of the earlier order of this tribunal dated 11th August 25, as the amount involved is substantial, we consider it appropriate to extend 3 months' time granted for compliance in terms of the order of the tribunal by a further period of 4 weeks from 10th of November 25, making it clear that failure to comply, etc. So, well, the time was extended ultimately.
Okay. That's all.
Now, my lord, I have here, my lord, 50%. I have paid 75%. As I have shown, my lord, I have paid 75%. As I say, my lord, they are fully secured. I will, my lord, kindly.
Mr. Mitra, your client is running the business. Okay, whatever the dispute, that will be decided. Why it's adamant not to pay? Let the pay, and if it is in your favor, you will get the refund. Why the client is adamant on not paying and let it be? Okay, you have made a representation that will be considered. If the okay, I am not on the Supreme Court order, appellate order. If they are not considered that, if tomorrow the Supreme Court order will Supreme Court reject the appeal, automatically you will get the benefit. It is your money.
Now, my lord, can I pray this? This your lordship can always do. Kindly, my lord, here, my lord, also, my lord, Aptel had extended, my lord, granted 4 weeks time. Kindly give time, my lord. I will tell them to pay, but not by today.
That is an interim order, my lord, which I am opposing.
No, that my learned friend has started by saying dismissal of the writ petition.
No, because they have already agreed, assured us to pay. Checks were given to us in August.
Sorry. not after the Aptel order. This is, my lord,
Even
the
after the
representation
Aptel order,
is being
payments
made.
were made, 14th of October.
That does not, my lord.
Mr. Datto, I am recording the submission that for the when you submit, when you pay the amount, record. I will record this otherwise, or you will not. You said then the
moment I disconnect, payment will come day after.
or you will say then the court has to pass an order. Then I will pass an order. You will get the order in the evening.
My lord, kindly give us 4 weeks time, my lord, to make the payment.
I oppose, my lord, this prayer.
4 weeks time.
We are facing a practical difficulty, my lord, with consumers. My lord, people are going to, my lord, NCLT with corporate insolvency resolution processes. My lord, crores of rupees are, my lord, getting lost.
That allegation is not against me.
I am not on that.
This is, my lord, on
allegation
behalf
is
of
not
DVC, I
against
am
me.
saying, and I am taking responsibility when I
No,
make
no,
this
really,
submission.
Somebody else has.
Today we are by 18th you pay. 1 week I am counting time, extending the time. 1 week. 2 weeks.
2 weeks, my lord, kindly.
But I was entitled to disconnect tomorrow.
That's why I am restraining you. Within 1 week, I am.
My lord, let them pay by my lord
Kindly make it
this
2
week,
weeks,
my lord.
Kindly make it 2 weeks, my lord.
Okay, by let you pay by 20. Okay.
Very good.
And keeps it on 20th, my lord, to see the conduct.
On 21st.
On
I am
21st.
keeping, I am not passing an order. I am keeping it. I am recording. Submission is completed. Directing you to pay by 20th. If not pay, then I'll pass appropriate order.
Very well.
Deal and
My lord keeps it as to be mentioned on 21st in that case.
Counsel for the parties have concluded their argument. At this stage, this court is not at this stage, and counsel for the petition prays for a week, prays for 10 days time. 10 days time to take instruction. Accordingly, let the matter appear on 21st of November 2020. 21st को 2 बजे है देखो.
Direct appointment. Conference করতে গেছি।
At 21st at 2 p.m. In the meantime, the petitioner is directed to pay the in the meantime, the petitioner is liberty to pay the dues, and the respondent authorities are restrained for disconnecting the connection till the next date of hearing.
My lord, only one line, if lordship kindly considers, this should not be treated as a precedent, because there are other, my lord, consumers who are similarly placed. My lord, one order of your lordship, everybody comes and cites this.
This order is passed only on the submission made by the counsel for the petition, that they will take instruction and will advise for payment of advise the client to make the payment by the said date.
Grateful, my lordship. Well, 21st at 2 p.m.
Affidavit of service, innocuous thing.
My lord, 21st at 2 p.m. Lordship has kept it. Grateful, my lord.
Under the adjourn motion. Adjourn motion.
Item number 154, your lordship. We had tried to mention it on Monday, your lordship. It is an interim order which is likely to expire in the next week. Your lordship was pleased to direct it to appear on, to be fixed on 19th, on Monday, since the lordship done that day, lordship, the appellate side court
When
of
it is going to be expired?
lordship, by next week, your lordship.
Which date?
Lordship, next week, by 20th.
20?
20th, not 28th. 28th. Your lordship, next week on, your lordship was.
एक काम उसको ले लो. 27th को रखो.
Lordship, any day prior to.
Urgent motion में कर.
Lordship, it is, lordship, any day before that, your lordship.
25th November urgent motion.
Lordship.
25th November.
25th
urgent
November.
motion.
Grateful, my lord.
Yes, call them.
With extreme urgency, my lord.
What? No, in between no urgency. You either come in the morning.
Original side mentioning. Only mentioning, my lord. Original side matter mentioning, my lord. With extreme urgency, my lord, I have given notice to the other side, my lord.
What is the urgency?
Urgency, lord, is, my lord.
The mid of the hearing.
Yes, my lord. Your lordship have passed an order for issuance of warrant.
Huh?
Your lordship has passed an order for issuance of warrant, my lord.
Against?
Against my client, the
Huh?
contemners.
Huh?
Against the contemners.
Huh?
My client is a contemnant
Original
member.
matter.
Yes, my lord.
Let-
Original
let-
matter.
Yeah, then?
My client is contemnant number 8
Ah.
in item number 43.
Ah.
My lord, your lordship will see the two orders passed by your lordship, whereby my clients have complied with the order of your lordship, my lord. Two orders, two successive orders, my lord. My client is a registrar of companies, my lord.
Yes.
Only thing, my lord, he has complied with the order, my lord.
Who?
Contempt number 8, my lord.
What is the name?
The registrar.
Registrar of companies.
Huh?
Registrar of companies, Mr. A.K. Sethi.
Ah. Register the company AK Sethi appears that, yes.
Yes. Now, my lord, your lordship has issued a warrant against all the contemners. My client is contemner number 8. As he has complied with the order of your lordship, my lord. He has also come today in court, my lord.
By which order? Where is the order of the warrant? So you are not appeared on that day.
Is that?
Then-
But we have complied, my lord. We have filed a compliance report also.
Correct.
2 reports we have filed, my lord.
File नहीं किया.
2 reports we have filed.
Number 8.
8, my lord.
ये आज है मैटर लिस्ट में है. ठीक है, सो कल ऊपर करो फाइल ना. कल ऊपर. Come tomorrow has 2 months.
In the meantime, my lord, no coercive steps be taken
Come
against.
tomorrow, I will pass an order. Let me see the file first.
Okay.
My lord,
Yes, call the.
my lord, may I be permitted to mention an original side matter, my lord? Yesterday, my lord had passed a judgment in an undefended suit. My lord, one typographical error only has gone down. If my lord kindly has a look. My lord, I have marked it out in pencil. My lord, the amount that my lord has observed at para 15, my lord, that is the total amount of my claim. My lord has decreed only 6 lakh, 4 is missing.
Have you gone through the exhibit?
Yes, my lord.
Have you gone through the exhibit?
Yes, my lord.
Exhibit, what is the total amount?
Total amount, my lord, it's 60.
Whether a court will go with the pleading or
No,
go
no.
with the evidence?
Yes, my lord. Para 15, if my lord kindly takes, the ledger says 62 lakhs.
No.
The ledger says 62 lakhs, my lord. In
No,
the
no, no.
para 15, if my lord takes once,
Ah.
para 15, my lord will kindly have from the oral evidence, court finds plaintiff has proved that the claimant has supplied material as per the
From
ledger
evidence
maintained.
document produced, the ledger
Yes,
maintained by the plaintiff.
62 lakhs,
Ah.
628409. Now, my lord, the ordering portion has gone down 62809. That 4 is missing only. Apart from that, nothing more, my lord. It seems to be an inadvertent error, my lord. I leave it up to my lord. I am not saying anything more.
No, no, it should be, but
Yes, my lord.
it comma is something different.
Yes, a
But
4
the
is missing.
8-4 will not come.
My lord.
8-4 will not come.
My lord, but then 6 my lord.
एक काम करो सो कल फाइल का साथ ऊपर ले
My lord.
for
My
correction.
oblige.
My lord, may I be permitted to mention one parted matter which was listed and was adjourned on the prayer of the defendant, and now it is out of list for since July 2025.
Parted matter.
Parted matter.
Which matter?
Surendra Singh Bengani versus Sunil.
You will not come. Then again it will come.
No, no.
It will bring on list.
Defendant
It will be listed. Then you will come. Your advocate is not well. Your advocate.
No,
is
no, no,
gone
my
out
lord.
of
I
court.
on the last
Calcutta.
3 occasions, the defendant has taken time, my lord. Defendant has
तो
taken.
लगा दो लिस्ट में लगा दो Yes.
Lordship, kind leave to mention, my lord. Original site group 9 matter, my lord. Original site group 9 matter, my lord. This is for inclusion, my lord. Direction for affidavit was given in May 2025. Liberty was.
Yeah.
I'm grateful.
Yes, call the matter.
Item number 1. This particular matter, your lordship, I mentioned it.
Yes.
2 dates, your lordship, fixed for the examination in chief of your lordship, the defendant. That is 20th November and 24th November. I just expressed your lordship that on 2 days, if there are some difficulties for the witness, if your lordship can just fix it on the first week of December, your lordship, subject to your lordship's convenience.
Well, defendants are interested in delaying the suit, my lord. More than 500 questions asked in cross-examination of my witness, my lord, for more than a year. If my lord kindly sees the order of 22nd of July, even on that day when they were supposed to bring their witness, they had taken an adjournment. Now, usually I don't oppose, my lord, but it said difficulty. What difficulty, we don't know. The court had fixed the matter in September.
Yesterday,
At least they let them indicate what is the difficulty.
Yesterday, I expressed to your lordship that there is a business meet for which your lordship.
Order fixed, passed by court, and then.
Understood, your lordship. I expressed to your lordship that there is a difficulty. Your lordship kindly fix the matter, your lordship, in the first week. 2 dates, your lordship, and we will conclude your lordship our examination.
Date होगा उनका डायरी भी देख लें अच्छा वो तो 3 बजे से ना 3:30 बजे से कब 3rd and 4th December from 3:30. 3:30.
Great.
Record and order. The matter is listed as to be mentioned on the prayer made by the counsel for the defendant. You for the defendant.
Yes.
By an order dated 2nd September 2025, this court fixed the matter on 20th November 2025 and 24th of November 2025 at 2 p.m. for witness action. Then at counsel for the defendant submit that there is some personal difficulties for the counsel for the witness of the defendant, and as such he prays for adjourning the matter and to fix another date. In view of the submission made, counsel for the plaintiff has raised objection and submit that time and again the defendants are taking time and prayed for fixing the matter on the same day. At the learned counsel for the respective parties, let the matter appear on 3rd of December 2025 and 4th of December 2025 at 3:30 p.m. for witness action.
No further adjournment be granted, my lord.
It is for the, it is.
No, it should be, my lord, because otherwise.
It is made clear that no further adjournment shall be granted to the defendant.
Grateful to my lord.
Next.
Both the parties.
I have come appearing for the real person, the other brother against whom all the complaint is, not impeding me as a partner. The list, so I will have to seek him.
You are the brother of the petitioner, and you have objected for passport.
Let me open my case. Then you will understand.
There is a deal by which he has gifted some property to the partner. Now he is claiming that he was not in India at that time, and that's why he wants production of records.
Okay.
There is a criminal case pending, NCLT pending, or pending. Another writ petition pending where I am part.
Okay.
I have applied.
Who is for the state? You are
I have applied before the authority under the RTI that you provide me the details of my passport for foreign travel. Why I have said he is correct. There is a proceeding pending where I want to show that there is a tremendous forgery. I want to show that at that point of time I was not in India. To that, my lord, reply is that it is cannot be given as per section 24(1) of schedule. Can you see this? Can you come to 41, 42? Then you will also go to this. If it is privileged document, I cannot ask. My lord has to satisfy your lordship whether these are the documents infringed with the security of the India, this, that, what are the schedules are there. It is coming under any of these.
Schedule?
Schedule, my lord, schedule 6.
Second schedule.
That I have opened, my lord, page 31 of that book.
Yes.
Can you see the schedule?
Intelligence Bureau. To whom you have applied for?
The authority, my lord, the Deputy Director, 28, page 28. Can. That's it. Address to me, our application.
Where is your application?
My application is just complete, my lord. It was reply is there. Yes, 17. It starts at some 17.
Information Fiction Right to Information Act. Who has applied for?
This is on behalf of my client, the advocate applied for. And the reply I have shown to your lordship.
Whether the Ashok Gupta was present in India, which place in India, or outside in India, on 14 September 2016. If yes, then
I am Ashok Gupta. I am Ashok Gupta. I am asking for an authentic document to show that I was not in India.
you are not in India.
Not in India.
So you are not having the passport.
That is there, but that maybe said that is manipulated, this, that. But if the authentic document is coming, I am not barred. Can you see the test? This reply. Can you see the reply? 28. Sorry.
Yes, 27. 26.
41. 41, 43.
41, 43.
40. Can you come to page first 40? It is regretted that information sought cannot be provided as is exempted from providing an information on the subject as per chapter 6, section 24(1) and schedule of RTI Act 2005. And 10 rupees has been returned. 10 rupees I have deposited.
Exempted for providing any information.
Now can you test my submission in terms of the schedule?
Yes.
Page 31 of that book I have handed over to my lord.
Correct.
First, Intelligence Bureau,
Correct.
Research and Analysis Wing of the Cabinet Secretariats, Directorate of Revenue Intelligence, Central Economic Intelligence, Director of Enforcement, Narcotic Central Bureau, Aviation Research Center, Special Forward Force, Border Security Force, Central Reserve Force, Indo-Tibetan Force, Central Indian Security Force. I don't find anyone is prohibiting me from getting this information.
Yes.
That's why, my lord, this result is without jurisdiction, which has been given to me.
Yes.
After that, this is a short submission of mine.
Lord, kindly see who are added as respondents. These passport authorities. Regional Passport Officer and Union of India. This particular case has got nothing to do under the Passport Act. Under the Passport Act, passport is granted as a simpliciter travel document only.
Correct.
It is simpliciter an application for the immigration particulars. That is covered by the Ministry of Home, Government of India. It's a separate department. They have not been added as a party. Immigration departments where how much time he was outside or inside, all these questions. Passport is granted under the provisions of the Passport Act, section 5 to 7, subject to other restrictions provided only for a travel document.
Let me add the department as party.
No,
my
that-
letter will be happy.
If it is at all maintainable, then he will add him a party. I am coming to that. At all maintainable. Now kindly see what is the application sought for which has been placed at page 17.
Yes.
Whether Mr. Ashok Gupta, the petitioner, was present in India, which place in India or outside of India. How can the passport department give this? They have no control about the embassy or the visa or the other. It's an absolutely misconceived application. And then details and is documents. Now I shall place before your lordship what the decision has been taken is perfectly in with regard to the statutory provision which has been stated. Firstly, there are two provisions which are exempted from giving particulars. One is Section 8 of the RTI Act. No, Section 8 of the RTI Act. Section 8. Now kindly come to first. It's not so. 8F is not applicable in so many words, but it is. I shall come to later. Section 8 of the RTI Act, 8F. This is exemption from disclosure of information. Now 8F says information received in confidence from foreign government. There's a clear bar. He stayed outside India. This for provision. This is clear bar under Section 8, 8F.
Yes.
That apart, the decision which has been taken not to give such information, that is on reliance of Section 24(1).
Correct.
What Section 24(1) says? Nothing contained in this act shall apply to the intelligence and security organizations specified in the second schedule. The Immigration Bureau is absolutely intelligence and security organization under the Home Ministry. Specified in the second schedule, being organization established by the central government or any information furnished by such organization to that government. Therefore, it is barred both ways, 8 and 24(1). Now comes the moot question. It has been referred to second schedule. Second schedule also kindly finds this is actually under Section 24.
Clause 1.
Second schedule. One is Intelligence Bureau.
Yes,
Intelligence Bureau.
It is there.
Now, my lord, he has filed an application which has been rejected. He preferred first appeal, which has not been allowed. There is a provision for second appeal, which has not preferred. So where is the jurisdictional error?
Yes.
Therefore, this is not maintainable. Firstly, the Immigration Bureau is a necessary party. They have not been made party. Secondly, the question which has been raised or sought to be raised is fully covered under a different law, under the immigration manuals and provisions of the Ministry of Home Affairs, which is an intelligence department. Therefore, it is clearly barred both under Section 8 and 24(1). And how can the Passport Department give information about his overstay or staying outside India? It is totally without jurisdiction. A misconceived application. Because Passport Act does not provide for giving any particulars or the rules of a person going abroad and staying outside. These are matters of the embassy of that country where he visited. These are matters of the Immigration Bureau whose permission is sought to be required for getting a visa. Clearance, police clearance report. Without police clearance report, no visa is granted. Therefore, this is absolutely a misconceived application.
Whether the Passport Department is keeping any record with regard to the travel documents by the
or staying outside India.
not staying outside. If
That is his claim.
no, my question is that if a person is having a passport and traveling outside the India, naturally they have to put the visa seal and all these things. Whether the passport authority is keeping any document with regard to the
No, because they are giving a passport and that is being checked at the airport.
That's correct.
That the airport for going to another country, whether he's a valid passport and he is allowed to go outside. And once he goes outside, that is covered by two things. One, a clearance from the country of the embassy regarding visa and a police clearance certificate from the Immigration Bureau of the Home Ministry. And second is his stay outside India and the reports what are there. These are all matters covered under the Immigration Bureau, which is an intelligence department. Therefore, it is clearly exempted both under Section 8F and 24(1) and the schedule.
No.
This is misconceived.
Thank you.
Kindly see, I just saw the brief. Kindly see page 25. The other proceeding he's talking about. It is my proceeding. Kindly see page 25, paragraph 2, first line. It is mentioned that sought information pertains to intelligence bureau. So that is second schedule, first item. And Lordship also takes a look. So that's the ground for rejection. Intelligence bureau document. So this is not covered by the RTI.
Yes.
And Lordship also takes a look at section 19 subsection 3. How does it reply?
Appellate authority.
Yes, the second appeal provision is there, 19, because he has gone to 19 subsection 3. If he has to challenge that decision of the Central Public Information Officer, he has to go on the 19.3.
Yes.
And Lordship, so far as 19.3, he has not gone under 19. He filed 19.1 appeal, which has been rejected. And he has not challenged that decision also. If that challenged that decision which Mr. Basu has cited page 40, that is a 19.1 decision. And so there is no prayer for challenging that. So that on section page 40 is the first appeal. That's section 19.1.
Yes.
And there is no challenge to that.
How my land Honorable knows that what I have challenged or not?
That's not the brief.
Yes.
How? How you saw the brief? Why it was stolen somebody?
Okay, leave aside, please.
How you have stolen others' brief? Well, my point is not that what I have done in foreign country, supply me this. No. I am producing the passport. Passport authority has the travel documents. They incorporate that I am leaving India. That you also will get in Passport Act.
No. Kindly come to the question number 1. Kindly come to the page 17. Whether Ashok Gupta was present in India, which place in India or outside of India on 14 September. Who will give?
Passport authority.
How?
If I am leaving India, there is a stamp.
Correct.
Travel document indicates that I am leaving.
Correct.
That's all I want that.
That travel document, see, passport authority issuing the passport to you. Correct. If you want to travel abroad or anywhere outside of the India, then you have to obtain if you are going any of the country where the visa is required. So you have to obtain the visa.
I am not concerned with visa.
I am telling the procedure. So you have to obtain the visa, and once you obtain the visa, and you can travel with the visa, and the immigration will check whether you have a valid passport and have a valid visa or not.
Absolutely.
So whether the passport, that's why I asked the specific question.
Yes, that I want to show.
The specific question, whether after the issuance of the passport to you, whether the passport authority is keeping any record with regard to your travel details.
Yes. That's why I want to show to Lordship. Can you see this part 2 of schedule of the Passport Act? Can you see? Person who have can you see that? Let me read along with mine. This is Part 2, travel documents. This schedule must have been kept by the passport authority.
Which provision you are?
Part 2, I opened for my lord, page 33.
Part 2. Yes, part.
Same book.
Part 2. Emergency certificate.
This is travel document. Can you see the heading? Travel document.
Travel document.
Travel document. Can you come to the right hand side, top of page 33.
Classified of person.
Person who have produced prima facie evidence of India's history, but the evidence is considered insufficient to justify the issue of passport without further verification.
Correct.
Citizen of India abroad whose passports have been lost, stolen or damaged, and to whom new passport can be issued without verification of this passport, particularly by returns to the office of issue.
Correct.
Everything is with the passport authority.
Correct. No
When
problem.
I am a particular person is leaving the country, there is a record on the passport itself. I want that. The person when he is producing this passport from leaving the Indian country, there is a record.
No, can you read? Person who have produced prima facie evidence of Indian citizen, but evidence is considered insufficient to justify the issue of a passport. That is with regard to the issuance of the passport.
So I'm not on that. What I'm saying, these are the travel documents with the authority.
Correct.
So when a person is leaving country,
correct.
There must be a recording.
That's why that recording with your own passport which you are carrying. That seal will not go to the. You are not submitting any document to the passport authority when you are traveling.
I am submitting one subject to concern. This is document. I am the custodian of the document.
Correct.
There is a similar document must be with the passport authority.
I don't think so. That's why show where is the law.
If that is, if my lord finds that there is no document kept by the passport authority, then I have no case.
There is no it. That's why they, if you can get the document or you can verify your passport by the passport authority at the relevant point when it is required before the court.
I don't remember.
If you want, if you are having a passport, you are telling you are having the passport on 14 September you were not in India, you have traveled to abroad, and which country you have traveled, there will be a seal and visa. There will be a seal of the immigration of the India when you leave.
That's all I want. That
I am telling that is in your passport. And when you reach the abroad, there will be a seal of the abroad country. That original document, that is the passport with you.
With you. My custody.
So you are apprehension that if you produce that document as an evidence, they may take a plea that it will be a forged document. If they will take a forged document, then you get the chance to prove that document by calling the competent authority at the time of evidence.
So that's why that means the passport authority is having some document.
Not passport authority. Then you have to. Then at that time you have to apply your mind. Which authority will prove that visa seal? Not the passport authority.
Whom else?
It will be the immigration, because the immigration are putting the seal in the passport. Every country, either India or abroad, the immigration is put and that seal will be proved by the immigration or the concerned authority, whatever it may be, not by the passport or the passport authority.
If this is the problem is I don't have the passport. I am not entitled to move this.
Don't tell this, sir.
It is a fact. So
he's only saving money. We all complain. He only saves.
That's
the problem. That's the entire vast problem against him.
No, yes. Given the promise, he will give a good, fair, good party to whole bar of the.
Once see through, I remember very good party, but that's long back.
I don't want that as a suicide.
Yes.
What I am submitting, I have submitted here, what is my problem? Problem is the passport which is in my name is in my custody.
Correct.
Document coming from the custody of an individual who is a litigant can be considered vis-a-vis the past document coming from the custodian official. So I am asking a document from the custody of the officials who can prove that I was not in India.
I will record my findings. If you want to prove that document which you have any persons or any authorities deny, then you have liberty to prove with the appropriate stage.
Appropriate stage, but which authority? I'm asking the question to myself, not to the court. From which authority?
The authority who put the seal. You have a passport. I am giving. You have a passport. You have a passport.
For coming to court, passport does not require.
The authority.
Sometimes I required when by mistake I entered into the criminal court. The lawyers there ask the passport from me. Why you have come here?
Once you also ask
Yes.
from me also.
Yes. Probably in this court. Yes, in this court. In this court.
So that's why I see there will be a seal and seal of the immigration of Calcutta, of Delhi, or anywhere, or Jaipur, whatever it may be, or if you brought abroad, Dubai or Egypt, whatever it is, that will be seal. If you prove, and you need not to prove the other country. If once you have proved that
I
you have left,
That's all. I want that only.
can be proved by.
Can you provide your lordship? But this is my problem.
That
I
you
may
can prove
face
at
the contest, my lord. I have to face this because my writing has been forged. That's why I have to prove that I was not in India.
If other party is telling that it is forged, it is the other party has to prove that it is a forged, not by you to say that it is genuine.
Produce the passport in NCLT.
I have to do it. Yes, I am apprehending. The relation is such. Relation is such. The only document I can prove that I was not in India is the passport.
And passport is the document whom nobody can deny it. That is the nowadays. I think senior is also passport is the document where everywhere it is valid.
No, I am not saying my valid because it is coming from my custody. That is an apprehension that may be denied.
So deny that they have to prove it is the fraud. If any person is challenging your any document, it is the person who is denying that.
No document about that. But whenever it is coming from my custody, private custody, vis-a-vis the custody from the official is more higher. That's why. Now, this is my problem. Can you provide something so that I cannot face this problem again?
Yes, anything.
Lord, passport, it is the specific provision and the object of the Passport Act. Simpliciter travel document.
That's I'm telling.
And then I have already said, after when he is entitled to go abroad, travel document. But for going abroad, which has rightly fallen from my lord, the clearance of the immigration department is required.
Correct.
And also from the visa of a country where he is visiting. Yes, and that apart, a clear police clearance report is required for going abroad.
I'm not asking those things. I'm saying
so therefore,
that's all.
Therefore, we are not in a position to give this document number one. And document sought for is absolutely exempted under two provisions of the Act.
That is not
record. The petitioner has filed the present writ application, praying for a direction upon the respondent to furnish complete record of his travel history / immigration movement details for the period from January 2015 to December 2016. The petitioner has initially filed an application before the Central Public Information Officer within bracket CPIO, Consular, Passport and Visa Division, Ministry of External Affairs, dated 5th of February 2025. And petitioner through his learned advocate. Petitioner through his learned advocate applied for क्या बोला? Petitioner through ठीक है? Full stop. Requesting for train क्या बोला? Last word. ठीक है. Petitioner through his learned advocate filed an application under Right to Information Act before the Central Public Information Officer within bracket CPIO, dated 5th of February, CPIO, Consular, Passport and Visa Division, Ministry of External Affairs, dated 5th of February 2025, praying for the following information. Semicolon 1. Whether Mr. Ashok Gupta was present in India within bracket which place in India bracket close or outside of the India on 14 September 2016, comma. If yes, then please provide me details and slash or documents. Comma close. On receipt of the said application, comma, the Assistant Director and CPIO by the letter dated 28th of March 2025 has rejected the request made by the petitioner for supply of the information on the ground that as per chapter 6, section 24 within bracket 1 of the second schedule of the RTI Act 2005, Intelligence Bureau / BIO is exempted from providing any information / details on the subject. And according the amount paid by the petitioner for grant of information was also returned. Being agreed with the said order of rejection, the petitioner has preferred an appeal before the appellate authority, but the appellate authority has also rejected the request, rejected the appeal preferred by the petitioner by an order dated 19th May 2025 by holding that the IB and BIO is exempted from providing any information / details on the subject as per chapter 6, section 24 within bracket 1 of the second schedule of the RTI Act 2005. Being agreed with the said order, the petitioner has prepared the present writ application. The counsel for the petitioner submit that the petitioner is having his original passport to prove that the petitioner has traveled from India to abroad. But the petitioner intends that that document has to be certified by the competent authority so that nobody can deny the genuinity of the passport of the petitioner. According, the petitioner has had applied the information under Right to Information Act. Per contra, the counsel appearing for the Union of India has taken the preliminary objection that the writ application filed by the petitioner is not maintainable on the ground that there is a provision of second appeal, but instead of filing a second appeal against the order of the appellate authority, the petitioner has filed the present writ application. Secondly, the learned counsel appearing for the Union of India submits that the petitioner has requested for supply of the information with regard to his travel document. Petitioner has with regard to whether the petitioner was present in India or was in outside of the India. The said information is connected with the Immigration Department, which is coming under the Intelligence Bureau. And as per Schedule Section 24(1) of Schedule 2 of the RTI Act, Intelligence Bureau is coming under the exemption clause. Thus, the authority have rightly rejected the application or grant application filed by the petitioner under Right to Information Act. Had the learned counsel for the respective parties peruse the materials on record.
This court find that the grievance of the petitioner, the petitioner has applied for information with regard to ascertain whether the petitioner were present in India or whether the petitioner was outside in India on 14 September 2016. On the other hand, the petitioner submitted that the petitioner is having his original passport with him. Full stop. If the petitioner is having the original passport with him, and if the petitioner has traveled outside the India, the passport may contain the seal and signature seal of the immigration department of the concerned airport of India, as well as the immigration department of the abroad where the petitioner has traveled. Full stop. There is no provision under the Passport Act that the passport authority will keep any document with regard to the travel, will not keep any document for traveling document of the petitioner as per the passport. If the petitioner counsel for the petitioner apprehend that the passport which the petitioner is having containing the seal that the petitioner has traveled outside of India and reached the abroad, but it may be denied by the other party, and take the plea that the said document is forged document. That's why the petitioner has applied the said document under Right to Information Act. This court, in considering the submission of the petitioner, this court finds that the petitioner is having the original passport. If the petitioner has traveled outside the India, there must a seal of immigration department of the Indian airport, as well as the seal of the immigration department of the abroad where the petitioner has traveled. If any person has challenging the said immigration and said original document of the petitioner, it is the person who has challenged has to prove that the said document is not genuine. The petitioner has to produce the original document. And if any person is challenging that validity of the said document, the said person has to prove that the document submitted by the petitioner, relied by the petitioner, that is the passport and the visa which is appearing in the passport, is not genuine. Thus, only by applying the document under the Right to Information Act cannot be said that at this stage it is relevant. Full stop. If the petitioner finds that in future the petitioner is required to prove the document, prove the passport, to say that the petitioner has traveled outside of India, the petitioner can take appropriate step by calling upon the authority before the court to prove the said document during evidence. Considering the above, this court find that the authority have rightly rejected the application filed by the petitioner, as the information sought for by the petitioner is coming under the Schedule 1, Schedule 2 as the department, Schedule 2 as the department, as the Schedule 2, now Schedule 2 as this said document is concerning with the Intelligence Bureau Department. The WPA numbers and so disposed of. I disposed of, recording that, not passed in order. Holding that he can apply if anybody has challenged the document, he has a liberty to prove the document at appropriate stage before the appropriate authority.
So there is no observation as regards the maintainability.
No, I will give the
yes, I record my submission. And secondly, they also record that admittedly no second appeal under 93 has been prepared.
So this court also find the petitioner has not filed the second appeal. Thus,
The writ petition is not filed the second appeal and file the present writ application. Thus, the writ application is not maintainable. But this court has disposed of the writ application by observing some observing the by giving some finding in the aforesaid order. In the aforesaid order. That's